Good morning, everybody. I apologize for my lateness. I didn't get breakfast in bed the way I was supposed to. My slippers weren't ready. So I had to take care of a lot of this stuff on my own. And, well, anyhow. Today, those of you who are not exactly familiar what exactly today's proceedings is about, we are about to witness an evidentiary hearing, a 2-day evidentiary hearing. What is an evidentiary hearing? An evidentiary hearing is a process whereby the court will conduct a mini trial of sorts. This is not a jury trial. This is a bench trial. I mean, there's only a judge. The judge is the finder of law and the finder of fact in this particular scenario. It's to enable him to make a legal ruling. So various witnesses are brought, questioned by both sides. Evidence may be introduced, likely will be introduced, which will be substantiated by these witnesses while they are on the stand during the course of the evidentiary hearing. The purpose of having an evidentiary hearing is that there are facts relevant to the case or to a particular motion which are unknown to the court, and it's a way for the court to vet out what its determination is as to those facts for the purposes of making a ruling. Now, the ruling in this case relates to Donald Trump and Michael Roman. It was brought by Michael Roman's attorney, Ashley Merchant, who's done a very fine job in presenting this motion and fighting to get her subpoenas upheld successfully so far, for the most part. And the objective here is that makes this evidentiary hearing so unusual is the fact that this hearing is literally investigating the love life of District Attorney Fani Willis. Ashley Merchant filed papers on behalf of Roman, and the reason this is relevant to most of the world, rather than just some relative throwaway motion in some forgettable case, is because Michael Roman is a co-defendant Donald Trump in the Georgia RICO case. District Attorney Fani Willis brought that case, and it was brought together with Special Prosecutor Nathan Wade, who was hired some time ago. In the motion that was brought by Merchant and Roman, joined onto by Trump, they allege that they have evidence that Nathan Wade and Miss Willis have a personal romantic relationship, and that he has been spending a lot of money on her, and that he is flush with cash because of this case, and alleging that she hired him and gave him hundreds and hundreds of thousands of dollars because she's his girlfriend. And that's the only reason that this case is moving forward. There were other bases for them to allege that their actions are motivated by bias, but those issues seem to be put to side by the court. The court doesn't seem to really care about that. And so we're going to have an evidentiary hearing specifically as to her love life. And that's what we should anticipate. All these questions about whether or not they were dating at the time that there was that Fulton County, courtesy of Fani Willis, employed Nathan Wade as special prosecutor. So that is what we are watching. That is what we are going to be seeing. And I'm waiting for the court to come in. Right now, I've got it queued up right here, watching it live. Yeah, that's loud. I know you don't see anything. Don't worry. That's the backdrop, the context of this case. If super chats come up, I'm going to try to address them as necessary as I can. Also, be alert. I keep a banner on the bottom of the screen here, letting you know whose witness it is, whether it's the plaintiff's witness or the state's witness. We should expect that the defendant in this case, it's not the plaintiff, excuse me, it's the defendant, it's their motion. We should anticipate that they will be calling witnesses first, even though you wouldn't think such a thing is the case. But they need to present, whoever the movement is has the burden. So whoever has the burden goes first. So you will see a banner which will remind you to please like and subscribe. And I urge you now, please like and subscribe. This is the only opportunity when I do live streams. It's really the only time that I actually get new subs. So if you could like and subscribe, I would be much obliged. The rest of my life I spend watching YouTube. Pull them away from me. Pull them away from me, literally. So that's what's and if you're on Rumble as well, please make sure you like and subscribe. It really helps in the algorithm, especially with the live stream that's going to be going on. This is supposed to be a 2-day evidentiary hearing. I tend to stream all of it. And yeah, I just want to say one thing, and this is based on the motion. Ashley Merchant is not just a fine attorney, but apparently she has it. Just try not to lose it if there's any sort of awkward camera angles. And oh my God bless you. You are so kind to me. Thank you. I'm gonna give you a little war horn for you. First, I gotta pull this up. So people can keep the simping to a minimum. Keep your cool. That's Ashley Merchant there in the white top. Any questions? Thank you so much, Bella. And new member of the following, Kobe Tiger. Welcome to the following. Of course, breaking news. Arnold gets lost in the studio again. I know. Yeah, on time.
Thank you all. Please be seated.
That's true. Too late. Can't do it now.
There you go. All right, we are on the record with 23 SC 188947. Defendant Roman's motion to dismiss and disqualify filed January 8th, adopted and supplemented by several co-defendants. So first, if we could have counsel for the record identify themselves, starting with the state, and then we'll go through the defendants in the listed order. So.
Good morning, Your Honor. I'm Anna Green-Cross for the state.
Good morning, Judge Adam Abadi for the state.
Good morning, Your Honor. Andrew Evans for Nathan Wade.
If you could all confirm that my volume levels are good, that you'll hear
All
me.
right. And beginning with
I
from the
interject?
order of on the notice, beginning with former President
That's
Trump.
not too loud.
Good morning, Your Honor. Steve Sadell and Jennifer Little for President Trump, and he waives his presence at the hearing.
But he can't be there because he's in
On
Manhattan
Mr.
today.
Alan Stocks for Mr. Giuliani. He waives his presence as well.
Mr.
I'm
Meadows.
loud.
Your Honor, Jim Durham on behalf of Mr. Meadows.
Turn myself down.
All right, thank you, Mr. Durham. On behalf of Mr. Clark,
Harry McDougall, Your Honor. Mr. Clark waives his appearance at the hearing.
and let me go back to Mr. Durham. Mr. Durham, is your client also waive his presence as well?
Yes, Your Honor.
Did I catch that from Mr. Giuliani?
Yes.
Okay. All right, on behalf of Mr. Chuli.
Richard Rice, Mr. President Willis.
Am I better now on my volume?
Thanks.
But I'm not like blowing your
Ms.
ears
Roman.
out compared to the court.
Good morning, Judge Ashley Merchant and John Merchant on behalf of Mr. Roman and he waives his presence.
Mr. Schaefer.
Good morning, Your Honor. Craig Gillen and Anthony Lake for Mr. Schaefer. Mr. Schaefer is presently in court.
And Mr. Floyd.
Aaron McCullough on behalf of Mr. Ford.
And then we also have Ms. Latham.
Good morning, Your Honor. William Cromwell for Ms. Latham. She waives her presence.
And did we get that, Mr. McCullough, also as well for Mr. Floyd? Just making sure. Okay, thank you.
He's here, though.
Oh, Mr. Floyd is here. Okay, I see Mr. Floyd is present as well. All right.
Your Honor, one more appearance, Sandy Monroe on behalf of the Fulton County District Attorney's Office.
All right. Anyone else present who believes they may need to be on the record or address any issue coming up in the proceeding? Seeing none.
Judge, I'm here, Dave Banks,
I've been subpoenaed as a witness, but I also represent Christopher Campbell. So
Thank you, Mr. Mix.
Judge Bimmel Chopra for Terrence Bradley. We're under subpoena. We'll be waiting in the hall.
Terrence Bradley is one of the key
Can you spell your name
witnesses.
for the record?
He's
Bimal, last name Chopra.
Roman's attorneys think that he's going to basically refute Nathan Wade.
In terms of just a little housekeeping in terms of presenting the evidence this morning, my thought was, as witnesses are called, this being Mr. Roman's motion, that counsel for Mr. Roman would be the first, and any witness that they call, then in order of the listed defendants, there would be the opportunity for additional direct or cross-examination, however you want to characterize it, and then the state on the tail end of that. So with that, I will turn it over to Ms. Merchant. Is there anything that we would need to take up before calling the first witness?
Judge, we would invoke the rules of sequestration.
All right. So to that end, pursuant to Rule 615, I would ask that any witnesses subpoenaed or expected to testify at the hearing today, that they should remain outside the courtroom until called, and they shouldn't discuss their testimony with any other witness or watch any kind of live proceeding or recording of the testimony until the evidence is concluded,
Ashley.
or they're excused from being called today. Are there any exceptions to this rule?
None from the state.
Any from the defense?
No, thank you.
Okay, Mr. Abadi.
Yes, Your Honor. And prior to starting any testimony, the state would just like to address, I guess, an housekeeping matter of the issue to the court as relates to what was represented during the previous hearing, as it relates to witness testimony, specifically the testimony of the former law partner of Nathan Wade, that would be Mr. Terrence Bradley, and what the state would like the court to understand and realize is that in preparation for this hearing, in speaking to witnesses, and doing the additional research as relates to the comments that were represented by counsel, specifically counsel for Mr. Roman, Ms. Merchant, that we've been able to determine that the claims that the defendant has asserted and did assert during the last hearing on Monday are not only legally meritless, but are factually unsupported by the statements that Ms. Merchant made to the court. What I would say they're patently false. They are egregious misrepresentations of what is believed that Mr. Bradley would say or even knows. What I would bring to the court's attention in my speaking with the defense counsel for Mr. Bradley, Mr. Chopra, is that any knowledge of anything he would have would be protected under the attorney-client privilege. He would assert that, and that privilege has not been waived by Mr. Wade. More
Bradley
the representation
was Nathan Wade's
Ms. Merchant spoke to
divorce
Mr. Bradley,
attorney,
and that Mr. Bradley represented that he had firsthand knowledge from speaking to the several witnesses that he would be able to impeach with the statements she represented, that there was a relationship prior to Mr. Wade being appointed special prosecutor, and that there was issues with cohabitation that he would be able to directly impeach those witnesses. That is patently false. And speaking with Mr. Chopra,
well, let's get him on the stand.
That are not true. They are for the purpose of harassment and undue burden to the district attorney. And we'd asked to renew our motion to quash. And the only hearing we should be having is a hearing as it relates to sanctions for
the ball's on this dude.
Lack of candor that's required.
There's no way the judge will
by
grant
not only
that
statutory law,
without hearing from Bradley.
responsibility,
And they might ask
and case
Merchant
law.
her position.
And we asked that
On
we
this.
move into a hearing that is related to the sanctions due to misrepresentation and flagrant falsehoods that
The
have
ball's
been
on this dude.
spread throughout the world in an effort to affect this case and to keep it from moving forward. With that, Your Honor, that's our
Sounds
request.
nervous.
So just small matter of housekeeping.
Yes.
All right. Ms. Merchant.
Judge, first, the witnesses haven't been sequestered, so I just ask that they be sequestered before we argue this or have any more argument. I know Mr. Wade is still here. So we just ask that he leaves since he is under subpoena.
Let's start there. Mr. Bonney?
Well, I have to agree when testimony starts that the rules of sequestration would require Mr. Wade to leave, but that we haven't started testimony. It's his argument. He's lead counsel for the case, and he has every right to be sitting at the table.
Okay, Ms. Merchant.
Let's hear from some witnesses, Judge. Let's actually hear some sworn testimony under oath. I have made proffers, and it just seems like all we're going to get is objection after objection because the state clearly does not want any witnesses to take the stand, doesn't want the truth to come out in front of the court. This is a very important issue, and we need to have witnesses. I have a good faith basis. We learn I have a good faith basis, and Mr. Bradley is not my only witness to this good faith basis. It is just happens to be the evidence I proffered at the hearing when the state first tried to.
Nice. No, it's not just Bradley.
I was forced to proffer certain testimony to get over the hurdle to refute their motions to quash. I did that. I used Mr. Bradley's testimony to do that.
Good.
He's not the only witness that can state that there was a relationship prior to Mr. Wade being hired. The first witness that I'd like to call is Robin Yurdy, not Mr. Bradley, no privilege issues. Let's start with her.
Your Honor, when we have additional argument or matters to be brought up, do we want to do it like I just stand up and with relation to what's just been said by Mr. Abate, or you don't want to hear anything? Ms. Merchant at this point, I just need to know the court's protocol on that.
Sure. So I think at this point, we just need to take these issues one at a time. And
It's really
as
the
you've
state
joined the
defending
motion, I
itself
think
in the
defense
motion.
counsel would have the opportunity to weigh in. But again,
not
at any
defending the
point,
case.
if I'm just hearing the same thing over and over again from each separate defense counsel, I'm going to reserve the right to say thank you.
I appreciate that. I only ask for the opportunity to be heard on the invocation of the attorney-client privilege and the burden being on the individual raising the privilege to prove that a privilege in fact was in existence. That's what I ask.
Sure. Understood.
Sorry.
I want to put it back to you, though. The issue raised by the state this morning is that essentially, as I would summarize it, the good faith basis that you did put forward on Monday did not exist, right? So why wouldn't we start with Mr. Bradley and see where we go from there?
The good faith basis does exist. So you basically have them saying it's not true and me saying it's not true. So they think they have a good faith basis. I think I have a good faith basis. I have a huge good faith basis for everything that I put in every single motion. That's going to come out. The reason I don't want to call Mr. Bradley first is for hearsay objections, quite frankly. And normally we don't have to disclose how we're going to present evidence.
Right.
I'm
Our
okay
call.
doing that here, but based on the rules of evidence, hearsay, and privilege issues, what makes the most sense, and we've spent a lot of time thinking about this, what makes the most sense is for us to have Ms. Yurdy testify. And if you
Ms.
want me to
Yurdy
proffer what I anticipate she's going to say, I
was
talked to her last
the
night. She's going to say that there was a personal
Gave up
relationship
her unit
that
for
began in
Fani
October of
and Nate
2019.
together.
She's going to
Muslim's
testify.
longtime friend of Fani.
And she has personal direct knowledge of that. It's not hearsay and it's not privileged. She's going to take the stand. She's terrified, but she's going to take the stand and tell the truth. And then I plan on calling Mr. Wade, because at that point I can overcome their motion to quash and bring Mr. Wade, bring him to come. Then I can go through privilege issues with him, and then I can have Mr. Bradley testify.
Well
We won't
thought
have
out.
to have an objection
Good
to
argument.
every single question I ask Mr. Bradley, an objection to hearsay, an objection to privilege. So that's how I plan on presenting the evidence, because it makes the most sense. And I think I'll be able to overcome any privilege objections. But we can talk about that when Mr. Wade takes a stand.
All right. Mr. Vani, any last words on starting with Ms. Yurdy and going from there, taking it a witness at a time?
I mean, no, but I guess my final response would be
I'm like-
that, as Your Honor pointed out during the last hearing, Ms. Merchant's entire representation for good faith was all solely based on Mr. Bradley. In fact, I remember the court saying that the star witness presented or provided by the defense is Mr. Bradley, and you asked a specific question.
Perhaps it's not
Ms.
relevant.
Merchant, well, Mr. Bradley, does he have firsthand knowledge from these people, each one of them, you named the lawyers plus the investigators, as relates to the claims that were made? And her answer was yes. I can definitively tell you the answer is no.
Well, you don't.
And Ms. Merchant has
let's
not
get to
spoken to
testimony
Mr. Bradley,
instead of
according
having
to his counsel, B.C. Chopra, who is
counsel try to-
outside and can represent to the court
The judge is
the
about to
things that
publish
I
this. Sit
represent.
down. Let's get
And he
started.
has maintained and represented that everything that she plans to go into or ask is protected by attorney-client privilege.
He said
The only
Probably
point
putting their
of this process and this procedure as it relates to the motions that were filed
Good to meet
is to create a spectacle and to create harassment to the district attorney of Fulton County. And we request that the only hearing we move forward is the sanctions for counsel's lack of duty of candor to the court and to counsel.
All right, well, I think you certainly put her on notice if that is actually the case, but at this point, I have someone saying yes, and I have another person saying no. And so I think that conflict in the evidence that we noted on Monday still exists, and that's where we are, and we'll see how the evidence presents itself.
More relevant.
So with that,
jury, not in front of
Ms. Merchant, are you ready to call your first witness?
the judge is sitting
All right.
and ruling on that.
We called Ms. Yuri, and I know Mr. Parker had emailed the board, and I had.
There we go. Wade's sent out because he's a witness.
So I think she's on Zoom or either 9:30. Maybe on Zoom, I'm not really.
Ms. Partridge, Mr. Partridge was joining us by Zoom, but Ms. Yurdy is here in person, right?
Mr. Partridge, I believe, represented that his client would be more comfortable if he were here in person, and that, due to this conflict in Richmond County this morning, couldn't occur until this afternoon. I think that is a reasonable request, but not the state's business. The witness is here. If her attorney is able to join right now, perhaps that can be something that is addressed with Mr. Partridge in the court. But I want to alert the court that that was the representation that the witness was.
They're so scared. Please don't move forward.
Sure. I think the latest I'd seen, though, was that Mr. Partridge was going to be able to join by Zoom.
Okay, great.
I didn't know that he had directed that Mr. Partridge had affirmed that, but perhaps that was an email this morning that I missed.
I don't know either, but the state seems to know that Ms. Yuri is here, so I guess she's not appearing by Zoom.
It's going to be a lot of simping for Ashley Merchant.
Is Mr. Partridge here?
We'll find out.
I'm going to call it Roman. In the banner, I put down who is talking. You know what? I'll just say, I'm going to call it defense, because otherwise people get confused. I think the Romans are coming or something, and they're fighting the Greeks, and then here come the Carpathians. It's going to be bad if I roll. I'm going to write a list of defense. And that this someone's making it work. So, I think I'm going to take this. Very annoying back. The Yurdi is a friend of Fani Wilson for a long time. And she also was the one who he was leasing an apartment in the Maui 30 years ago. Supposedly, Annie and Nathan Wade were cohabitating.
All right. So just for everyone's information, we did convey the Zoom link to Mr. Partridge this morning. I think the last exchange we'd had is that he can join us by Zoom.
Oh my God.
And apparently he's elected not to do so. So I don't really know what else we can do with that. He was noticed of the hearing. We provided him a link, and we haven't heard from him at all. So I think we need to go forward.
Thank you.
All right.
Your Honor, before we go forward, we have business documents that were certified and filed yesterday evening. Filed this morning, emailed to Fulton Council yesterday evening. We wanted to make sure that this was part of the record before any testimony is taken or before the proceeding commenced this morning.
She's from this state.
Satisfies Fulton County's subpoena in this case?
Correct.
Okay. If you could hand that to Ms. Merchant, and we'll take it from there.
Okay, and I don't know either with
And also I have an original for the court.
Ms. Monroe, if you could just provide it to Ms. Merchant, and
Yes, she has
if you
a
could
copy.
just stay on call, we'll let you know if we need you again, okay?
Okay, thank you.
All right. Were we bringing in Ms. Yurdy?
I'm sorry, I thought the state said that Ms. Yurdy was outside, that they'd seen her or something. So, may John step out. She's under subpoena to be here at 9:30.
For those defendants in court, it almost feels like Dark Knight. The whole gallery was.
May I text the lawyer?
Weird. What's out of one ear that might go back? I like it as well. Anyway, it'll look something like this. I'll flush it out. Down on the bottom of the cabinet. Always keep in mind, whenever you're watching me covering any sort of hearing, trial, or anything like that, I always try to take a reminder down and alert my audience if it's direct cross, is direct across. But I'll who's on the stand, I'll put in the name.
Yeah, and just one of them.
So this way, you can walk out, walk in. You know who's on the stand, who brought them, is this direct, is this cross, and you sort of have a better frame of reference to back of the exchange happening at the stand. My audio is bad. Is that better? My mic is everyone's telling me low before. I'm just trying to get my volume levels synced. I'm gonna see if I have a different feed because someone in the court there is like sitting on the audio on this ear, not on the other ear.
I tried to call Mr. Parker's judge and it went straight to voicemail and he messaged and said he's taking the plea.
All right. Did he say where his client is? All right. And this is the, was this a former or current employee of the DA's office? Okay.
And her return's been filed. I know that she did not want to come without a lawyer here, but I instructed them that.
The state is sweating. They were fighting.
Do you have
Another?
any other witnesses available?
Well, we have Mr. Bradley.
No.
Have him testify.
I want Yurdy first.
Again, we're probably going to have a lot of objections with privilege, and so I'd much rather call Ms. Yurdy first, but I know that
This
Mr.
bitch
Parker
Yurdy. Where are you?
in that this morning by having a conflict.
Sure. So.
But what I could do is I could call Mr. Bradley and then I can bring him back.
Exactly. I think you can always recall him. We can ping pong back and forth if we need to based on hearsay issues, but at least we can use this time until Mr. Partridge chooses to join us.
On the Zoom? Or not Mr. Partridge or Miss Yurdy on the Zoom?
No, not that we're aware of.
No, okay. Just wanted to check that.
All right, so
That's the only
let's
thing I
call
can
your
do.
next witness then.
Call Terrence Bradley
All
then.
right, we call Terrence Bradley.
That's annoying. That's a very frustrating opening. My banner's there when there's someone on the stand. It goes up like 30 seconds after. they take the stand because I'm filling in the banner as they're giving their name under oath.
If we don't hear, and I don't want to have the sheriff pick anybody up or anything like that, but if we don't hear from Mr. Partridge within an hour or so, we need to.
Understood.
Thank you.
This douchebag Partridge.
Thinking, is someone getting Mr. Bradley in?
Yes, I believe so. Oh, the sheriff's in gone. Okay. Sorry. Normally, sorry. Are the sheriffs, when I call a witness, will the sheriff's not sound for them?
I don't know if they're going to know where they are. So I think it'd be best if maybe someone from your team, and they're not going to know what they look like either.
Not a problem.
Sure.
He's outside. Yeah.
Well, let's wait to see how the volume is. I hear it lower also now, so I don't know. This is the feed that I'm working on is 11 Alive, which is Fox. So So Terrence Bradley, just to alert you, is a sort of business partner. Like it's called Wade and Bradley, their firm, but there's implications that they're at war with each other. He's doing a whole investigation into forensic investigation into Wade himself, like on their business issues. So there's all sorts of money fights that are going on there. He also was Wade's divorce counsel, but Wade's divorce only started after, like the day after he got the job as special prosecutor, and he claimed, Ashley Merchant represented to the court earlier, that he claimed that there was an ongoing relationship between Fani Willis and Nathan Wade that preceded his retention as special prosecutor. And that's really what's key to the court, because the court's trying to assess, did Fani Willis basically start this entire thing for the purpose of giving her boyfriend a job? To me, that's what the court implied is of the utmost concern to the court. And it looks like she basically, the reason they're going after all these people and is to enable him to bill crazy numbers of hours. He's ratcheted up like something like $700,000 worth of legal fees over that he took from the state over the last 2 years or so. So, and then he used many thousands of dollars buying Fani Willis trips on cruises to Aruba and Belize and Miami, that they're basically going around the country or even outside the country. So on these fantastic vacations. And that there were several bases that Ashley Merchant brought to have this dismissed, but all the other ones he seemed to not care about. She said he's not qualified, which I think his failure to be qualified was to give stronger legs to the argument that this was all about giving her boyfriend a job. So one of the key things is, when did their relationship start relative to this prosecution? So Terrence Bradley purportedly, she said, was going to start saying all sorts of terrible things about like that, and testified that it started earlier. The state is claiming that he's going to say otherwise. He is one of the key witnesses, this guy, Terrence Bradley. He's taking the stand now. I'll turn it up. I know it's low.
Terrence, Bradley, Bradley.
Your Honor, as Mr. Wade's counsel, before we start, we would request to try to get the chambers to talk about attorney-client privilege before we give up the stand.
Oh my
need to be on camera.
It doesn't necessarily, there's statements that could be made that could be prejudicial depending on whether they were covered or not, whether he's going to break the.
So at the time a question is asked that you think implicates some of those statements, object, and we'll handle it.
Yes, sir.
Thank you, Judge.
Judge, on behalf of Mr. Bradley, and I apologize, this is not our proceeding, but it might be helpful to have a brief sidebar as opposed to something in chambers, at least so that we could let the court know our position rather than having to restate it repeatedly.
And Judge, I've carefully crafted my questions to avoid any privileged information. But if they think that I'm invading that, then I welcome an objection and I'm happy to address it.
Let's see how it goes. And again, Mr. Bradley, I'll ask if you can just give a pause in between each question to allow counsel the opportunity to object before answering.
Thank you, Judge. Was the witness sworn or do I need to swear the
I
witness?
believe he was.
Great, thank you. I'm sorry. Good morning, Mr. Bradley. How are you?
Good morning.
Not happy to be here, I'm assuming.
I am not.
I understand. Thank you for being here.
Wasn't by choice.
Right. You were subpoenaed to come and testify in this case.
I was.
But you and I have spoken previously about relevant facts surrounding Mr. Wade and Willis's relationship.
No, we have not.
We've not texted about those facts.
Through a third party, you were giving some information. You and I shared text. Our texts were more so about my health, more so about if I was okay with what was going on, that I would not be, whether or not I was going to be subpoenaed or not, and that emphatically I would not have been sitting in this position as being called as a witness. So
I ain't no
that's what
snitch.
my text chain show. So no.
That we've never talked about Willis and Wade having a relationship.
Not directly you and I, no. We talked about my health.
Okay.
We talked about, as I stated before, other things, but not this, no.
Okay. Did you text me about Wade and Willis taking many trips together?
I object, well,
Mr. Brown, there's been an objection.
One, I'm gonna object as it relates to attorney-client privilege. Two, I'm going to object because I haven't seen the text message that she's attempting to impeach the witness with. And two, he's made all of his representations that he's had zero communication as it relates to the issues that
And she's impeaching that with her
to
question.
ask about, and that the only information that she has from him is through a third party, which would be hearsay.
Ms. Merchant.
Judge, it's not hearsay. We've had these conversations. If I need to take the stand, I will. If I need to put my phone into evidence, I will.
So the first objection was to privilege on behalf of the state.
Oh, I'm sorry. I did not respond to that.
Sure.
Thank you, Judge. Privilege is only communications that are made in furtherance of legal advice. There's been no showing that whether or not they took a trip to California or took a trip, or that Mr. Bradley and I talked about that, either in person or by text, that's privileged. I'm not asking for any communications that Mr. Wade might have made to Mr. Bradley in furtherance of any legal advice.
All right. And Mr. Abadi, I believe as the one asserting privilege, it would be your burden to show the necessary foundation there. Is that something you want to voir dire the witness on or take up here on this specific question?
Well, no, I'd also object to foundation grounds. She has not provided any foundation that he would have any knowledge of what she's
Refute what he just said.
requesting.
They didn't talk at all.
Where he had no knowledge, and now she hasn't laid the foundation in order to continue to ask the same question over and over again.
Ms. Merchant.
Judge, on behalf of Mr. Bradley, we do object. This falls under the privileges afforded under 1.6 of the rules. And the attorney-client privilege is not something that Mr. Bradley can waive. Only Mr. Wade can waive it, regardless of any information or communications being proffered by the client. Mr. Wade would have to waive them in order for Mr. Bradley to continue to testify about any of this relationship until it's been established when that privilege should have.
What he said, whether or not he's telling the truth.
So far, though, I haven't heard anything about a relationship, about an attorney-client relationship, about a privilege ever attaching. And I think that's going to need to be established before we can actually determine the scope of it and whether this falls inside or out of it. So I think either Ms. Merchant can take the lead if she wants to, but my understanding was that generally has to fall on the person who's asserting the privilege.
Except for the attorney is not authorized to violate that privilege, or else he has in fact violated the bar rules, which we have an opinion regarding from someone in the state bar of Georgia.
All right.
that's why I thought perhaps the sidebar might be important rather than my interjecting.
Well, still want to kind of see how we can go. So, Ms. Merchant, it sounds like you're going to need to lay a little bit more foundation to see whether this actually is going to fall under privilege or not.
That's not a problem, Judge. And what I can do, I was just told that Ms. Yurdy's in the waiting room. But I can, if the state wants to read my text, if Mr. Bradley wants to read them to refresh his memory, I have absolutely no problem
Go
with
to
that.
Yurdy.
I have my phone here and they're welcome to do that. But
Yurdy
I'll
is
talk about some other things, and then maybe if they're going to have a lot of objections to privilege and hearsay, what I can do is I can lay a foundation with Mr. Bradley, get him off the stand, put Ms. Yurdy up, and then Mr. Wade, so we can get through the privilege issues. That might make the most sense. Thank you. All right. Let's talk about something not controversial then. When did you and Mr. Wade first meet?
Probably 1998.
Okay. And did you all have a law firm together?
We did.
Okay. When did that firm start?
Probably, I think it was 2010. We started exclusively working together as a firm, operating as a firm.
Okay. And were you all actually incorporated as a firm?
Not initially, no. He had, when I passed the bar and I hung the shingle in 2007, I think he had been practicing a few years prior to that. He had his own firm. We had two separate firms.
Okay. At some point, did you all incorporate though together?
We did.
Okay. Do you remember about when that was?
I do not at this particular moment, no ma'am, I'm sorry.
Okay. Do you remember if it was administratively dissolved?
I've been made aware that it's been administratively dissolved. Yes, I left the firm around 2 years ago.
When did you leave the firm?
August of 2022, I think it was.
August of 2022. Okay.
It was either August or September of 2022.
Okay. August, September. Let me make a note. So at in October 2019, were you all incorporated as a firm?
I think we were, maybe.
Okay.
Yes.
And when Mr. Wade filed for divorce November 1st or 2nd, 2021, were you all incorporated as a firm?
We should have been. I'm thinking that we were. Yes, ma'am.
Okay. When did Mr. Wade come to you to file the divorce action in Cobb County?
That's privileged information.
No, it's
The
not.
timing and the
No, it's
beginning of
not.
privilege, I don't believe that is overall.
So the timing was around 2018.
Okay.
And it was probably December 2018. I remember it specifically because I was building a house. And I noticed that he wasn't wearing his ring. I asked him about it. I had invited him to the house because I was having not a housewarming, but people over. And he wasn't wearing his ring. I inquired about it. From there, we discussed what would happen. And we discussed the divorce and what would happen.
What would happen with the divorce?
What would happen over me representing him for the divorce and when he would want to do it, yes.
When did he retain you?
Well, my memory would be 2018
Okay.
when he consulted with me about the divorce and told me what he would like to see done and when he wanted to do it.
Do you know when Fani Willis and Nathan Wade met?
Specific dates, no. I know it was sometime at a conference.
Municipal court conference?
Correct.
And October 2019, if it's been represented in the state's pleadings before that's when they met, does that sound familiar?
If that's what they're saying, then absolutely. I know it was at a conference in 2000. I mean, it was at a conference. If you say it's 2019, I'll take you at your word.
Okay. So it was what you're sure of though is it was at a municipal courts judges conference
Yes.
when they were both municipal court judges.
Yes.
So it's fair to say, since she became district attorney, she was no longer a municipal court judge. So it had to have been before that.
That they met?
Yes.
Yes.
And he was teaching a class at that seminar, as far as you know.
I'm going to object to deleting at this point. That's on direct.
Was he teaching a class at this seminar?
To my knowledge, he was.
And was Miss Willis, to your knowledge, attending this seminar?
Your Honor, I'm going to object. He has no personal knowledge. He wasn't present at the municipal court training.
But they put it in their pleadings. Like, we are going to be here all day.
We are going to be here all day.
All right. If you can establish that he would have some personal knowledge, then that's a fair question. So if you just need to preface it with that, then that's fine.
Thank you. Are you aware of when their romantic relationship began?
Your Honor, I'm going to object. That relates to privilege. She says that he began representing Mr. Wade in 2018. He met Ms.
Whether or
Willis
not
in
he's aware.
2019. That's clearly within the bounds of attorney-client privilege.
I think there's
Know that.
understood, Mr. Vadi. So I think, Ms. Merchant, you need to qualify that question.
Qualify like
thank you.
outside. Did you learn
I'm
about
not
that?
asking you to tell me what Nathan Wade told you in furtherance of legal advice. Okay, so I want to be very clear. If he told you something asking you legal advice, I'm not asking you about that. I'm asking about what you observed, what you saw, and what you knew outside of what he told you when he was specifically seeking legal advice. Okay.
Judge, this is too far afield. I apologize. I object again on behalf of Mr. Bradley. He's asserting that there's an attorney-client privilege associated with this case.
He's not
Rule
asserting.
1.6. For him to draw any inference, make any statements, or any other proffer of information after this relationship began between attorney and client in December of 2018 would be improper, and he would in fact be violating the rules of ethics associated with his bar license.
So the way the
Not be
question was
observed.
phrased was just saying, what did he personally observe outside of the relationship, not involving communications? How does that fall within attorney-client privilege?
So, Your Honor, whether we like it or not, when we have a client, there are a number of items associated with that relationship between attorney and client that come within your purview and that lead you to further action, lead you to further investigation, further questions, develops your strategy. We can't talk about Mr. Wade on any level. It would be inappropriate. The divorce was filed sometime thereafter. During that entire interlude, any of these issues could in fact have been the basis for their relationship to remain privileged.
Ms. Merchant?
Judge, his observations are not privileged. That's not what the privilege law says. And I can read you the attorney-client privilege attaches where, and this is the law, this is the rule. There's an attorney-client relationship. The communications in question relate to the matters on which legal advice was sought. And the communications have been maintained in confidence,
Not on
and there's no exceptions to the privilege. First, or number two, the second prong. This was not in furtherance of legal advice. That's not in furtherance of legal advice. What he witnesses as a human being is not in furtherance of legal advice. Unless, and if he witnesses them together, it would get rid of the attorney-client privilege because Ms. Willis is there. Additionally, though,
Great point.
exceptions. We can go all day about exceptions to this. Fraud to the court, that's an exception. Mr. Wade, we contend, has filed a false affidavit with this court. That is fraud to the court.
Yep.
If this witness has direct knowledge that that is not true, then that's an exception to attorney-client privilege.
There you go. Great. Get him. Get him. Does anyone
All
else
right,
present? There's no attorney-client privilege. Who's not an
Ms.
attorney?
Merchant, if you could re-ask that question, again, qualifying it as, if it's, I think you qualified it as anything that outside of anything he learned or was told as a result of his representation. It was just any observations he made, which in my mind, as you phrased the question, would have included before December 2018 when this first consultation occurred.
That's correct.
I think if you can go step by step, we can handle this.
And Judge, I would just ask permission. We gave the state notice under 611 that all of these witnesses do not want to be here. They are adverse witnesses.
I understand.
Yes, so I'd like to have leeway to be able to cross it. Thank you, Judge.
She can lead, and that's the point.
All right, Mr. Rapp.
Objection leading.
Yes, ma'am.
You have knowledge that their relationship began in 2019.
I do not have knowledge, but again, I have consulted with the bar as late as yesterday at 4:00. I am not here to.
Your testimony is that you do not have independent knowledge.
I cannot. I was advised by the bar that Rule 1.6 of confidentiality applies, and that I cannot reveal anything that I saw or learned.
That's
And that
crap
if
advice.
the court is
That's not
asking
true.
me to do that, that an immediate certificate of review should be asked. And so I'm not here to misrepresent to the court or to say anything inappropriate or anything. I am here because I also have a law license, and I'm not trying to lose that.
And so, Mr. Bradley, can you finish that thought? As saw or learned, just period, without qualification whatsoever?
Judge, I'm going to refer to what I was told by the bar, that Rule 1.6 of confidentiality applies,
Ridiculous.
and that I would be asking for an immediate review by the Supreme Court.
Sure, but applies to what?
Any communication is what the person at the bar told us.
That's not observations.
Any communications? So like,
He did not
like Ted, if you
qualify.
talk to Mr. Wade, that's covered.
Well, Judge, I don't know. He didn't go into those specifics.
That means you didn't ask about those.
This is what was told. I was sitting there with my attorneys, and this was what was told to us. To state that Rule 1.6 applies.
The answer you get from the bar depends on the question you ask.
And we gave them the scenario, and this is what they told us to do. And this is what I'm doing.
This doesn't mean the
at this
bar's
particular-
corrupt the way a lot of you think.
Judge, and
You
we have
phrased
no
the
knowledge if
question.
the bar was aware of the affidavit that Mr. Wade filed, but that significantly changes the privilege. He waived the privilege when he put that in the affidavit, so that's one of the reasons I wanted to call him. That's a waiver. He put the relationship in the when the relationship started and put the relationship in his affidavit. He put a lot of information in that affidavit that would waive certain amounts of privilege. So he disclosed this relationship. So basically what we've got is we've got Mr. Wade being able to say what he wants about this relationship, but then we're not allowed to ask questions to qualify that.
During a break, I'll
So
explain
that's not
this
how it
bar
works. They
issue.
either get to admit it or they don't. Either privileged or it's not.
We're just talking about a relationship, though. How does that open the floodgates to anything he's ever told an attorney during representation?
It doesn't, and I'm not asking him that. I'm asking for his knowledge. They were law partners, and as I go through the questions, I think he has knowledge of things that is not something that Mr. Wade specifically told him. I also think there's a fraud exception to a lot of this, even if there was a privilege, but I don't think there was for most of it.
Your Honor, but he's already represented that he has no knowledge of it.
I don't think we've actually gotten anything
No.
to that extent yet.
Yeah.
I think we're still
And nothing. You keep
making our way
correcting
through
every
it,
2
which is,
seconds.
I think he's taking the position that he's not willing to share anything Mr. Wade ever told him, period. Which that's a broader representation of attorney-client privilege than I've ever heard.
Yep, it's ridiculous.
And I think that's what we're trying to parse out, is if the relationship starts, I've never heard anything that said everything before that point is privileged. Do you have
Before that
something that I should know? Yes,
My
sir.
apologies, Judge.
That's fine.
Before that relationship, these questions aren't being established. It was 2018, December. The last question was directly related to a point in time after that, during which the relationship, attorney and client, would have been already established.
No, that's not really
an opinion
established.
From the State Bar of Georgia, if he's going to be required to testify when he's ordered by the court on any of these issues. And Judge, I understand how delicate this is. You can phrase it in 1,000 different ways to try to make him say something, but you can't unring a bell that he puts out into the universe where he has violated that privilege. We're going to get to go back 6 months from now and say, oh, well, we shouldn't have said that. It's not acceptable. It violates hundreds of thousands of relationships in this state that we rely on in order for the justice system to function. This is an attorney-client privilege issue. We've done all the diligence we can as far as looking up the relevant laws, relevant information. We do not have a waiver from the client. The client is present.
There's no question why we're not barreling ahead is because I recognize the privilege. What we have to determine is actually what that privilege, the scope of it, and when it started. And I don't think we've even gotten close to that yet.
Yeah, we haven't.
I apologize, Judge.
We don't know when the attorney-client privilege.
Mr. Bradley testified directly that is when the retainer and the divorce proceedings were
I
beginning.
didn't say that.
The issues being brought up by the state have to do potentially, if I've been
So we have a starting point,
correct.
but does that necessarily foreclose anything from that point onward? If they started talking about something else entirely?
Post-divorce, of course not, Your Honor. But during the pendency, it would absolutely
That's
curtail
ridiculous.
that, especially
That's
as it has to
ridiculous.
do with observations.
This thing in a basketball game?
Functions together or other realizations that Mr. Bradley came into during the pendency of his representation. And to parse it out would put Mr. Bradley in an untenable position because his reputation means everything.
Okay. Ms.
None of them are me.
Your Honor, I think we're talking about two aspects
Other than this.
of arguably the attorney-client privilege. There's the attorney-client privilege, which is controlled by case law and statute, which deals with communications and furtherance. I don't hear that being the objection. The objection is that there are confidential matters under 1.6, which in some form or fashion mean that once you start a relationship with attorney-client, that everything from that point on is confidential between two. There's no such case law in Georgia that deals with confidential information at that time. Attorney-client, yes. Confidential information, no. And I believe what's being argued by counsel, Mr. Bradley, is that he has received, of course, we don't have anything in writing, but he's received some oral advice that under 1.6, confidential matters cannot be gone into, which is, according to them, everything that occurs between Mr. Bradley and Mr. Wade from 2018 forward. There's no such law that protects such confidences, only communications made in furtherance. And if I'm mistaken, I apologize, but I think what we're being told is I don't have to say anything at all about Mr. Wade once I have an attorney-client relationship with him because it would be deemed confidential, and if it's deemed confidential, I can't talk about it. And there's no such case law to that effect in Georgia. There is no bar rule to that effect.
Anywhere.
What the court has to do is say, are we talking about attorney-client privilege or pure confidences or confidential information? And once you decide it's confidential information, you ordered Mr. Bradley to testify, and then it's up to his counsel to decide whether he wants to have his client held in contempt.
Well done.
Ordered him to testify.
Well done.
That's an overstatement. We have not said that he can't testify.
That's exactly what you said.
The specific question on the table is what observations do you have from Mr. Wade and Ms. Willis from that point on? Now, they, the defense and their teams, have made an allegation of some impropriety. That same impropriety could be related to a divorce proceeding on every level. We're not here to say we're not talking. We're here to say we're not talking about things that came into his knowledge associated with his representation during the divorce. I realize there's an evidentiary standard, and then I realize that there's the cornerstone of what we do, which is the bar rules, the state bar rule 1.6. We violate that, and the whole thing comes tumbling down. We're not saying that you can't ask about, did Mr. Wade enjoy a beer at a ball game? That wasn't the question. The question was specifically relating to some impropriety that they were trying to dig into. That is privilege.
What if he talks about Fani?
Mr. Bradley has said twice now that he has no independent knowledge as it relates to what she's referencing. He has said it 2 times. So there's not a good faith basis for her to continue to probe into this area because he said he has no independent knowledge outside of the attorney-client privilege.
All right, Ms. Merchant, last word.
Yes, Judge. Judge, Mr. Bradley, if ordered, he's here by subpoena. If ordered to testify, it's not a issue with the bar. My question was not about attorney-client privilege. I'm being very careful not to ask anything that Mr. Wade asked in furtherance, but I've been informed that Robin Yeardy is on the Zoom. And so if we want to start back on our original plan, we can call Ms. Yeardy and have her testify and then put Mr. Wade up and we can go through the privilege issue with him. And then we won't have to have all these objections, or else I'm happy to continue questioning Mr. Bradley.
Go to Yeardy.
So Ms. Merchant, you're saying that your understanding of the evidence that you plan to present, that these issues are affected by Ms. Yeardy in terms of the scope of the privilege and the relationship?
No, I think, thank you for letting me clarify that. I think that Ms. Yeardy is going to give me enough to get Mr. Wade on the stand. Once I get Mr. Wade on the stand, because they filed a motion to quash, and you said I had to present something before I could put Mr. Wade on the stand. So once I present Ms. Yeardy, I can put Mr. Wade up on the stand. And then I can put him up before I call Mr. Bradley. And then I may not even have to present Mr. Bradley at that point.
All right, let's go to Yeardy.
All right.
Judge,
Sorry, who's
I'm on Zoom, Your Honor. Attorney Durante,
Just like
on behalf of Ms. Yardy.
God talking to me.
Your Honor, when we were here for the motion to quash earlier this week, it's my understanding, as represented by defense counsel, that Mr. Bradley's testimony is, so to speak, the bridge that was built to involve my client, Ms. Yardy, into this matter altogether. Now it seems as though that is being usurped, and now she is being the quote unquote foundation for the defense counsel's presentation this morning. So we do object.
None of them want to
renew our motion to quash the subpoena, because this is completely contradictory to what we had via the hearing earlier this week, Your Honor.
Judge, may I
It's okay,
respond?
Ms. Merchant. Mr. Partridge, as I recall, that did not apply to your client as much. The original motion to quash that you filed said she had absolutely no knowledge about anything.
Mute
What
yourself.
Ms. Merchant proffered, and
Mr.
what I
Yurdy
didn't
on the
hear
stand.
you saying was not the case, is that at some point Ms. Yurdy lived in a residence and shared a residence with Ms. Willis and potentially Mr. Wade at some point. So I think she's directly involved in the center of this. I don't think that really needs much in the way of foundation.
And Judge, I apologize, Your Honor, to talk over the court. That information, however, Your Honor, is my understanding, came from Mr. Bradley, and that information was incorrect, as I informed the court earlier this week as well. There was never any time that Ms. Yardy and Ms. Willis lived together. There was
This
a
is a
sublet
factual
of
question.
a
Let's get Yurdy
condo
on the
that Ms.
stand.
Willis
not
resided
a
in
legal
that
argument.
had absolutely nothing
Shut
to
up.
do with that of Ms. Yardy, outside of Ms. Yardy subletting it to Ms. Willis.
Well,
Ms.
we'll know
Yardy
that
actually
when she
moved into a
answers
different
questions.
residence. Per our conversation with Ms. Merchant yesterday, that is exactly what it is. So there was no overlapping or any time that they stayed together, nor does Ms. Yardy have any
Let her
information as it relates to
testify. You're
Mr.
the one
Wade
who's gonna
staying
testify
at
now.
that condo as well with that
Shut
of
up.
Ms.
Oh my
Willis. So
God.
again, Judge, I'm renewing.
No, we don't need to hear it again. Ms. Merchant.
Judge, luckily, I don't have to tell the state or them everything that I plan on introducing a witness for in response to their motion to quash. She has a lot of personal knowledge. And when we had a motion to quash, I had to get over a good faith basis, and I presented that to the court. I did not spend 4 hours going
Right.
through everything that this woman's going to testify to. She has personal knowledge.
Is she actually here?
I think she's on Zoom. What I understand, Mr. Partridge.
Mr.
put her on
Partridge, is
Zoom.
your client with us?
She's on the Zoom platform, Your Honor, since I'm in Richmond County via my conflict, but she is on the Zoom platform at this time, Your Honor, in the waiting room. I believe she may have been admitted. I see a Robin on my screen. I'm assuming that is my client, Ms. Yardy.
Ms. Merchant, you want to examine her by Zoom?
That's fine.
I just need
Right.
We will waive
Mr.
any
Abadi.
Sixth Amendment objections to
Sure.
it. That's fine.
My only objection was the representation at Monday's hearing was the good faith basis was based on what she learned
Shut
from
up.
Terrence Bradley. We know that is false. It's not true. So there is no good faith basis, and we would renew our objection and to quash the subpoena.
That was not in regards to Ms. Yurdy.
It certainly was. It was at like the 20-minute mark in the hearing.
Judge, she has personal knowledge of this relationship.
It's not what was represented on Monday. The personal knowledge came
That's
from
not
Mr. Bradley.
relevant.
There's no good faith
Just explain
basis
why it's
to
not
explore
relevant.
this
Oh my God,
fishing
sit down.
expedition as it relates to Ms.
You're so
Yurdy.
desperate.
This is a blatant misuse
All right,
of the
Mr.
process.
Ms. Merchant, I do believe that when we went through the motion to quash, you grouped them into two categories, and each one of them we said that they were going to be impeached by Mr. Bradley.
We took Ms. Yurdy outside of Fulton County, Judge. So we talked about Fulton County differently than Ms. Yurdy. We took Ms. Yurdy out separately. She was different than Fulton County because there wasn't other issues. And again, so we're arguing a motion to quash. I responded to their argument on the motion to quash. Did I tell them that she's going to testify that she's known Miss Willis for years and that her middle name is Latrice? No, I didn't tell them everything she's going to testify to. I don't if you wanted me to, I could have, but that has nothing to do. There is a witness that contradicts what they have said in court, and they're doing everything they can to keep her off the stand and keep the truth away from this court. They filed a motion to quash. I showed a good faith basis. If my good faith basis is Mr. Bradley or Miss Yurdy or texts I've seen, it's still a good faith basis.
No,
There's
it's
no
not
law
my
that
right.
says I have to tell them every single good faith basis I have ahead of time. If we did, we would never have trials.
All right, Ms. Merchant, appreciate the argument of counsel. I think the standard on a motion to quash and a subpoena is not one where we're required to completely flush out and litigate every reason the
Get her up
witness
there.
may be relevant. And so we'll take these one at a time with Ms. Yurdy. I'll deny the motion to quash. And if your
Nice.
election and to proceed in your presentation of the evidence is to call her, then that's what we'll do.
Thank you, Judge. So, Mr. Bradley, you may be excused for now. Thank you, but subject to recall. We will call Ms. Yurdy.
She's keeping it together really well. Really well. Really well. She's fending off one shark after another. She's like, this oh, there's another one. Ah, there's another one. She's like fending them all off. Doing really well. And the judge so far seems pretty reasonable.
Would you like me to swear her, Judge? Or?
I think we need to make sure. There we go. Deputy Scott, if we could swear in the witness.
She
Ms.
looks
Yurdy,
so
can you
mad.
hear us?
What's with those earrings?
Yes, I can.
All right.
Jesus, look at those earrings. What the hell's going on?
You swear affirm the testimony you get a court will be the truth, that the truth will help you.
Yes.
Would you please state and spell your full name for the court?
Robin Latrice Yurdy.
L.
Thank you, Ms. Yurdy. Thank you for being here. Can you tell the judge when you first met Ms. Willis?
In college.
Okay.
So 19.
But those are her glasses.
90 or 91.
And have you been friends since 1990 or 91?
Yes.
When was the last time you spoke with Ms. Willis?
March of 2022.
From 1991-ish till 2022, were you what you would consider good friends with Ms. Willis?
Yes.
And did you all share personal information regularly?
Yes.
And did you even come and work with her at the DA's office?
Yes.
And when she needed a place to stay, did you let her stay at your apartment? It was a condo, right?
Condo, yes.
Do you remember approximately when she moved into your condo?
It was April of 2021.
Okay, great. And you know that Ms. Willis and Ms. Wade met at a conference in October of 2019?
I'm going to object to that, Your Honor, without a foundation for how this witness would know that. If Ms. Merchant can establish she has personal information of that, then certainly that's something the witness can testify to. But if it's, she heard it.
Understood, Ms. Cross. All right, Ms. Merchant, if you can lay the foundation.
Do you have information that Ms. Willis and Mr. Wade met in October of 2019?
I'm going to renew my objection, Your Honor. Information is not sourced to personal information. If the question can be rephrased, then that may address my concern.
So Judge, I just want to make sure that I understand. So they've objected to me calling Willis and Wade.
It's just a matter of foundation. If you can just rephrase.
Do you have knowledge of when Willis and Wade met?
I'm going to object again.
Let's
Personal
just say
knowledge.
personal knowledge.
Thank you. Do you have personal knowledge of when Willis and Wade met?
Now she threw in personal.
Yes. She told me that they met at a conference. I don't know what conference.
Okay.
I'm going to renew my objection, Your Honor. Clearly, this is not firsthand information from this witness. It's hearsay that was.
But you said she told me.
Yes, it's statement against interest, Judge. If Ms. Willis,
Just pause.
I'm sorry.
Okay, Ms.
Yes.
Cross.
The representation of the witness, the testimony of the witness was that Ms. Willis, District Attorney Willis, had a conversation with her. There is no statement against interest. District Attorney Willis is not a party opponent in this case. The information that the witness has testified to came from Ms. Willis, and we have a hearsay objection to that.
Why wouldn't she be considered a party opponent in this context?
She is a representative of the state, Your Honor. This isn't private litigation or civil litigation, obviously.
The claim is that she should be removed.
Ms. Willis is not on trial. Ms. Willis has not
Yes, she
a
is.
party to the litigation outside her obligation to pursue criminal charges with the state.
Ms. Merchant. I guess it's evolved into a hearsay objection.
Yes, Judge. And we plan on calling Ms. Willis to the stand. She's under subpoena, so hearsay will be cured. If there is a hearsay objection as far as that issue,
That's not the best answer. There are better answers.
but we do still think that it's a statement against interest.
Yes, that's what you
Ms.
should be fighting.
Willis has filed a document that states that they met at this municipal court conference. So
Paint out how she's a party
I think maybe I
opponent.
can streamline a little bit. State will stipulate that District Attorney Willis and Mr. Wade met in October 2019 at the judicial conference that we've been talking about. There's no reason to get it secondhand from this witness. Well, that's true.
So then why you
All
object?
right, you accept the stipulation, Ms. Merchant?
yes. Am I permitted then to ask questions about that since it's now
Don't
not
keep-
hearsay?
Don't get pet. Don't get,
If it's just to a stipulation,
you're good.
if
You're
it's just to
good.
that basic fact,
good,
I
Ashley.
don't think we need a question, but if there's a follow-up that you
Okay.
think is admissible, go for it.
Ms. Yurdy, you have personal knowledge that Ms. Willis and Mr. Wade began their romantic relationship soon after this time that they met at the municipal court.
I'm going to object to that question. That certainly is a leading question. No foundation has been laid for how this witness would have
There's no
personal
leading
knowledge of that
issues.
until that's happened. The state objects.
Judge,
I think you can do a yes or no and then follow up with how she knows it.
thank you. Do you know if Ms. Willis and Mr. Wade started dating in October of 2019?
I don't know if it was October of 2019.
Could it possibly be November of 2019?
Could possibly.
Okay. And when we spoke, you said it was shortly after the municipal court conference, is that correct?
Yes.
Okay. So
Nice.
you know that their relationship, their personal relationship began shortly after this municipal court conference.
Yes.
And when I say personal, romantic. I just want to make sure we don't get in an argument over what personal and romantic is later. When I ask you personal, do you take that to mean romantic?
Yes.
Yes. Bam.
Do you understand it that their relationship began in 2019 and continued until the last time you spoke with her?
Yes.
Oh yeah. Here we go. Here we go.
And you were essentially her best friend during this time, right?
Not best friend. Good friend.
Good friend. Okay, close friend. And so would you frequently socialize with her?
Yes.
And you saw her at work every day?
Yes.
So you had a chance to see them interact together on a personal level?
Yes.
And so from everything that you saw, heard, witnessed, it's your understanding that they were in a romantic relationship beginning in 2019?
Yes.
And when you left the DA, I'm sorry, let me ask you, you said that Ms. Willis came to live with you in April of 2021. I'm sorry, April 1st, 2020 or 2021?
She didn't live. I never lived with her.
Okay, I'm sorry. She took over your lease in April 1st, 2020, correct?
No, 2021.
Okay, I had it both ways, so I'm glad you clarified. So when she took over your lease in April 1st, 2021, it's your understanding she moved out of the house that she was sharing with her father and started staying at the condo?
Yes.
And is it your understanding that that's because she needed to have her own space?
Yes.
Away from her father?
Yes.
Okay. When you left the DA's office, was it, were you fired?
No, I resigned.
You resigned, okay. Just one moment, sir.
Just to go over the timeline.
Can you tell us why you resigned the DA's office?
The number of things that was happening.
A number of things that were happening, is that what you said, ma'am?
Yes.
Okay. What was happening that caused you to resign?
More specific? A little more specific?
It was a spiral of things. So, I guess the last straw is I was put in a department that I knew had no knowledge about. Something happened, and I didn't like it. They didn't like it, and that was it.
Okay. Did you have any falling outs with Miss Willis?
Well, we never spoke after that.
You never spoke after that, okay. And so you're, without going into all the painstaking details, there's no doubt in your mind that from 2019 until 2022, Miss Willis and Mr. Wade were in a romantic relationship.
What's the question?
You have no doubt that their romantic relationship was in effect from 2019 until the last time you spoke with her.
No doubt.
Dang.
And that's based on your personal observations and speaking with them and seeing them together and things like that.
Yes.
That's it.
No other questions. Thank you. The other folks may have some questions for you, Mr. Yurdy.
Say no.
You want me to go to the turn?
If it's more than a couple questions, then sure, but if not.
It's only a couple questions. I think, can the court reporter hear me okay?
That's great, Dennis.
Ma'am, let me be very specific. Did you talk with Miss Willis about her romantic relationship with Mr. Wade?
Yes.
Did Miss Willis tell you on more than one occasion that she was engaged in a romantic relationship with Mr. Wade prior to you leaving the district attorney's office?
Did she tell me or did I observe?
I'm straight right now with the tell me.
Yes.
Did she tell you that in the year of 2020?
Yes.
In the year of 2021?
Yes.
Are you certain that Miss Willis told you about the romantic relationship with Mr. Wade prior to November 1st of 2021?
Yes.
Now, did you also have observations of Mr. Wade and Miss Willis together prior to November 1st of 2021?
Yes.
And are those observations, were those in a social setting?
Yes.
And did you observe them do things that are common among people having a romantic relationship?
Yes.
Such as, can you give us an example?
Hugging, kissing, just affection.
All before November 1st of 2021, correct?
Yes.
That's all I have.
Beautiful.
Mr. Stocks.
Great job. Great job.
Ma'am, did I understand you to say that there was a period of time when you and Miss Willis lived together?
No.
Mr. Durham.
No, nothing for me, Your Honor.
Mr. McDougall.
Nothing, Your Honor.
Mr. Rice.
I'll come back to this.
Good morning, Ms. Yurdy. Were you aware in 2021 of any trips, social trips that Ms. Willis and Mr. Wade took together?
No.
These are all
Are you aware of any
co-defendants
social
who are
trips
questioning
that
her.
Ms. Willis and Mr. Wade took together in 2022?
No.
And are you aware of them in 2020 or 2021 spending the evening together overnight?
No.
No further questions.
Mr. Gillen.
Go ahead.
Mr. McCullough. And Mr. Cromwell.
No questions, Your Honor.
Ms. Cross.
I do have some questions. Thank you, Your Honor. Ms. Yurdy, we haven't met before. Is that correct?
Correct.
You're able to see and hear me okay?
Yes.
All right. I want to start with a couple things. Now, I think you've made it clear that you never lived, and we'll call it the South Fulton address, the South Fulton condo that you were leasing. You never lived at that address with the District Attorney Willis, correct?
Correct.
And never at any time?
Never.
All right. You never observed or have any information about District Attorney Wade and District Attorney Willis and Nathan Wade living together, correct?
Correct.
You don't have any information about that?
No, I don't.
Anybody said that that information was sourced to you, then that's incorrect.
That's incorrect.
Did District Attorney Willis pay rent at that establishment, at that condo while she lived there and you were living elsewhere?
Yes.
Who paid the rent?
She did.
Nathan Wade ever pay the rent?
No.
And you never told anyone otherwise? I didn't hear your answer there, Ms. Yurdi. Did you ever tell anyone otherwise?
No.
All right. So let's talk for a second about your time at the district attorney's office. You were disciplined several times in the district attorney's office during your employment there, correct?
No.
You weren't written up ever for poor performance, Ms. Yurdi?
Once, not several.
One time you were written up for poor performance. Were you counseled several times about your performance in the district attorney's office that was subpar?
No.
They're trying to establish bias.
Did the district attorney tell you that your performance was insufficient and that you were going to be fired?
No.
That never happened?
No. Maybe when we were at the end. What's the question?
The question, Ms. Yurdi, was did the district attorney ever counsel you on your poor performance in the district attorney's office prior and inform you that you were going to be fired?
We're going to get them all on the stand. This was so key. We're going to get Nathan on the stand. We're going to get Fani on the stand.
I don't really know how to answer that. I mean, the situation happened. That wasn't my fault. And I either was going to resign or be let go. So.
You understood that that was the situation. You could resign or you could be let go.
Correct, yes.
You were not welcome to stay.
No.
She's trying to establish bias, but that's not going to help.
And the conversation where you were informed that you could resign or you could be fired, that conversation was not the first conversation you had with the district attorney about your poor performance in the office, correct?
Well, it was kind of a spiral, but no.
Yeah, it was. Whatever the situation was.
Commentary by counsel. Questions are fine.
Understood, Mr. Sato. Ms. Cross.
Ms. Yurdi, the circumstances of your leaving the district attorney's office ended your friendship with the district attorney Willis, correct?
Yes.
Y'all haven't spoken since?
No.
She's trying to establish bias, but even if she can establish bias,
I want to
there's
talk
enough
about
question
the
of fact now
representations that you made here
that they
this
can get
morning,
weight
Ms.
on the
Yurdi,
stand.
about
They've got weight on the stand now. He's
any
coming.
relationship between District Attorney Willis and Mr. Wade. I want you to tell me what was the first time let me ask it this way. You said that District Attorney Willis personally informed you of a romantic relationship. Is that what you testified to?
Yes.
And when did that conversation that you purport to have, to recall, when did that happen?
I mean, I don't have a month or a day.
Where were you?
Just talking in general.
Your Honor, we'd like to keep this witness under subpoena, but that's all the questions I have right now.
All right, thank you, Ms. Cross.
I have to recross then. I mean, redirect, I'm sorry.
All right, on those points only.
Yes, just this one. The state asked you a lot about when you were let go, when you resigned. Did something happen as far as purchasing that you didn't feel comfortable with, purchasing things through the county for Ms. Willis that caused you to not be comfortable working there anymore?
No.
And I didn't tell you how to testify here today though, right?
Right.
And everything you've testified to is from your personal knowledge?
Yes.
Okay. And you've told the truth here today?
Yes.
Okay. Judge, I believe she's only under my subpoena and I'm fine releasing her from that subpoena.
Not yet.
Oh, I'm sorry.
By show of hands from other counsel, starting with Mr. Sato.
Your Honor, I believe the door's been opened now to ask this particular witness about statements that Ms. Willis made to her. She brought it up on cross-examination on a couple of occasions. Did Ms. Willis say this or inform you of that?
Nice.
So I'd like to now ask her questions
Nice.
directly about what Ms. Willis told her about her romantic relationship.
I think we'll take those one at a time, question by question, and we can address those to see. I don't know about a complete opening of the door. We'll see where we go.
The first time that you spoke to Ms. Willis about her relationship, romantic relationship with Mr. Wade, do you happen to remember what Ms. Willis said? In essence, not word for word, but in essence, what she said.
No,
Do you remember the first time she told you, in whatever words were used, that there was a romantic relationship?
no,
Is this the kind of conversation that you had with your best friend, ongoing over a period of time in which it was common knowledge to you that there was an ongoing relationship between Miss Willis and Mr. Wade?
what's the question?
Yeah, I'll ask it again. Is the nature of your then relationship with Miss Willis such that you were having these ongoing conversations, that is, best friend type conversations about her relationship with Mr. Wade?
I don't remember.
Without getting any further in too much detail, is there any doubt at all that Mr. Wade and Miss Willis had a romantic relationship, as was told to you, prior to November of 2020?
She was already asked that question by Ms. Merchant.
I just didn't know whether that needed to be.
She said no.
He just
No
wants
doubt.
to reiterate and end on a good note.
Any other defense counsel by show of hands? Seeing none. Last recross from Ms. Cross. Anything else?
Not this time, Your Honor, but we've asked the witness remain under subpoena and subject to recall.
Judge, she's under my subpoena and I'm releasing her from my subpoena. So they
Nice.
subpoena her, they will welcome it.
You go get her.
Ms. Cross.
I would prefer that the court keep her under subpoena. I think,
Sure.
Given the representation of
Court's
Ms.
gonna keep her on this.
Merchant, given how she intends to proceed today, that this witness may need to be recalled.
All right, understood. In the interest and knowing that we may have to bring witnesses back and forth, I think it's in the interest of the presentation of the evidence here. Ms. Yurdy, you are still going to remain under the auspices of your subpoena. And so please stay in touch with your attorney. We may need you to rejoin us on Zoom at some point today or tomorrow. Understood?
Okay,
All right, don't discuss your testimony with any other potential witnesses, all right?
all right.
All right, you can log off.
And Judge, I'd ask, just can Mr. Partridge stay on for just 1 moment?
For what reason?
The state have made some allegations that I misrepresented some things to the court, and I'd just like the opportunity to clear that up, that Mr. Partridge is the one that told me that they lived together for a month. They've called me everything but a liar today, and so I just think that it's appropriate for everyone to know where that information came from.
All right, Ms. Merchant, I think you've made your position clear. That's, I don't think we need to get sidetracked on that. All right, Ms. Merchant, you can call your next witness.
I like the way the judge is handling it.
Have you excused as well, please?
All right, take care, Mr. Partridge.
Here's your timeline.
All right.
Put the timeline over here so you
Ms.
also
Cross.
see the timing.
Your Honor, the
Key element here.
motion to quash Mr. Wade's subpoena was held in abeyance, waiting for the representation. I believe that the good faith basis that Ms. Merchant represented on Monday, I think that's clearly not accurate. I understand the testimony that's now in the record. Mr. Wade is available, but we maintain that at this time, the motion to quash probably should be granted, but understand the court's ruling.
I know he lost.
I'll say yes. On Monday, it did seem like the focus was that Mr. Bradley would be the hook that makes every witness potentially relevant. And we really haven't been able to explore that on the privilege issues that we'll likely have to tackle again later. But for now, the evidence in front of the court at the moment is that we have a witness who has said this relationship may have predated the affidavit that Mr. Wade filed. I don't see a way around the relevance of his testimony. And so I'll deny the state's motion to quash subpoena Mr. Wade.
Here comes Wade.
Ms. Merchant.
I think we're getting Nathan Wade now. Later on, I'll explain the whole thing about the bar. But the key here so far is I want to just point out the key date is November 1st, 2021. That's when he was fired, a day before he filed the court. The court is looking to establish whether or not there was a romantic relationship, which may have been motivation for Willis to start this entire prosecution in the first place and hire Wade. So now we have a witness who just came in and testified that they were dating for over a year at that point. started going out in 1919, 2 years. So they were like dating for a long time at that point. All right, not 1919, 2019. But they were dating for 2 years at that point. Almost 2 years. Is my mic too low? Because if it is, I can turn it back up. I'm having problems with the court volume. Here comes Wade.
Well.
My name's Nathan Wade, NATHANWADE.
Good morning, Mr. Wade.
Good morning.
Prior to filing this motion to disqualify, you and I were friends, correct?
Yes,
And in fact, I supported you when you ran for judge in 2016.
you did.
I wore your shirts, my kids wore your shirts.
Mr. Merchant,
Fines.
your personal opinions have no relevance.
Okay.
I mean that in the best way.
That's
All right?
completely fine. I
Let's
will
get
move
to the
on.
point.
Thank you. No. Totally fine. Thank you. You filed for divorce from your wife on November 2nd, 2021.
Yes, ma'am.
And in that divorce proceeding, did you file answers, things such as interrogatories?
I did.
Okay. And so interrogatories are where you're responding to things that basically answers that the other side is asking.
Everyone knows what.
Yes, ma'am.
Everyone important.
And
knows. It's a
I've
discovery
got your complaint for divorce. I'm just going to mark it for the record as Defendant's Exhibit 2. The first interrogatories that you answered, those were December 27th, 2021. Is that right?
Thereabout. Yes, ma'am.
Okay. And in those, you were asked different things, but those are sworn. You actually swear to those. You verify them, right?
Yes, ma'am.
Okay. And so that verification is where you're swearing under oath that everything in it is true?
Yes, ma'am.
And let's see, you were asked if you have any documents which relate to the purchase of gifts by you to any person other than the defendant with whom you have or had a relationship, romantic relationship from the date of your marriage, correct?
Yes, ma'am.
Okay. And you responded under oath that you didn't have any documents to that.
That's correct.
You again responded to an interrogatory. You updated those responses on May 30th, 2023.
Yes, ma'am.
Okay. And you actually sent those directly to opposing counsel in the divorce?
Yes, ma'am. I think so.
But in that one, you answered none again to that question, correct?
Yes, ma'am.
Okay. So May 30th, 2023, you said that you didn't have any documents showing any purchase of anything with someone that you had a romantic relationship with.
I believe the interrogatory was gifts.
Okay.
Not anything. Yes.
And I have it if you want to take a look.
You don't consider a cruise a gift?
I'm going to mark. Okay, so just for the record, I've got your
A free
complaint for
cruise,
divorce
not a
marked
gift?
as number 2. I've got the verification and the interrogatories from 2021. I'm going to mark those as 3. And then your May 30th, 2023, I'm going to mark as 4. Judge, may I approach the witness?
You may.
Thank you.
He spent a lot of money on cruise trips and other trips for her. And that's not
This
gifts.
is what I marked
It's
as
gift.
3. Okay, thank you, Judge.
Look at the judge's face. He's very he's like trying to figure
All
out.
right, if you would take a look at what I marked as 2, 3, and 4.
I don't think he's too happy with
Just see
Nathan
if you
Wade.
recognize those.
I did.
And are those, that's your divorce complaint, and then your 2021 interrogatory and your 2023 interrogatory, correct?
Yes, ma'am.
Okay, are they a fair and accurate representation of what is filed in that case?
Yes, ma'am.
I'd move to admit those into evidence.
And this is 2, 3, and 4.
It's 2, 3, and 4, yes.
All right. Any objection from the state?
The divorce.
I have no objection to 3 and 4, and subject to Ms. Merchant's representation that 2 is a filing of divorce. I just don't, the divorce complaint, I don't have that in front of me, that's subject to that representation. No objection.
All right. And by show of hands, any objection from other defense counsel? Seeing none, defendants 2, 3, and 4 This should be Romans, well, we'll just call them 2, 3, and 4, admitted without objection.
So that interrogatory that you filed in 2023, that's one where you said no, that you didn't have any documents relating to the purchase of gifts, that you had a romantic relationship with someone, right?
Which interrogatory are we talking?
Number 4, 2023.
Which number in the interrogatory?
Number 4.
So which number interrogatory are you referring to?
It's defendant's exhibit number 4.
No, she says what number on there.
Here.
Uh-huh.
Which number interrogatory are we referring to?
Oh, which number out of the questions?
Yes, ma'am.
Hold on. It is number 20, 24, 25, 26. All of them.
Have a number 24, 22.
Oh, this one. It's supposed to be numbered. I guess they're all numbered 1, so. Number 1 again, and then the
Normally,
number 1.
interrogatories are numbered like number 1, 2, 3, 4. But apparently, they numbered them. Apparently, whoever gave the interrogatory response here, which should be his attorney,
I don't
Bradley.
know how to tell you what number 1, because when you responded, you put number 1 on all of them.
You
So
just point to it.
this one. This one, I'm talking about this number 1, where this tab.
interrogatory is a whole series of questions.
Okay.
And then you have
Page number,
responses
but
to
it is the second
interrogatory.
page.
All right.
They're discovery
They're
things.
asking if you have any receipts for restaurants, hotels, bars, things like that.
Discovery vehicle.
The first number 1,
I believe it's the second number 1.
the second number 1.
Oh my God. Look,
Okay.
So it asks you if you have any receipts for things like restaurants, bars, hotels, things like that, where you accompanied a member of the other sex romantic partner. Correct?
It says identify any and all occasions.
Okay. And so let's go through it, but yeah. It says to identify any and all occasions where you entertained a member of the other sex, okay, who's not related to blood,
Mhm.
and including dining, drinking, restaurants, bars, pubs, hotels, all of that. Okay. And what was your answer to that?
under oath. It's 7-1.
None.
None. Okay.
Oh, you
So
lied
May
under
30th,
oath.
2023.
Oh, no.
You prepared this document,
I did.
submitted it,
I did.
and it says none as far as
Was that
entertaining a
true
member
or
of the
a
opposite
lie?
sex.
It does.
Okay. No hotels, no bars, no restaurants.
Correct.
Okay. You again updated that.
That's
Let's see, you updated it on December 22nd, 2023. And I'm gonna mark that as defendant's number 5, and I have copies.
That's
Is
not
that
just a
correct?
lawyer. He's the special
Yes, ma'am.
prosecutor.
And then you
Oh,
updated
yeah.
it once again on January 26th, 2024, correct?
Yes, ma'am.
That one. May I
Wow.
first witness again, Judge?
Is that what you're marking as defense exhibit 6?
Yes, Judge. I'm
Yes.
marking number 6 is the January 26th, 2024 interrogatory, and then that one. And then number 5 is the December 22nd, 2023 interrogatory response.
All right, are you tendering those at this time?
Yes, I am.
All right. Any objection from any counsel to defense exhibits 5 and 6?
Yes, Judge. No objection.
Thank you, Ms. Cross. Seeing none others.
Luckily, I have for you. So now that you have those, let's just talk about those for a minute.
Ticket number 4.
Those were verified, so sworn under oath.
Mhm.
Okay. And one of them was December 22nd, and then of this last year, so last December, and then one was just recently submitted in January, right?
Mhm.
Okay. In May 10th, 2023, Judge Thompson heard a motion to compel in your divorce case as well, correct?
Yes.
And you were actually held in willful
Yeah,
contempt.
I'm going to object to the relevance of
His credibility is relevant, Judge, and if he was held in willful contempt for failing to provide answers and documents, I think that's relevant to this court.
How is that a prior false act or crime of conviction or anything else allowed for impeachment under the rules of evidence?
I'm not offering it as a prior bad act or something like that. I'm offering it towards his credibility, Judge, which you get to determine. If he's made misrepresentations in these pleadings.
I already know he's a liar.
You're here to determine whether or not he's telling the truth or not. So if another court has held him in contempt and that's part of the divorce proceeding, I think it's relevant.
But just contempt generally can be for many different things. Like a failure to produce is not necessarily a false act, right?
Right, and he's welcome to explain that.
He may not have to. Ms. Cross.
I object to the relevance of that. That's
He's not
clearly
gonna allow it.
a proper impeachment. We're going pretty
He's gonna
far afield
sustain the
into
objection.
divorce matters that don't have any direct relevance to anything that's pending before the court. Subject to the relevance of that. And
He's gonna-
All right. I'm not seeing that being a proper grounds for impeachment. It's sustained.
Okay, let's talk about this December 22nd, 2023 verification. I tabbed it for you. Again, they asked you if you had any documentations showing proof of this relationship, proof of any relationship, correct?
I'm going to object to the phrasing of that question. I don't believe that's an accurate read of the interrogatory.
Why don't you
Let's
just
be
ask him
precise,
if he
Ms.
went
Merchant.
everyone on a trip?
And
Ask him if he tonight.
Please read it. I want to make sure I'm accurate. Please read it.
Which number?
This one actually has a number. I tabbed it for you, so you should be able to open right to the page. It's number 22. The question specifically is if you have any tangible evidence of any nature in your possession or control or any other person or entity which relates to any manner of your activities to any person with whom you've had a sexual relationship during your marriage. Tangible evidence is notes, cards, letters, photos, films, recordings, documents, tapes, video recordings, receipts, invoices, and other tangible evidence.
Yes.
And you answered that you did not have any documents to that effect, correct?
Correct.
That was not true, was it?
And that was on December 22nd, 2023?
Yes, ma'am.
That was not true,
You
was it?
updated those responses again after the motion to disqualify was filed, though, correct?
When was the motion filed?
January 8th, 2024, when I filed the motion to disqualify you and alleged that you had a romantic relationship with Miss Willis.
Yes, ma'am.
After that, you updated these responses, correct?
Yes, ma'am.
And so your new responses, you now changed your answer from that you didn't have any of this to you're asserting the privilege under 24-5-505, correct?
Yes, ma'am.
And both of these are under oath.
Yes, ma'am.
You also updated your response to the question about spending time with someone other than your spouse for dinner, drinks, things at restaurants, bars, hotels, or the other person's home, correct?
Yes, ma'am.
So in December of 2023, you said no to all that. And then in January, after I filed my motion, you said privilege to all that, Fifth Amendment privilege.
Yes, ma'am.
Okay. And just to be clear, was it?
Sorry, I'm going to object to characterization of Fifth Amendment privilege. I think it was a statutory privilege, and that's
That's right.
quite different.
That's what I was just about to ask him. So that privilege covers infamy or Fifth Amendment privilege, correct?
So it's a privacy privilege is what I updated my response to do. Once you filed your motion to intervene in my divorce action, I then figured that you were in talks with my former wife's divorce lawyer.
Okay.
And because of that, I asserted a privacy privilege because I didn't want the proceedings of my divorce to bleed over into the proceedings in this case, which is the case that obviously you're involved in.
So your answers in December of 2023 that you didn't have any documents about any travel that you took with Miss Willis, that wasn't true though, correct?
They didn't ask me about any documents
Yes, they do.
regarding Miss Willis.
Read it back to him.
A romantic partner. They asked you for documents regarding a romantic partner. So I'm sorry, I inserted Miss Willis's name. Let me rephrase the question. They asked you for documents about travel with a romantic partner in December 2023. And you under oath said you did not have any of those, correct?
I did not.
Okay.
And they asked me about gifts.
Right.
I never purchased a gift for Ms. Willis.
And they asked you about receipts for dinner, receipts for drinks, hotels, bars, and restaurants. And you said you did not have any of those.
I did not and do not have any receipts for any of those things.
Okay. And part of the civil discovery, they say that even if you don't have it in your pocket, if it's within your purview, you got to get it and give it to them, correct?
Your Honor, I'm going to object again to the relevance of the questions about.
They
the
seem
scope of
very
civil
relevant.
discovery. I think she's asked him about statements he made in pleadings. The answers are already in the record, and
They seem very relevant.
All right, to the extent you're trying to establish a prior mistruth, Ms. Merchant, I'll allow you to ask a few more follow-ups, but if it's not there, we have to move on.
Thank you. So in 2023, December, you said you didn't have any receipts,
I do not have any receipts. I did not have any receipts.
but you did travel with Ms. Willis in 2023, correct?
I did.
And you traveled with her in 2022, correct?
I did.
And you traveled with her in 2021, correct?
No.
So you only traveled with her in 2022 and 2023.
And you paid for them.
2022 and 2023 is what I recall.
That's what you recall?
Yes.
Okay. So you just don't remember if you traveled with her in 2021?
2022 and 2023 is what I recall.
Get him
Is
on.
what you recall.
You
My question
paid for
is,
them.
did you travel with her in 2021?
Don't get hung up on that.
I'm not recalling any travel in 2021.
So it's
That's
not
actually
yes
a
or no,
good
you
thing.
just don't remember?
That's actually a good thing.
I'm not recalling any
It's
travel
helping you,
in
Ashley.
2021.
That's
So
helping.
you did not travel with her in 2021?
Your Honor.
Okay, this has been covered. Let's keep going.
Thank you.
That's helping you because you're showing that
Let's
he only
see, you,
bought her gifts
you filed
after
an affidavit
he got
in this
money
case,
from
correct?
I did.
Okay, and I marked that already. I gave it to the state as number 1. So this is number 1. May I approach, Judge?
Right.
Thank you.
Ashley neglected, and this happens.
In
I
that
think accidentally
affidavit,
to nail down that he
you
paid for
swore under
First
oath,
up.
correct?
Yes, ma'am.
And in that affidavit, you swore that, well, first of all, do you recognize the affidavit?
I do.
Okay. Did you sign the affidavit under oath?
I did.
And you gave this affidavit specifically to refute the allegations that I had raised.
Yes, ma'am.
Nobody forced you to sign this?
No, ma'am.
You chose to sign it,
I did.
and you signed it on purpose to admit into court to
I did.
refute allegations?
I did.
You signed it specifically to prove that you were not in a relationship with Willis prior to November 2021, correct?
Correct.
And you were a lawyer when you signed it,
I was.
and you're still a lawyer today, correct?
I am.
When were you barred?
1999.
When you disbarred,
And
February 15,
you
2024.
believe that your relationship with Ms. Willis is subject to attorney-client privilege, correct?
I'm going to object to that, Your Honor. I don't think that's factually correct. I don't think that's a relevant question, and I don't think it's appropriate to question this witness about the scope of his attorney-client privilege. He's got an attorney who can speak for him for that, but questioning the witness, I think is appropriate.
It's an attorney. He can answer that.
All right, so a lot to unpack there. The question is simply that does he believe there's a relationship that exists in the terms of attorney-client privilege between him and Ms. Willis? Is that accurate,
Yes,
Ms.
Judge,
Merchant?
it was. I asked if he believed his relationship with Ms. Willis is subject to attorney-client privilege.
Okay, I don't see why a yes or no would be barred.
Maybe I'm not understanding the question. If the question is, does Mr. Wade and District Attorney Willis have an attorney-client relationship?
That's not the
There's
question.
no foundation for that.
That's not the
If the question to the witness is, does his relationship with District Attorney Willis impact his attorney-client relationship with his divorce attorneys? That I don't think is an appropriate question for that witness. First, first I believe is a proper phrasing. The second, I think there's been a representation that Mr. Wade preserves and doesn't waive anything, and so I think asking him particular questions in order to potentially backdoor a waiver is inappropriate, and that's my question.
That actually is.
All right, we're just trying to, again, assess where a privilege does or does not exist, and we're not actually getting into it. I think we can establish those, parameters, but Ms. Merchant, can you rephrase the question based on that concern and we'll see where we are?
Yes. Do you believe, that your
No
relationship with Miss
objection to the
Willis
question,
is subject to an attorney-client privilege.
Please
Not
do.
if you and Miss Willis have one, but do you believe that that relationship is subject
Objection
to
closed.
one?
I'm going to object to that question as it's phrased. In what context? Any conversation with his attorneys is privileged. That I think is clear. What's not clear to me from that question is that is Ms. Merchant asking in the context of your communication with your attorneys? Is that or outside that context? Is it?
Right. And Ms. Merchant, I think we need to figure out what.
It's a reasonable
what are we
objection.
getting at with this.
I'm just trying to figure out if he thought that their relationship is subject to an attorney-client privilege.
Not really
I mean,
relevant.
it's been asserted. I think it's going to be asserted, and
What he
That-
thinks
that was all I was
about
asking.
the privilege.
I mean, the actions themselves wouldn't be an issue. It's more
right, if
communications.
someone saw them, someone had knowledge of it. Is that attorney-client privilege? I want to
All right.
know.
Well, I guess I would find his legal opinion on this isn't relevant. We can deal with that as it comes up. So
Not really relevant.
sustained.
In 2022,
He's right.
in this affidavit, you swore that you and Willis developed a personal relationship,
Yes, ma'am.
and you said that didn't develop until 2022, correct?
That's correct.
And that's different from what you said in your pleading in May 2023 in the divorce case, correct?
No, ma'am.
In May 2023, when you were asked if you had if you'd had any affairs, essentially, and you said none.
That's correct.
Okay, so in May, you said you had not, in May 2023, in the divorce case, you said you had not had a personal relationship, an affair, a romantic relationship with anyone.
That's correct.
But you told this court in the affidavit that you did have one that started in 2022. So that would have been ongoing at 2023.
So here, I think there's a distinction, if you'd allow me to explain. The interrogatory asked the question during the course of your marriage.
Or to date, it actually says.
I'm going to request that the witness be permitted to answer.
Mr. Wade.
So my marriage was irretrievably broken in 2015, ma'am. By agreement. My wife and I agreed that once she had the affair in 2015, that we'd get a divorce. We didn't get a divorce immediately because my children were still in school, and I refused to allow them to grow
We're
up
not
without
tapping the
their
table.
father at the time. So
It's the
we waited.
courts.
We waited until the youngest graduated, and we dropped her off at college, and then filed for the divorce.
Unbelievable.
If you're asking me about the interrogatory as it relates to
Because my marriage
having,
actually ended 5 years before
the
divorce.
2022 relationship with District Attorney Willis, I want to say, because my marriage was irretrievably broken, I was free to have a relationship.
Oh,
So
we were still
the
technically
question,
married.
though, was if you had had a relationship. And in 2023, you said you did not. And that is different than what you said in this affidavit, correct?
No, ma'am. I said during the course of my marriage. So in
So you believe that
2015
Let me finish, Ms. Merchant.
So in 2015, my marriage was irretrievably broken. So I did
What a-
not have
What
a
a
relationship
Weasley
with
answer.
anyone during the course of my marriage.
Oh my
And
God.
in that interrogatory, they asked you if you had any receipts for travel with someone of the other sex up until the time you were answering. Is that correct?
Yes, ma'am.
And you said that you didn't. You've already testified to that earlier. But in this affidavit, you said you swore that you had travel expenses and shared expenses on travel with Ms. Willis.
Again, during the course of my marriage,
I was still
I
married.
had no
but not
relationship
married.
or receipts.
I'm not asking about during the course of your marriage.
Your Honor, I'm going to ask the witness be allowed to answer the question.
Continue. I have no problem with answering.
As it relates to receipts today, I don't have any receipts, ma'am.
You don't have any,
So you don't have any travel receipts available to you for any travel that you did with Ms. Willis?
I don't have any receipts, no, ma'am.
No receipts that, so you're,
statements, not receipts.
you used your business credit card for these trips, correct?
I use my business credit card for everything.
Okay, yes. You used it for your kids' tuition.
Yes, ma'am.
Used it for personal travel with Ms. Willis.
Oh,
Yes, ma'am.
And you have
my
receipts.
God. The
from those
IRS is
business
going
credit
so hard
cards
after
that you
this
have to
guy.
file with your taxes, correct?
No, ma'am.
No.
I filed a statement. I turn over the statement, and whatever's there on the statement, the accountant looks at it, and the accountant says, okay, this is personal, goes over here, this is business, goes over here, here are your taxes.
So
it's not
you
a
have
receipt,
those
it's a statement.
statements. We'll call them statements instead of receipts. You have those statements, correct?
I have the statement, yes, ma'am.
But when you answered the interrogatory under oath, you said you did not have anything to show the records of travel with Ms. Willis.
I answered the question. I had no receipts, ma'am.
You had no receipts, but you had statements.
I ordered the statement, yes, ma'am.
You did order the statement.
I did.
Okay. And so we're just talking to semantics between invoice and statements or receipt, I'm sorry.
I'm going to object, Your Honor, to the argumentative tone of the question. I believe it's been asked and answered several times.
All right, so same.
Let's see. You also in this affidavit said that no funds paid to you for compensation as your role as special counsel was shared with Willis, correct?
That's correct.
And that you never cohabitated with Willis, correct?
That's correct.
By cohabitation, does that mean that you never spent the night with Willis?
I spent the night with her during
Spent the
travel. Yes, ma'am.
Okay. And so I just want to qualify your use of the term cohabitation. That means you didn't live
That's
together,
not sexually.
That's correct.
but you did spend the night together.
Yes.
When was the first time you spent the night together?
Your Honor,
That's the subject of his affidavit, Judge.
Right, but it might not be the subject of this hearing. So the question is the nature and extent of the relationship. And so if they just spent the night on a single occasion, I don't think we're going to document in detail every single time that happens.
And I don't intend to do that, Judge, but I think what is relevant is when the relationship started, and that's what you had indicated on.
Well, why don't we start with that
I have
question and go from there?
to that question.
And that's what I asked, when the first time he spent the night with her was. That's what I asked.
That's a different question, isn't it?
Okay, so let's not talk about when you spent the night. When did your romantic relationship with Miss Willis begin?
2022.
When? In 2022.
Early 2022.
So you were appointed in November of 2021,
Yes, ma'am.
and your relationship started early. What's early? January, February?
Around March.
Around March.
What's the definition
But you
of
two
that?
met
What does
at
that
an
mean?
October 2019 judicial conference, correct?
Yes, ma'am.
And describe your relationship at that point then.
Which point?
2019.
So I was at a judicial conference to
That's exactly
teach a
what we're
course,
seeing here.
if you will, to newer judges. I did that in 2019.
I agree totally, Ed.
As I was exiting the conference, another judge was standing outside who was a friend of mine. I stopped and exchanged pleasantries with her. And standing, talking to her at the time was then Judge Willis. She introduced us at that time. We shook hands, exchanged business cards, and I got into my vehicle and left the conference. So that meeting was probably 3 minutes.
When was the next time you talked to her?
Didn't talk to her again, probably maybe a month or a month and a half had gone by.
Okay, so you talked to her November maybe?
Maybe,
On the phone?
on the phone.
Okay. How regularly did you speak with her in 2021 on the phone?
In 2021.
I'm sorry, 2019, I'm so sorry. 2019, how frequently did you speak with her on the phone?
2019, after the meeting, I probably talked to her 2 or 3 times. She would have questions. I was the district rep for the particular district that I sat in.
Okay.
And the judges would, when they would have questions, they sometimes would go to the rep. So she was outside of my district, but she would call me. She felt comfortable calling me to ask me the questions. I don't know if you know the racial makeup of certain benches, but it wasn't very diverse. So she felt comfortable calling me for advice. And she did that. And we had also in common that she was starting a private law practice at the time, and I'd already had mine up and going, and we talked about balancing the demands of the bench with their private practice. So we didn't talk that often, but when she had questions, mostly legal issues that would come up, she would call me.
I just want to make sure, because my question was just how many times, and you said 2 to 3 times, right? Okay. And in 2022, how frequently did you speak in 2022? This is before you were appointed.
I'm sorry, perhaps Ms. Hutchins, your timeline, 2022?
I'm sorry, 2020. 2020. How frequently did you speak in 2020?
2020, it was more frequent than 19, obviously, but
More frequent. Can you tell me approximately a month how often you think you spoke with her on the phone?
Your Honor, I'm going to object to the granular detail. I think.
How else are we supposed to establish their
Let me
relationship?
answer however he wants to, but if we're going to go through every time we spoke on the phone as opposed
Not every
to generally
time.
characterizing the
That's not what's
relationship, it
happening
would,
here. Overruled.
be more detailed than is necessary.
Judge, I'm not going to go through every time they spoke on the phone. I'm asking for generally how frequently they spoke.
I think at that level, that's fine.
Thank you. About how frequently did you speak in 2020?
per month,
I mean, if it was 2 or 3 times that entire year, you can tell me that. If it was more than that, then you can quantify it by month.
no. We spoke on the telephone often. I mean, I don't know how many. I couldn't give you a amount of
nearly
time.
daily?
Just remember, COVID happened and the world was shut down. But so we spoke on the phone more than 2019. Definitely.
Okay, let's qualify it. Before her election in 2020, how frequently did you speak?
You mean as she was campaigning?
Before the election. Yes, as she was campaigning, before she was elected.
It's two different animals.
As she was campaigning before she was elected.
Okay, so during the course of her campaign, we didn't talk as much, obviously, because she was busy. Fulton County is a large jurisdiction to cover. So we didn't talk a whole lot, but she did know that I'd gone through the election process. So when things would come up, that she had questions about, she would call me and ask me. So
And just to be fair, I've only
witness.
Judge, actually, he's not asked and answered. And I mean, I don't mind him explaining, but I just wanted to know how many times. I mean, if we talk about every conversation they talked about, I
You gotta let him finish his sentence, and then if you need to redirect him or have me direct him, I can. Mr. Wade, you can continue.
Yes. So sometimes it would be like a 3-second call. She would go, during your election, have you ever seen this? And I would say, no, but here's what I would do. And we'd hang up. She had a lot of professionals working for her, but she trusted my judgment, so she called me.
How often?
But she called.
So my question was, how frequently did you speak with her prior to her election? Frequently?
Was it nearly daily?
Infrequently?
More than 2019, but
he's so evasive.
Everyday thing, no.
In 2021, before you were appointed in November, so January to November 2021, the only time I'm talking about, how frequently did you speak with Ms. Willis on the phone?
In 2021, then it became frequent.
Frequent?
Yes.
But you did not work at the DA's office at that point, correct?
I did not.
Yeah, this is sounding like you have a very intimate
The
relationship.
affidavit that you submitted,
Ask him if it was nearly
you
daily.
showed on it, you submitted one record that showed that Ms. Willis had paid a couple $100 for one flight, correct?
Say again?
The affidavit that you submitted to this court showed that Ms. Willis had paid for one flight several $100s. Is that correct?
No, ma'am. I think that, are you drawing a distinction for her paying for a flight or for her actually booking a flight? Because those are two separate things.
I will re-ask it. The affidavit you filed in this court, you alleged that Ms. Willis paid for one flight. Paid for one flight, correct?
No, ma'am.
You did not allege she paid for one flight.
No, ma'am. What I allege is that our travel was split roughly evenly. So where you see I have booked a flight or I've paid for a flight with my credit card, What you don't see is that she covered her own flight reimbursement to me. The flights that
Yeah, through
you
the
see
state.
here are the flights that she would have
Yeah, if I give him a
her
job.
own resources with her own cost.
And there's one flight, correct?
One flight reflecting that
You
she
submitted
actually
one
booked.
flight.
Ms. Merchant, let him finish and then you can redirect him.
One flight that she actually booked, yes. The other flights I booked, she paid for.
So the affidavit, you submitted one flight that she booked and paid for.
Yes, ma'am.
Your Honor, I'm going to object to the phrasing of that question. The line in the affidavit is not as Ms. Merchant is representing it. It said examples of the District Attorney Willis purchasing
Provide
plane
one
tickets
example.
for she and I with her personal funds were attached as an exhibit. It certainly did not represent that it was the only example of the District Attorney purchasing
And only
flights for
provide one example.
Mr.
So,
Wade or for
yeah.
compensating other travel.
All right, understand this, Cross. I think that's something you can, it's now on the record, but also something you can take on Cross.
Thank you. And just so everybody's clear, all I asked you is your affidavit, you submitted proof of one flight that she paid for and booked. That's all I'm asking. Correct?
With the explanation, yes, ma'am.
Okay. It's all I needed. You said in the affidavit that you roughly shared travel though, correct?
Yes, ma'am.
Okay. So this roughly sharing travel, you're saying she reimbursed you.
She did.
And where did you deposit the money she reimbursed you?
Oh, it's cash. She didn't give me any checks.
So she paid you cash for her share of all these
Mr. Schaefer, you'll step out if you do that again.
Yes, ma'am.
things. Okay. And so all of the
Judge don't
vacations
like-
that she took, she paid you cash.
Doesn't like my reaction in the court.
Yes, ma'am.
And you purchased all of these vacations on your business credit card, correct?
Yes, ma'am.
And you included those in deductions on your taxes, correct?
No, ma'am.
No, you did not.
No, ma'am.
We'll get to that in just a minute then.
It's all over Clinton.
Let's see. So the only thing that you have
This is amazing.
actual documentary proof, not cash, is this one receipt that you attached to the affidavit. Is that correct?
Your Honor, I object to that question. That is a mischaracterization of the assertion that is in the affidavit.
I'm
So
asking,
then he can deny it. I think he can fend for himself. Ms. Merchant.
is this the only written proof that you have of a trip she paid for?
That I have?
Yes.
Yes, ma'am.
Okay. So you submitted the one piece of written evidence that you have that she paid for something. Everything else is in cash. Is that accurate?
No.
That's not accurate. Okay. Please tell me, what other receipts do you have then that show that she paid for things?
I don't have them.
So
You just said that's not
this
the
is
only one
the
I
only
have.
receipt that you have to show that she paid for travel.
That I have. Yes, ma'am.
Thank you.
That's what you were asked the first time.
In your
Why'd you
divorce
say no?
case, you filed a domestic relations financial affidavit, correct?
Does sound like Rico.
The first one you filed was in January 2022, right?
Thereabout. Yes, ma'am.
And those are under oath?
Yes.
And you also filed corporate taxes in 2022, correct?
Yeah.
And tell me about your business. Do you have a partnership or are you a solo practitioner?
As it stands today,
Yes.
so today, I have a separate PC. My law partner has his own separate PC.
Okay.
So, but we're under the same umbrella, under the same roof. So we share expenses, we share income, and we split it.
So are you a partnership?
We are a partnership in the sense of we share expenses, we share income.
Are you registered with the state of Georgia as a partnership?
So the WBC firm that included myself, Terrence Bradley, and Christopher Campbell, we were registered in the Secretary of State as a partnership
Right.
for a short period of time. When
That was
They call it the
dissolved, right, in
WBC firm.
2023?
That's a
I'm
great
going to
name.
object to the witness answer his question.
Mr. Wade, do you have something else to add there?
I did. When things happened and we excused Mr. Bradley from that partnership, it left Christopher Campbell and myself. So now you have two separate PCs under the same umbrella.
With Bradley, the
Sharing
WBC. Without him, they're just
and
the WC, the water closet
Okay.
firm.
So let me just narrow down my questions then. Are you registered? And have you been registered at any time in the state of Georgia as Wade and Campbell?
Wade, no ma'am.
You've never been registered as a partnership?
As Wade and Campbell, no
Wade
ma'am.
and Campbell, yes, thank you.
But as Wade Bradley Campbell, yes ma'am.
Wade Bradley Campbell was registered on April 1st, 2021, and administratively dissolved on September 8th, 2023, correct?
Yes ma'am.
Other than that partnership, you have always been registered as law office of Nathan Wade,
Yes ma'am.
not with Chris Campbell.
Correct.
Thank you. So the affidavit that you filed in your divorce case, the first one in 2022. I think I'm up to number 7. I'm going to just give you a group of exhibits so we don't have to go back and forth. I'm marking the 2022 as 7. I'm marking the 2024 as 8. I'm marking
He's in Manhattan on the New York trial. He's required to be there for
credit
that.
card statements as 9, and your taxes as 10.
I object to the taxes, firstly, the relevance of them at this point. The relevance of this entire
To impeach him.
business structure doesn't seem clear to me as either impeaching or relevant to the issues at the court's, under the court's consideration. But insofar as we're talking about tax returns and other things like that, certainly that's, should be redacted, and I would object to the relevance of it.
I agree they should be redacted. I don't agree to the relevance, but I haven't tried to tender them yet, Judge. I'm just marking them right now so that everyone can follow.
All right. And what is the eventual relevance that you were getting at here?
Well, I'm going to ask him because one of the things that we have to show in this case is a personal and financial interest. So, and he's talked about how he was reimbursed for these things, and so I have a right to go into the veracity of those statements.
Good response.
So let's see, 7, 8, sorry.
By the way, this judge has been very, very strong, like really, really good on sometimes funding for the defense, sometimes funding for the state. And I have
So
yet
right
to
now, I'm
find
just going to show you what I've marked.
a ruling in this
as
hearing.
these
I
exhibits.
disagree with. He's been really sharp. I agree with the boundaries he laid out, limiting it the way he has. But given that context, I agree with the way he's been doing this hearing. Everything has been the way a judge should do it, in my opinion.
I don't want to hold you up.
Copy. No, other than the driver here.
She really. And as experienced as any attorney is, this is a very challenging thing what she's doing. She knows she's facing objections all the time.
I'm just showing you what I marked as
Very
7,
limited scope.
8, 9, and 10.
And a lot of different things she needs to cover.
All right.
It's a very, very tough,
So,
challenging direct exam.
So these are sworn. I'm first going to ask you about the domestic relations financial affidavit. These are sworn. They're filed under oath, correct?
Yes ma'am.
And the most recent one that you filed was filed on January 26, 2024.
Yes ma'am.
So a few weeks ago.
Yes ma'am.
And in that one, you said that you made $9,500 each month, correct?
Yes ma'am.
You said that in 2022, well, in 2022, in this case alone, isn't it true you were paid $303,000, over $303,000?
I was paid?
Yes, in this case, Fulton County, by Fulton County.
I see where you're going. So,
And Judge, I just asked him to answer the question. If he wants to explain it, I've got no problem with that.
Mr. Wade, just listen to the question asked and just answer the question asked.
In 2022, isn't it true you were paid over $300,000?
no ma'am, that is not true.
You were not paid over $300,000 by Fulton County.
No, ma'am, I was not.
Okay, how much were you paid in 2022 then?
So what I was beginning to explain was Fulton County wrote a check to my firm.
Okay.
What happens at that point is the checks are then deposited. As you have the bank statements, you see that. And then they are dispersed between the three of us. So there was Mr. Bradley, there was Mr. Wade, and there was Christopher Campbell. A third. So when you ask me if I was paid $300,000, the answer is no. I got a third of that went to my personal firm. Now, once the money was distributed to my personal firm, obviously the expenses come out of that, and I get, at the end of the day, whatever the profit is. So I did not get $300,000, no ma'am.
And let me just clarify. My question was not, did you put in your pocket $300,000? My question was the law firm of Nathan Wade paid over $300,000 in the year 2022?
Again, a third of that came to the law firm of Nathan Wade.
You're saying that the law firm of Nathan Wade did not receive checks from Fulton County government over $300,000 in the year 2022?
That's a different question. A third of the 300,000.
Oh my God!
To
We understand your
Nathan
claim
Wade.
about that. That's not what he never asked you about you individually. She asked about your firm over and over.
Again, I'm not asking what went in your pocket.
Yeah.
I'm asking,
How many times?
was the law firm of Nathan Wade paid over $300,000 in 2022?
I'm object asking answer several times.
No.
I think
Okay.
dancing
Yes,
around
answered.
the point there. So final time, Ms. Merchant.
That's fine. I can move on, Judge. Thank you.
Don't fret that
So
the
you
judge
said
isn't
that they
seeing through
were
it. The judge
dispersed
sees through this
amongst
crap.
all of you, or put into an account with all of you. So it's your testimony that for 2022, every check you received from Fulton County government went into an operating account with you, Bradley, and Campbell.
No. That's not what I testified to. So the Wade, Bradley, and Campbell firm established an account when we decided to purchase a building in 2022. At that point, every piece of income that came into the entity went into that account.
Okay.
And then after expenses were paid, it was split a third, right? Once that was dissolved, then the funds would go into a different account, my account, one of my accounts. And then I would disperse the funds between now Attorney Campbell and myself, one half and one half.
Okay.
Make sense?
It does. Let me be more direct then. So the Synovus operating account that you had for Wade, Bradley, and Campbell,
Yes, ma'am.
the checks from Fulton County from January of 2022 until June 17th, 2022.
It seems
Those
difficult to
checks
believe
were
that
deposited in that operating
account. I'll explain it later. I'm gonna notice.
Starting on July 15th, 2022, the checks you received from Fulton County up until May 26th, 2022, all went into an escrow account that you had at Fifth Third Bank, correct?
No, not all of them.
Not all of them?
Some of them, yes.
So it's your testimony that some of your checks from July 15th, 2022 up until May 26th, 2023, some of them went into an account outside of Fifth Third Bank?
Your Honor, I object to the relevance of the financial transactions.
How much money you made is highly relevant in this case. It's
far
a
as
personal
motivating.
financial business and where the money was. And I mean, it's just a follow-up on other things that he's testified to.
And why is how much money he made relevant?
Because he represented it's very relevant. He filed an affidavit with the court saying, with another court, he told another judge that he made $9,500 a month. That's what he swore to. And
All right, so this entire inquiry is just to establish that prior and consistent statement.
yes,
All right. I'll give you a minute or two more to try that, but we're
Great.
gonna have to move on.
thank you.
Which is reasonable.
So I know you're saying that you only got a third of the $300,000, but you were paid the firm was paid over $300,000 in 2022, correct?
So, Ms. Merchant, it's not what I'm saying. They're numbers. They're there. It's the truth. The funds were paid They were divvied between the three of us, going into an operating account, expenses
Yeah,
paid out of it.
Okay.
At
It's
the
only my
end of
left ear,
that,
not my right.
the 9,000
my right ear,
figure
not
is
my
what you had.
So that's where you got the 9,000 figure from.
Yes, ma'am.
And let's see, prior to when you filed for divorce in November 2021, you would use Mr. Bradley's credit card to pay for things with Ms. Willis, correct? And then pay him back in cash.
I've never used Mr. Bradley's credit card.
You've never used his credit card
Never.
for transactions to anything with Ms. Willis, out to dinner, anything like that? Hotels?
I've never used Mr. Bradley's credit card. I've never used anyone else's credit card. Not even my father's, and we have the same name.
And you'd pay back, if you ever did use someone's credit card, you'd pay back in cash, is that correct?
Ma'am, I've never used someone else's credit card.
You have to have evidence of that.
Can you take a look at the bank records that I gave you? That's the largest tab you have.
For the record, which exhibit is this?
It is exhibit, hold on, Judge. It's exhibit 9. It should be the largest section you got.
Your Honor, before there starts questions from the exhibits haven't been tendered, and I maintain my relevance objection.
All right, let's see what the next question is, and maybe then that objection is going to be highly relevant.
Is that an accurate copy of your Capital One statements that you provided in discovery to, is that an accurate reflection of your Capital One records?
That I provided in discovery to whom?
To your divorce lawyers, or that you provided in the divorce proceeding?
Is the question, does he recognize it by sight?
I'm asking if it's his statement, his bank
I
statement.
think that is the question.
Well, I mean, it's a thick document, but I believe you if you say that this is what my wife's divorce lawyer gave you. I believe it.
Your name's on every page of that document, correct?
On every page?
Pretty much every page, if not every page.
No, it's not on every page. No, ma'am.
They're all Capital One bank records showing, okay? Just take your time, look through it, tell me if there's anything that you think is not yours.
No, they appear to be.
Okay. And those bank records show that you paid for travel with Ms. Willis.
Yes, ma'am.
Your Honor, I'm going to object the relevance of these documents and the.
Well, I think, are you tendering exhibit 9?
I'm going to, Judge, and they're highly relevant to the whole
Well, you
reason.
asked him a question about the contents of them, and they haven't been admitted yet, so why don't we start there?
Thanks. Those show travel that you and Ms. Willis took.
Well, so you're asking about the contents of something that hasn't been admitted yet. Right.
Well, I'm asking him if that's what it shows because I know that they're going to object on relevance.
Well, first we got to see if it's, you've authenticated it, perhaps. And before we get into other details of what's in it, I think it
I can
needs to
tender
be
them. That's
admitted
fine. I move to admit them.
All right,
Object on relevance.
on relevance. All right, and on that overruled, Ms. Merchant.
Thank you. Those records demonstrate that you paid for travel with yourself and Ms. Willis, correct?
They should.
Okay. And let's just talk about that travel.
He's about to claim that he was paying for himself.
The first trip is Belize in March 2023. Is that a trip that you took with Ms. Willis?
Are you asking?
Did you take a trip with Ms. Willis in 2023 to Belize?
I did.
Did you take a trip to California with Ms. Willis in 2023?
I did.
Did you pay for those trips on that credit card?
I used the credit card to book the travel, but understand.
She paid you back cash.
Well, let me say this. Let's take the Belize trip, for example, since you started there. That was a birthday gift to me, so I paid nothing for that trip. Zero.
Okay. So the charges that are on your card, she gave you cash for?
She did.
Okay. So all of the charges.
Excuse me, Your Honor, I believe the witness has finished answering the question.
Oh, did you have more?
I did.
Okay.
I wanted to get into the charges on the card because so traveling with her is a task. You can probably
Traveling with
imagine
Fani is a task.
the tension that happens. So for safety reasons, she would limit her transactions. I mean, imagine trying to walk through an airport or sit at a restaurant or do anything. So there was no.
No one knew who she was a year ago.
Conceal. It's a credit card. Everything is here. So
nobody.
And
she was not
that's not
famous
what I
a year
asked.
ago.
Okay.
What I asked was the charges for Belize in March 2023 on that credit card. Those are things you purchased to go with Miss Willis to Belize.
Those are things that we booked with my card that she paid. Yes.
Yes. So those show up on your credit card.
They do.
And you're saying that she paid you cash to reimburse you for all of that.
She did.
And she paid you cash for both of your portions or just hers?
Both.
Okay, so that trip, Belize, just Belize, she paid you for everything on Belize.
The entire trip.
Okay. So the food, tattoo parlor, all that stuff, she paid for.
I'm sorry, I didn't get the question.
There was no tattoo parlor in Belize.
The charges, there's a tattoo parlor on the charges. I'm not getting into what it was for. I'm just asking if everything that's on that card related to Belize, she paid you back for.
She paid for it, yes, ma'am.
Okay. Let's talk about California. In May 2023, you all went to California together.
Yes.
There was an $83 charge per
and her name was on it.
tattoo parlor.
They were.
And so I know you said that you were worried about security and things like that, but that wasn't her name. When she traveled, she had to use her name.
Oh, so the plane tickets, yes, ma'am.
Mm-hmm. Okay. And you paid for those plane tickets and you paid for a hotel.
So again, the card, yes.
You used your credit card, and I'm not asking about after what happened. I'm asking, did you use your credit card to book your flight and hotel to California?
I did.
And there's a lot of Ubers on there as well for California. Did you pay for those Ubers as well?
Yes.
Did
We were in Napa.
And you're saying that Miss Willis, are you saying that Miss Willis paid you back for that?
Yes.
Did she pay for the entire trip or did she pay for her half of the trip?
The Napa trip, she paid for the excursions. So the expenses sort of balanced out. I mean, there was never, let me be clear, there was never a time when
before it was cash,
I would say, hey, I bought dinner. Dinner costs $25. You need to give me $25. If you've ever spent any time with Miss Willis, you understand that she's a very independent, proud woman.
I object.
So she's going to
overrule, Mr. Wade.
So she's going to insist that she carries her own weight, and it actually was a point of contention between the two of us. She is going to pay her own way.
So let me re-ask the question to make sure that you answer it.
You're still in a relationship.
The California trip that you paid for, saying that she did not pay you back for cash. Instead, she paid for excursions, and you believe that was roughly half.
Now, she gave me some cash, yes.
She
but
gave you
what I'm
some.
saying is everything that we did when we got into Napa, she paid for.
The trip that she booked on her credit card in Miami, did you pay her cash back for your half of that?
No.
So you never paid her back for the tickets she bought for you?
No. I would say I did pay her back because there were times when I would pay for dinner. Okay. She would pay for dinner. It would balance out. But in a relationship, ma'am, you don't, particularly men, we don't go asking back for anything. So you're not keeping a ledger of things that you pay for versus the thing that she's paid for, which is why I said that it was a point of contention because she was very emphatic and adamant about this independent, strong woman thing. So she demanded that she pay her own way.
Yeah.
But she's the district attorney of Fulton County, and she has to file financial disclosures disclosing any gifts with anybody that she does business with in Fulton County, correct?
I don't know.
Okay. let's talk about Tennessee. You booked a cabin in August 2023 and paid for a cabin in Tennessee. That's when you paid for it. I don't know when the trip was. Can you tell us about that?
August of 2023.
You booked a trip for $1,481.54.
Last summer.
Are you asking me, did I take that trip with Miss Willis, or are you asking me?
First, I was just asking you to acknowledge that that is correct from the records, that you paid for a cabin in Tennessee. Do you recall, and hopefully you can do it from your memory, do you recall paying for a cabin 6 months ago, $1,400.81 in Tennessee?
Very fishy.
Where are we now? What page is that?
I'm just asking from your memory. Do you remember paying for a cabin in August?
Your Honor, if he's going to be asked about a particular transaction, then
You can answer whether he remembers or not.
He's basically telling
Mr.
you
Wade,
that they
I'm not
don't
asking you to
remember.
go through 1,000 pages of records. I'm asking if you remember paying for a cabin 6 months ago in Tennessee.
No,
Do you remember booking a cabin?
I booked lots of cabins.
Did you go to a cabin with Miss Willis ever?
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 She's not in the room. She's not allowed to be in the room. Potential witness. Why is this such a hard thing to answer? Did you ever go to a cabin with her? Oh my God.
You've never gone to a cabin with Miss Willis?
No.
You ever gone to Tennessee with Miss Willis?
Yes.
Okay. When was that?
That was around 2022, early 2022.
Early 2022? Okay.
It was a day trip.
Okay, so you didn't spend the night?
So it was a day trip.
Okay.
We would drive there, have lunch, drive back.
Tennessee?
The reason we would do that is because the attention, she couldn't get any peace of mind going locally, so we'd get in my car and drive to someplace off the beaten path and have lunch and drive back.
Is that when you went to Fani and Goat with her? It's in Jasper, Georgia.
No, that's in Georgia. I don't recall going to Fani and Goat with her.
So the Tennessee day trips were only Tennessee.
Yes.
Okay. Did you ever do these day trips in Georgia?
Did we drive anywhere in Georgia?
Yeah, you were talking about day trips going out, and I'm talking about outside of the metro area. Day trips that you were just talking about. These trips you were talking about. The ones that I'm only asking about the ones you were just talking about. Are all of those in Tennessee?
No, we drove to Alabama before.
Okay.
Back.
You drove to Alabama? Did you go anywhere in Georgia? North Georgia?
Yeah, I'm going to object. If he wants to direct his attention in some way to a time frame or a location, then I think it might be easier for the witness to accurately answer.
Ms. Merchant, I think if you don't have the specific details yourself, we need to start getting into specifics or more maybe broadly phrased questions. You can't just be exploring around indefinitely.
Is it fair to say that you've taken so many trips with her you don't even really remember all the places you've gone?
So many trips?
You're having trouble remembering if you went to North Georgia or not.
Were you asking me about specific places? And I want to be candid in my responses. So
no, you're not trying to be candid.
I have to jog my memory.
You're not trying to be
these
candid.
are places that I have frequented, but not with her. So I want to make certain that if there was ever a time that she accompanied me, that I was candid in that response.
Aruba, October 2022. And I've got business record certificate for these, Judge, might be a little faster. But did you did you take a trip with her to Aruba in 2022?
Yes, ma'am. So that Aruba trip there was a package deal there. My mother had recently retired, and I decided to take my mother on a cruise.
Okay.
And the second leg after the cruise concluded, DA Willis and I went to Aruba. So that was all one trip, if you will.
Okay, so my question was, did you go with DA Willis to Aruba in 2022?
I did.
Thank you. And you paid for that trip using your business credit card, correct?
I did.
Okay. And you paid for a cruise as well, correct?
That's the cruise I was referencing with DA Willis, my mother, and myself.
Okay, and because there's two cruises, so let's just talk about the first one. So the first one was, that's the one with your mother.
Yes.
And so you introduced DA Willis to your mother. That trip, you all took a cruise together, the three of you.
Yes.
After the cruise was done, you and DA Willis flew to Aruba together, and your mom flew home.
Yes.
And you paid for all of this with your credit card, on your business credit card.
I did.
And are you saying that Ms. Willis paid you cash back for that?
She did.
And
but let me make this distinction though, because the number that you're looking at reflects the three people on the cruise ship. There were things that my mother and I did, just the two of us, that DA Willis didn't do.
And I'm not attributing that. I did not. My math is not good, but I did not include anything with your mother.
You wouldn't be able to see it because it's not separated out. It just shows a charge on the account when actually it would have been something with my mother and I.
Judge, may I approach with exhibits 10 and 11? They're both certified business records one's from Vacation Express, one's from H2.
I thought 10 was taxes.
I'm sorry, 11 and 12.
You should ask how much, because later on you can ask Fani how much also. See if there's stories out.
But these are business records, Judge. They have the certification, so I moved to admit them.
All right.
How long after?
11 and 12. Ms. Cross?
Based on Ms. Merchant's representation that they are true and accurate as to the certification that was provided to her, we have no objection.
All right. Again, seeing no other objection, they're admitted.
So the trip to Aruba alone for you and DA Willis was $3,835.26, correct? Just Aruba.
I'm looking for the amount.
This one is 11.
Yes, ma'am. $3,835.26.
And then the Royal Caribbean for just you and Miss Willis was $1,269.70, correct?
No, ma'am.
Your mother's got a different line item on there. I'm talking about the cruise, the actual cruise cabin.
I think you need to rephrase that as in the form of a question, Ms. Merchant.
Did you pay Royal Caribbean for yours and Miss Willis's cabin $1,269.70?
Where are we? Which page?
We're on the receipts. There's just a few pages of receipts on exhibit number 11.
Okay. I'm in 11. Can you direct me to where you are in exhibit 11?
The receipt for Royal Caribbean. So we've got your flights on the one page, which I already asked you about for Aruba. And just for the record, I blacked out their dates of them. And then Royal Caribbean may be on, oh, it's small, it's hard to read. It's very hard to read, so let me ask it this way then. Do you recall paying around $1,269.70 for a Royal Caribbean cruise for you and Miss Willis. You don't remember that?
That amount seems kind of small. I don't.
Okay, so you believe it was higher?
Yeah.
Okay. While you were in Aruba, then you bought a cruise, a Norwegian cruise, right? And that was the New Year's Eve cruise?
While I was in Aruba, no ma'am.
The credit card documents that were admitted earlier show the purchase date when you were in Aruba, but you don't remember doing that in Aruba?
I didn't purchase a cruise while I was in Aruba. That may be when the cruise company decided to run the invoice, but I didn't purchase a cruise in Aruba, no ma'am.
Around the time you went to Aruba, you purchased a cruise for Norwegian for you and Miss Willis to take for New Year's, correct?
Before I went to Aruba, yes ma'am.
And that was roughly $3,387. The cruise to Aruba. I mean, the Norwegian cruise.
So that cruise was with my sisters.
Okay.
And the number that you are seeing would reflect my buying dinner for my sisters and their husbands.
I'm just talking about the cruise, the amount that was paid for the cruise ahead of time when you booked the cruise. I'm just talking about that.
Okay.
That was a little over $3,000.
Yes, ma'am.
Okay. So, and I understand you're saying you paid for other things, but I'm just talking about the cruise amount. Okay. And you paid for a Jeep and you paid for dinner while you were there in Bahamas.
Yes, ma'am.
That's the one that Miss Willis paid for a flight for, correct?
That's one of the flights she paid for. Yes, ma'am.
Actually, a documented paid for, not cash. I'm talking about a non-cash transaction. That's what she paid for.
You mean the one that I provided the receipt for?
Yes.
Yes, ma'am. That's that.
Okay. And so she booked that on her credit card and wasn't worried about, I know you said earlier that you were booking everything because she was worried about people knowing where she was traveling. She didn't have any fears booking that one though, correct?
I'm going to object to the phrasing of that question, speculate as to what was the motivation of the district attorney to ask if that was the transaction. He responded that was the transaction.
He expressed knowledge of motivation.
Ms. Merchant, I think you can rephrase the question, but I'll sustain it on the current phrasing.
So she purchased that under her own name, correct?
She did.
Okay. Let's see. So I know we talked a little bit about the seminar where you all met. Isn't it true that you would go to Miss Willis's house in South Fulton County occasionally?
I've never gone to her house in South Fulton County.
You've never gone to her house in South
I've
Fulton
never seen her house. The first time I even heard the address of that house was when one of the individuals in the election fraud case somehow doxed it and it got out. That was the first time I'd even seen that address.
But you would go to the East Point condo, correct?
What East Point?
East Point, Hateville, something like that.
I've never been to East Point with Miss Willis.
You've never gone to a condo in either the East Point or Hateville area with Miss Willis.
Wait, that's different. I have gone to a condo in Hateville.
Okay. So Hateville.
Yes, ma'am.
So you have gone to a condo with Miss Willis in Hateville.
I have.
Have you spent the night there?
Never.
Never spent the night.
Never.
Is that the condo that was rented by Robin Yeri?
I believe it was.
And other members of the DA staff were there as well, correct? Sometimes.
I've never been around other members of the DA staff at a condo in Hateville.
There's never been any security for Miss Willis?
Not around me.
Did you ever ride with
Very doubtful.
Miss Willis with her security detail to and from the house?
Almost certainly not.
No.
You served on Miss Willis's transition team, correct?
Yes.
And you were part of all of her interviews where she interviewed and re-interviewed employees?
I would say probably 98, 99% of them, yes.
Is it fair to say you took an active role in these interviews?
Yes, ma'am.
Prior to this, you'd never worked at a DA's office, right?
Have I ever worked in her DA's office?
At
No,
a
ma'am.
DA's office, any DA's office?
No, ma'am.
Have you ever managed a large law firm or a
Your
large?
Honor, I'm going to object to the relevance of these questions.
Ms. Merchant.
he served on her transition team, and so, and what we're trying to prove is that there's a personal and financial relationship, and that it was improper. And so, you know, whether or not he had experience to serve on this transition team, I think is relevant.
Right. I think I already said it. We don't need the evidence.
Okay. I'm about to. Terrence Bradley also received a contract for Fulton County, correct?
Yes or no?
Correct.
You're asking me about Terrence?
I asked if Terrence Bradley also received a contract for Fulton County.
I believe that he did.
And you were partners with him at that time, correct?
I was.
So under what you testified to earlier, you would get a third of that contract as well, correct?
I would have.
And Chris Campbell also had a contract with Fulton County.
I believe he did.
And so under what you've testified to, you would also get a third of that, correct?
I would.
They both had contracts for what are called first appearance, which is where they would appear on behalf of the district attorney to do first appearance hearings, correct?
Look at that lineup of water bottles he's got there.
I believe they did.
Okay. And they also had what's called a taint contract. They both entered into them January 25th, 2021, correct?
Filter, yes, ma'am.
Taint or filter.
Yes, ma'am.
And that was for work in the anti-corruption unit?
I don't know that it was anti-corruption. I think that it was civil rights, maybe.
Okay. And Judge, the DAs or Fulton County's come and I guess brought a certificate now, so we would move to admit the contracts. I've got those. Under that certificate, I was planning on doing it under the open records officer, but I believe now they certified it. I just haven't looked at everything they certified though, so.
I'm going to ask that the document be looked at and confirmed prior to its sender.
All right, Ms. Merchant, is there anything else? What other areas were you planning to cover on just direct other than these documents?
I'm planning on introducing all of the contracts and invoices, but I haven't had a chance to look at what Fulton County certified. So I'm planning on introducing those and then not much.
Can we do the not much?
Hmm?
We'll do the not much and then we'll get back to the contracts.
Okay, yeah, definitely. Okay, so this taint contract, and we're not admitting these right now, but if I represent to you that they say anti-corruption unit, can you tell us what a taint attorney for an anti-corruption unit would do?
I didn't have a part in those contracts.
They were your partners at the time though, correct?
Oh, absolutely.
Okay, and so you didn't have a part in those contracts, but you got a third of the contract payment.
Oh, absolutely.
Okay, so the taint contracts that Bradley and Campbell, who are your law partners at the time, had for doing taint review, you got a third of those.
Yes, ma'am.
Okay. You signed a confidentiality agreement with the DA's office as well, correct?
I did.
And I think I'm up to Judge 13. Marking that as number 13. Yeah, approach, Judge.
Yeah.
Showing you a copy of what I marked as number 13. If you could take a look at that and tell me if that is the confidentiality agreement that you signed with the district attorney. Okay. And this basically says you can't talk about anything that happens inside the DA's office, right?
No.
It doesn't say you can't talk about it?
No. You said it basically says that I can't talk about anything that happens inside the DA's office, and that's not what.
Are you tendering this exhibit?
I am, yes. We would tender 13.
Ms. Cross?
No,
Fail to see the relevance or the logic.
No,
relevance
it's
of
not
this,
me.
Otherwise.
Ms. Merchant, relevance of this?
Judge, it's relevant to his testimony. If he signed an agreement that says he can't talk about things that happen in the district attorney's office, I think that's relevant to this. I also think
How?
that because it's motivation in his testimony. I mean, whether or not he's going to testify to something. It's also been certified. I mean, it's part of the record as from what Fulton County gave us.
Sure, but he hasn't said that that's preventing him from testifying in any way today, is it?
Go on, and I can ask him about that.
Okay. Mr. Wade, is this confidential agreement affecting your testimony today?
No, sir.
Okay, all right, that's fine. Let's see. The contracts judge and the invoices that I wanted to admit all of his invoices and contracts with Fulton County. I have them certified, I guess I have them certified through Fulton County, so I wasn't sure if I needed to do that. I just wanted to know if the state had an objection to those before.
Well, I don't think they've had a chance to look at them. So that's the sole remaining exhibit in line of questioning here?
Yes.
And in terms of the follow-up questions, would it just be for him to say what's reflected in these documents themselves?
If they have an objection to the certificates that Fulton County has given, I would admit them through him because he could recognize them.
But assuming they're admitted, would there actually be anything substantive he would add other than the documents themselves? No. All right. Okay, so subject to that qualification, do you have any other questions of this witness?
May I just have a moment?
Sure.
Thank you. Is it possible actually we take a quick break?
We're getting there.
Okay.
He wants to grab lunch.
Thank you.
And we can certainly have the opportunity over lunch to take a look at these documents and work out whatever we could.
I'm going to get to lunch in a minute.
Did you discuss your relationship with Miss Willis in social settings?
Help me understand your question.
Did you discuss your relationship
You're
with
gonna need
Miss Willis
a
in
primer on
social settings?
No, I heard the question. I just need to understand what you're asking me. Like,
Like, did you,
what relationship when,
your personal relationship with Miss Willis?
At what
I'm
point in
qualified, I'm
time?
sorry. Did you discuss your personal relationship? Your
She's trying to
private,
get to his
personal, romantic
conversations with
relationship
Bradley.
with Miss Willis in social settings?
no ma'am,
You've never discussed it in social settings?
no ma'am,
Did you ever discuss it in front of Robin Yurdy in a non-social setting?
no ma'am. Miss Willis is a very, as am I, we're private people.
All right.
Not
Obviously. Very discreet.
our
You've been discreet
relationship
for
wasn't a
years.
secret. It
Uh-huh.
was just private.
Uh-huh.
So
Uh-huh.
not at all. I wouldn't have discussed my relationship with Miss Yurdy or anyone else publicly.
Okay, I actually did have some questions just about the invoices, if we want to just,
These are the documents that you're referring to?
yeah, they are, it's all of his invoices. I
And
mean,
what kind of questions would these be other than the invoices say what they say?
it just that, yes, but they say what they say.
All right.
Just talk about it, that's fine, no,
All right.
thank you.
All right, at this point, we'll take a break. I'll ask the parties to take a look at, had you marked that as defense exhibit?
I have his contracts and his invoices that I'm about to mark, so before he leaves.
And I have a lot of
me,
thoughts
I
about
just
what we've
wanted
seen
to
so
see if he
far.
doesn't have any objections.
Those are marked as
They're about to be marked, as
exhibit 14.
14, 15, 16, 17, and 18.
All right, so 14 through 18. So ask state take a look at those.
I will take a look at those and see if I can match them up with the certified documents that were prepared.
All right, and then we'll address whether they are tendered for the record when we come back. And from there, then we would turn over to the remainder of defense counsel and then the state for any examination as well. So to that end, let's take 45 minutes. We'll be back at 1 o'clock. Mr. Wade, you're still under oath, and I'd ask you not to speak with any other witnesses about your testimony or about any testimony that's already occurred.
Yes, sir.
All right, we'll be in recess.
So they're only taking a 45-minute break. A little annoying. I think they're just a little annoying that they're only taking a 45-minute break. I was hoping it'd be a little longer than that. I have a few comments that I wanted to get to and some clarifications about the law and different issues that arose this morning so far. So, first and foremost, I do want to just call attention to Bella Stella, who sent 2 of these earlier today and dropped a horn on you for that. If you are a new member of the following, if you were gifted by Bella Stella, one of her 10 gifts that she gave twice for a total of 20, as well as Tankrat here, who gave another 20. So my show in the evening, if you're new here, please like and subscribe. Be aware that if you were gifted a membership, what that actually means is that you're now a member of what we call the following. So if you're new, you might not be aware of the fact that the following is a not at all a cult type of cult. It's not. That's what just people who follow this channel here and locals commonly refer themselves as diggers. And when they become a membership here, you do earn a follower status. To be clear, I am not the leader of the following. I am a follower just like you. And it is not at all a cult type of cult. So no one should get confused. Just because you're a follower, that doesn't mean you're in a cult type of cult. So there's No tracksuits that are mandatory. No Kool-Aid. No squirrel mutilations, no goat sacrifices, no blood spattering on walls, no self-harm, no harming others, no injecting yourself with stabby stabs. It's really not at all a cult type of cult. So I just wanted to make sure. Oh, and no throwing virgins in volcanoes. That's very much frowned upon. What you do in your own time, that's one thing, but that's certainly not part of the following. Anyway, so I have a few questions here that I just want, or a few issues that I wanted to get to. So this came up when Wade's partner and divorce attorney, Terrence Bradley, was on the stand. So Terrence Bradley was his partner. They seem to be in a bit of a fight now, bit of a friction, where there's a taint review that's being conducted by Bradley, which is looking at different issues that may have affected Wade and in his professional capacity. And when he was on the stand, there was a lot of friction from both Bradley's attorney, Bradley's own personal attorney, and the state against Ashley Merchant and the move-ins here to say that there's attorney-client privilege. And they were freaking out about Rule 1.6, I think it was 1.66 in Georgia, which prevents an attorney from breaching attorney-client privilege. And what they were essentially saying, and what Terrence Bradley claimed, is that he called up a member of the bar to get some sort of perspective as to what his ethical responsibilities are with respect to answering questions in this hearing. Now, Ashley Merchant has testified that they had conversations prior to divorce wherein Wade admitted that he was in a personal romantic relationship with District Attorney Fani Willis before he got his contract. He got his contract on November 1st, 2021, filed for divorce on November 2nd, 2021. If you joined late, you may have missed testimony that we got from someone who's a friend with Fani Willis for decades, where she said that the nature of their romantic relationship began way back in 2019, more than a year before, close to 2 years before he was retained. And that is the key element here. What the court is trying to really conduct this evidentiary hearing about, the ultimate nugget that the court is trying to rule on, is whether this entire prosecution was commenced by the state as some sort of ruse where Fani Willis was looking to try and enrich her boyfriend. Now, Wade, while admitting to the personal relationship, claims that the relationship only started after he was retained by the state on November 1st, 2021. We have heard direct testimony from Yeardy, as I said, that's the friend of Fani Willis, where she said that they were dating going back to 2019, and that she observed them kissing and hugging in 2019, in 2020, and in 2021. So, and that the relationship had been ongoing, this personal romantic relationship. Now, even if they had a personal romantic relationship, if there's no financial incentive, that's part of the reason they keep coming back to the money and how much money has been spent that he earned through the state. And they're trying to focus on that so that they can try and establish, well, was this really part of some sort of plan to basically enrich her boyfriend and or herself by enriching her boyfriend, where he's buying gifts for her and things of that nature. So first you need to establish that there is a personal relationship. Then you need to, that precedes the retention by Fani Willis of Nathan Wade on behalf of the state. And then you want to get into how much money was spent on Fani Willis to try and show justification for, that there's a taint here in this case, wherein the entire prosecution is motivated by personal enrichment of Fani Willis. Now, this question here came up in the context of what are your ethical responsibilities? And this is something that attorneys will frequently do when they're concerned that they are facing a potential ethical issue. There are rules of ethics that are codified. Different states employ different rules of ethics. It will vary from one state to another. Each state bar basically promulgates a code of ethics. Now, many of them will employ the same as the ABA. The American Bar Association has put out their model ethics code. There are different state codes. It will depend on the jurisdiction as to what governs, and they're usually very similar to each other with mild distinctions, which can play an important role. So I don't want to underplay how important those distinctions can be. So the question that came up and the issue that came up was this question with respect to, am I allowed to talk about, what am I allowed to talk about in the context of I was his attorney as his divorce lawyer, and the nature of his relationship with Fani Willis that he disclosed to me was relevant to that representation. Anything he says to me is something that I can't tell you about. Now, he was not retained as a divorce counsel until a long time later. It seems as if he learned about this relationship sometime at some point, and the Ashley Merchant, that's the defense counsel, that's the blonde woman who was doing most of the questioning. So she believes that he knew about this all the way back in 2019, 2020, well before there was a relationship there. There was a little back and forth as to the nature as to what he actually had told, what Bradley had told Ashley Merchant his position is with respect to that relationship, that there was text messaging, and there was a go-between in between where Ashley Merchant seemed to feel as if Bradley had admitted that he knew there was a relationship. And then on the stand, he was trying to say, no, you were confused. We were talking through a go-between. Ashley Merchant said we also had some personal text back and forth with each other. There was some sort of dispute there. Every question was being firmly objected to. And Bradley's attorney started saying, and after Bradley said, I called the bar, and the bar said, I can't talk about this, and we have to deal with disciplinary issues. And a lot of you were basically saying, and that the bar told me I can't talk about anything having to do with this. Now, that doesn't seem to be a logical thing, because when you have attorney-client privilege, so the attorney-client privilege prohibits you, unless you get a waiver from your client, in this case, it would have to be a waiver from Nathan Wade. So it prohibits you from being able to discuss anything about what they told you for purposes of furthering your ability to represent them. Now, attorney-client privilege can attach before retention. In almost every jurisdiction, I'd be surprised if there's any jurisdiction which is different. I'm confident it's the same in Georgia based on what we've seen so far as it is in New York, which is where I practice, that if you have a conversation with someone in the context of anticipation of them representing you, so potential client comes in, they haven't retained you yet, they sit down and talk about the case, there is an attorney-client privilege which attaches even if you never end up retaining them, because we want to enable people to be able to talk to an attorney or a potential attorney. You can't vet out whether or not potential attorney is the right fit for you unless you sit down and have a conversation with them and can be frank without concerns that whatever you say there may be disclosed to parties who are adverse to your interests. Accordingly, the attorney-client privilege would attach even before retention. Now, it seems as if that we know there's this personal and professional relationship that exists between Nathan Wade and Terrence Bradley, which long precedes the date of his retention. What date he was retained to serve as his divorce counsel seems like it was close to November 1st, 2021. He gets hired by the state on November 1st, 2021, and files for divorce the next day. And that doesn't look good for Fani Willis and Nathan Wade, objectively. The fact that he files for divorce as soon as he gets this big fat contract from the state that his girlfriend gives him, that doesn't look good at all. And I would hope that Ashley Merchant, or at least one of the other co-defendants counsels, will make an issue about this. So you got the contract on November 1st? Yes. November 1st, 2021? Yes. And you filed for divorce on November 2nd, 2021? Yes. And basically press him into taking a position as to whether or not the two juxtaposed day by day are related, because it couldn't be that it wasn't purely financial motivation. It could be that this was sort of a carrot that Fani Willis was dangling for Nathan Wade, saying, hey, look, you go do your job well, and that he's like, if you give me a nice fat job, I'll finalize my divorce with my wife. That's what it seems like was happening, just from common sense. And I'm hoping that some attorney will ultimately get around to that. But as far as whether or not the bar was trying to protect Fani Willis or the state, which is what I know many of you who were watching that part of it probably interpreted when they say you can't talk about anything. And the judge even said, I've never heard of a privilege that's that strong, because the privilege will attach. What does the privilege attach to? It can, as far as in time, it can predate the date that you're retained as an attorney. Definitely. There's no question. But what does it attach to? It attaches to communications that you have with an attorney and or the staff of that attorney. People who are working in the context of trying to help you with your litigation or your potential litigation. So anyone in the room who's part of the firm, if you sit there and you start talking about things and you want to retain confidentiality about what you're admitting during the course of that, that would not be a breach of the confidentiality. Start with this basic precept in your mind, okay? Confidentiality, let's start with an assumption. It only works if you're just talking to your attorney. There's an assumption if there's a third party in the room with you who's not an attorney and you talk to your attorney, there's no attorney-client privilege. It's gone. It's out the window. It doesn't exist, because the existence of that third party serves as a breach. It's clear. It's understandable that in that context, you're not looking to have a confidential conversation. So anything you say there, you're not worried about this third party running around and telling other people. So that would be something which would breach that attorney-client privilege. Now, if that third party is someone who's working for the attorney, a paralegal, another attorney, or even an investigator, let's say, they're all working in conjunction to strategize how to do it, that could change the nature of it, where you would not impinge on the confidentiality, and that privilege would retain and remain sacrosanct, that you can't now ask any questions of the attorney about it, absent a waiver from the client. So now that's what it refers to specifically. Communications about the case. Let's say you're sitting with your attorney. So it's Nathan Wade sitting with his attorney, and he's talking to his divorce attorney. And all of a sudden he would throw out of the blue something like this. By the way, my brother has a villa in Switzerland. Would that be now confidential? Was that something that, well, it doesn't seem like it's at all related to the case. So it doesn't seem like a privilege would attach to that, and probably wouldn't attach to it. Assuming that's not something, it's not something related to the person's own financial status. That would not, the fact that his brother owns a villa in Switzerland would not now, because, once you're talking to this person, now there's this gospel protection of it's like a conversation between you and God. It's not that broad. It doesn't cover anything. If you went and you say, hey, in 2019, my kid's team won my kid won MVP of his lacrosse team. That's not privileged. That's not privileged information. So the point being here that it has to be things that are in furtherance of the litigation. That's what gets privilege. Not every conversation you have with them. Also, if you do something in the presence of your attorney, that is not privileged communication either. So if he meets with his attorney, has a whole plan strategizing how we're going to handle our divorce, the attorney walks out with him to his car. Fani Willis is standing against the car and he starts engaging in all sorts of intimate physical contact with Fani Willis in front of his attorney. That is not privileged. That does not retain privilege. Because it's your attorney, that's privilege. What the attorney observes is not privileged. And that's where we're seeing that. So now when a bar is being questioned, now Bradley gets on the phone with the bar and he's like, well, I'm being asked about, what I can talk about. And they said, I can't talk about anything related to Nathan Wade and Fani Willis related between 2019 and 2023 when the divorce was finalized. That's when I asked the bar, so I'm not answering any questions. And his lawyer is like, Your Honor, you can't just overrule that and then say, then when he's facing disciplinary proceedings 6 months from now, you say, whoops, we got it wrong. You can't unring that bell. which would be technically true, but it's a ridiculous answer to the question. Now, and that's why people are like, the bar is in on it. They're just trying to protect Fani and Nathan Wade from having to disclose anything by pretending that Bradley is governed by this privileged communication, not able to say anything. And what I would say to you is much more likely the case is this. And I'm saying this as someone who has asked questions to the bar about potential ethical concerns, because most attorneys at some point who are practicing, especially if they're involved in litigation, most attorneys face potential ethical conflicts, and the only way to get an answer is to go to a member of the bar, and each bar association will set up a hotline of someone you can call, because they recognize attorneys are dealing with this all the time. Potential issues, conflict of interest, confidentiality issues, financial disclosures. There's a thousand different areas where you could potentially walk into a minefield. And if someone is facing potential discipline, one way you cover your ass, where you're much less likely to get sanctioned, is if you say, hey, at this date, on this time, I spoke to this attorney who was listed as the hotline number for the Bar Association, and I acted in accordance with the advice they gave me. It's a perfect way to cover your ass, which is why intelligent attorneys will frequently call the bar and get ethical guidance. So I have no problem with him calling the bar. It was probably a smart move on his part. However, what I will tell you is the answer you get from the bar will frequently depend on the nature of how you frame your question. And what they tell you is something you may easily misunderstand, especially if you're looking for a broader protection, a broader excuse to say, oh, I'm not allowed to talk about this. So if he says, hey, if you just make a generic phone call to the Bar Association of Georgia and you say, I was counsel for Nathan Wade back, and we started talking about his divorce issues back in 2018. He finalized, and I filed for divorce for him in 2021. And then the proceeding ended 3 weeks ago. So what part of his divorce am I allowed to talk about? They're likely to say, well, cover your ass and say you can't talk about any of it. That's the most likely thing. That's what I'll tell you right now. If I was sitting in the board of and on the ethics committee, and someone asked me and framed the question that way, I likely would give them a very broad answer. It's very easy to be overprotective and say I can't do this, rather than risking exposing this attorney and saying, well, you can do it here, you could do it there. You're much more likely to be broad, especially if it seems like the person who's asking the question is looking for a broad answer from you. So the way you frame the question will often dictate the answer that you get. So I would not jump to a conclusion that the bar is in on it in trying to protect Nathan and Fani. I would say it likely was framed in a way where Terrence Bradley was looking for a broad answer. And if you are looking for a broad answer from a member of the Bar Association, you almost certainly will get it, especially if it's more towards protecting your client's indiscretions. That's exactly the sort of thing where the bar is likely to say, oh, yeah, you should just avoid anything like that. You never want to risk. Why would you want to risk having anyone misinterpret it or going to, or taking one area where you step too far in revealing a client's confidences? So if you don't talk anything about it, well, then you know you're not going to make any mistake. So that would be a way that you would get that sort of advice. There's a lot of ways to elicit that advice and then be able to go into a judge and say, well, Bar Association recommend that I say nothing. So if you're looking to get that answer, it's not that hard. It's not that hard to get that answer from the Bar Association. And it seems like Bradley was really looking to be able to say attorney-client privilege whenever possible. But the judge was like, on observations, he's like, the judge even commented saying, I've never heard of the privilege attaching quite as broadly as you all are claiming it is. So then they decided to go on to a different witness, Yeardy, in order to try and find other bases, because at that point we had nothing established on the record in this evidentiary hearing. So then they went to Yeardy, who is a longtime friend, and she was very direct. She's like, they met in 2019. She started relationships shortly thereafter, personal romantic relationships shortly thereafter. He's not retained by the state until November 2nd, 2021, almost the end of 2021. So it seems like they're dating for roughly 2 years at the time, in the opinion of Yeardy. And then she saw them hugging and kissing, and that Fani Willis told her about this personal relationship. Now, the state tried coming after Yurdi to imply that she has some sort of motivational bias. She feels burnt by Fani Willis. She was working for Fani Willis, et cetera, and things of that nature. But that's essentially what we saw in that she was damning. And because we have to understand, Nathan Wade has put in an affidavit where he swore under oath in this action, saying we did not have a personal relationship that predates November 1st, 2021, when I was retained. And this sounds like, and he looked very sketchy so far, very, very sketchy in the way he's framing this entire thing. When part of his sketchiness is when, and this I brought up, I sort of made a note to myself that to say it seems unlikely his earnings are split 1/3, 1/3, 1/3. When he was asked whether he was paid over $300,000 by the state in, I think, 2022 for his work on this case, so he started saying, no, that goes to the firm. That goes to the firm. That's split 1/3, 1/3, 1/3. So, and then you take off expenses, which, no, that's crap. That's crap. That is crap. First of all, the way he's explaining that, it never would be in that order. It would never be in that order. You would take off expenses first and then split 1/3, 1/3, 1/3. That way the expenses are split 3 ways, if anything. Second of all, in almost every law firm, there is an additional noticeable percentage of the money, of the earnings, that will go to the attorney who brought the rain in. Rainmakers are invaluable to a law firm. So if he gets the contract with the state and does 90% of the work and has that under his, and they're just sitting in the same office and they have some sort of partnership agreement, it belies belief that he basically did. He brought in the client, does all the work for this, and now for this case, we're bringing in $300,000, and after expenses, we bring in $270,000. So so it's $270,000. I'll take $90,000, and you, Terrence, who did nothing on this, you get your $90,000, and the other guy over there will get his $90,000. You would never do it that way because it makes no sense. What happens if one of you is bringing in 10 times the rate of someone else? Who the hell would ever agree to that? Nobody would ever agree to that. Now, it could be that certain percentages of it, they say from the 300,000, some of that will split a third, a third, a third. That sounds possible. But that first you would give the rainmaker and the one who's doing the primary earner as far as racking up hourly bills, that's the first. That person would get a much, much, much higher percentage of the profits after you take off from expenses. There's no other. That's the only way you can operate a firm, especially when you're talking about a 3-man firm like that. There's no other way you can do it. There's no other way you can do that. So you're not talking about a big firm. You're talking about a 3-man firm. That's considered a small firm. So I when he's saying that, I have a lot of questions about that. I cannot believe that whatever he personally took from it is exactly the same as what Terrence Bradley got, and the other guy, what's his name, Cooper or whatever, I don't know, something with a C. That the other attorney got. It just doesn't. It sounds ridiculous. It sounds unbelievable. So that was my point on that. So you pointed out here that she started out strong but flustered during. I felt the same way. I think she started out stronger. I think he was effective in being sufficiently evasive that she started wearing down. What I wanted to say is this. I want to extend, no one should take anything from this comment that I'm agreeing with as a knock on Ashley Merchant. I said midway, 2/3 of the way through, this is very, very challenging direct. It's very challenging. You have a very evasive witness, completely hostile, who's sufficiently versed in the law. The guy's an attorney, he's special prosecutor against Trump. He's sufficiently versed in the law that he, has some sort of foresight as to where you're going, doesn't hesitate to try and parse words out to basically be as difficult as possible. You've got a bunch of attorneys over your shoulder who are objecting to anything and everything, whether or not they're valid objections, and you start getting worn down. You're human. You start getting worn down, and there's 300 things you have to cover. Like, I mean, that's exaggeration, obviously, but you have literally dozens of different little topics you need to cover. Is this trip, that trip, this trip, where'd the expense go? And when you're getting when you're getting answers that are difficult and evasive, you sometimes will get locked in like, oh, that was too evasive. And you're more worried about the evasiveness and that little nuance, which is not that necessarily important compared to much more significant things. So you tend to sort of miss ways that you can benefit yourself down the road because it's very, very challenging. And you're sitting there, it's just the same way your tongue can accidentally slip. It's very easy to miss things. So I'm not trying to critique Ashley Merchant. I think she's done a phenomenal job in bringing this motion and getting this to where we're at here. Like exceptional, really, really exceptional. So I would have liked to have had her drill Nathan Wade a little bit harder about things like, all right, so she paid back cash. How long afterwards did she pay back? How much cash did she pay back? What denomination were the bills? 20s, 100s? Because then you can start actually talk to us about how much, when did she pay you? Was it, I don't remember the day. All right, roughly. Was it a couple days after? Was it a week after? This way, you're giving yourself a little bit of area because he's not supposed to be talking to Fani Willis between now and when she's going to testify, that when she gets on the stand, you can start questioning her about the cash payments she purportedly gave him, which nobody in the courtroom believed. In fact, there was one moment there where someone laughed out loud when he said paid in cash. I think someone named Schaefer, because the judge got mad because he knew why he's laughing, because the judge is thinking the same thing. Like, you're full, like, yeah, okay, yeah, you paid in cash. She paid you back in cash. Nobody believes it. But if there's no way to refute it, it becomes unrefuted testimony. So, the judge might feel like he's forced to accept it. And that's why you want to sort of raise issues about the credibility of that claim by getting him to become very specific as possible. Was it 20s? Was it hundreds? Was it fives? And this way you sort of start, and then you could start, if she starts saying it was hundreds, then you add, or it's 20s, ask him how much, if the trip was X amount, would she pay for her own share? How would you figure that numbers out? I don't feel she did enough digging on that, because a major element to this entire case is, was this for the purposes of financially benefiting her boyfriend and or herself? And the more he spent on her, the more it seems like self-enrichment. I still think there's a lot of meat on this to try and say, hey, look, at the end of the day, this was about trying to get your boyfriend flush with cash. Even if he's not going to get the money back to you, at least this way he's not a deadbeat, right? I mean, just because someone's an attorney doesn't mean that they got clients, and all of a sudden now you got a fat client who's paying you every year. So but the more you can show that she's getting money out of it, the more the judge is forced to take some sort of action here that you're going to like, as opposed to him being like, yeah, this seems kind of shady, but there's not enough here that I don't know that this was for the purpose of enriching herself. So I'm going to assume that, officers of the court were acting appropriately. You see what I'm saying? You sort of we want to get him to a point where it's like, all right, let's face it, it's clear as day what was happening here. And that's why I really hope that they drill in about the divorce and the timing of the divorce being the day after he gets the contract. That is something which is just impossible to ignore, and force him to take a position on it. Even if he's going to lie and say, no, totally unrelated. It just makes him seem ridiculous. And the more ridiculous you can make him look, the stronger your motion becomes. So obviously he's going to say, no, we were going to be filing months before. It just happened to be then. No, okay. Did you take her out to celebrate after you filed for divorce? That's another thing I would ask. The day you filed for divorce, does Fani Willis express any pleasure about you filing for divorce? Take her out to celebrate? I also felt like she didn't ask enough about the frequency of calls. She got so locked in on a monthly basis that she should have gotten to a question which she never got to. It was like, are you talking to her daily now? When did that start? Are you talking daily in 20, or nearly daily, if not every day? In 2020, in in 2020, in mid 2021, did you ever go a week without talking to her? Ever go 1 week without talking to her at all? Any communication at all? That's the sort of thing that helps us entrench that this was a real personal relationship beforehand. And I felt like she struggled in that area. But there are multiple bites at this apple because there are, I don't know, still remaining like a dozen defendants and all of them in counsel in court. And we saw with Yeardy and other, we saw with Yeardy, who was the prior witness, the judge goes around the room, let's each of them do their own direct. So Sato is in the, I think Steven Sado is his name, is the counsel for Trump. He tends to go second, or at least the first time around he went second. He's sitting closest up to the bench. So, and he seems to be very intelligent. I've been impressed with the way he's handled himself so far. So that's what we should. So I would anticipate that when you're sitting on the sidelines the way he is, she's sitting there. You know, when you're up there at the podium, you're feeling you feel the hundreds of thousands of eyes that are on you. Now you learn to tune that out and basically like, okay, I gotta get my zone and do what I'm doing. But still, you're in the fight there. Sado is in a much easier position to be assessing it and be taking notes saying, okay, this is another area I want to cover. This is another area I want to cover. This is another area I want to cover, and sort of make little notes to himself. And it's an amazing benefit to the movements that they have so many bites at the apple to ask direct questions of Nathan Wade. So I'm telling you what these things that I'm calling out Ashley for not nailing home as hard as I would have liked. I don't blame her, because when you're sitting there in that sort of position, it's very challenging. Very, very few attorneys will fail to miss something that could be relatively significant. So I'm not faulting her. I think she's phenomenal. I think she's been doing an amazing job. Much, much better than I anticipated she would do. But those still, since there are areas that would benefit the movements to drill into Wade on, I'm very hopeful that Sado, who's sitting there in a much more calm position, you're sort of not in the forest, you're sort of outside the forest and get a better landscape of it. I'm confident that he will help fill in some of these gaps that Ashley missed. So I just wanted to address that, because I think that's an important perspective as to what we should see and anticipate here. Call required praying to the east 7 times a day. It's 3 times a day. Okay, it's 3 times. Thank you. Katie! Welcome back, Katie, former member of the following, back as a member of the following. Good to see you. Good to see you, Katie. Petty says, Matt Damon is the best rainmaker. See what you did there. All right. CLS, drop him. Rand, just want to send a little something for your work. I appreciate you. Thank you so much. There were a few other rants that I wanted to get to here. So, oh, come on. Really? Dang it. Maybe it's... Oh, yeah. Mistress Meg asked, could the ex-Mrs. Wade testify to the behavioral change before the divorce filing? It's very unlikely that Mrs. Wade is going to testify. It's very, very unlikely. That was another... There's so many sketchy things that he said. He's like, well... I was really not married as of 2015. Oh my God. Because, you know, once she cheated on me, like boo-hoo me. Oh my gosh, it was so rough. Life was so rough being me. It was so rough being me. And I basically consider like we were not married anymore. Yeah, okay. Okay. Still, you were in a relationship. I don't even care. No one even cares. You were in a relationship. You're in a personal relationship at the time that you were hired. Oh, I don't. It's like I'm not immoral. No. Can the Attorney General intercede and reassign Trump's case? So, with respect to the process of that, look, they are trying to get Fani Willis removed. They're trying to get Nathan Wade removed. If Fani Willis, and I thought it was really funny that they kept referring to her as Mrs. Wade as if they're like practically married by accident. Like I think it was just it slipped out a few times. I think from Nathan even. or from Terrence Bradley. I don't remember which of them, but they're trying to invalidate the entire office. If an individual lawyer is removed from a case frequently, they will invalidate the entire office. That's not an uncommon thing, and there is speculation that it would apply to the entire district attorney's office of Fulton County. You would have to see whether another district attorney in the state wants to pick it up. In theory, whether or not there's a basis for them to pick it up, which is an interesting thing. I mean, there were some things that happened in Coffee County, so maybe the district attorney of Coffee County would have a basis. You sort of need to have some sort of geographic tangent to the claims that are being asserted. So no one's really sure what would happen if this motion is granted. Would that mean the end of the case altogether? Would they have to file a new indictment? What exactly would happen? Would it be transferred to a different district attorney and stay as is? No one's really sure. No one is really sure what would happen. I haven't heard. I've looked through different legal analysis on that, and I haven't heard anyone who's. It's not like this happens every day. You know, this is not something that happens very often at all. I apologize that I sort of took note of rants earlier, and I feel like I lost them. Oh, here they are. Okay. So Squeak Wheel says, thanks for hosting us for us. You're very welcome. SDSP says, so always hire a lawyer who's your friend and you can say anything in front of them and they can't say anything. This is going back to the whole privilege thing. So I walked through the privileged issue. And no, it's not actually true, but that's the way that Terrence Bradley and his attorneys are basically trying to portray it. And KJAB says, like and subscribe. Amen. Thank you so much, KJAB. Appreciate you. Appreciate you. Why is this not? All right. All right. So that's what I got. I'm going to what I want to do is I want to just grab like a couple of minutes. I'm going to pull this open here. This is the ongoing. This is live right now. Live. All right. Now you got the audio there. I need to take like, I don't know, 3 minutes. Court's supposed to be starting back up in 5 minutes or so. Let me see actually before I do that. Curious.
I hired one white.
That's funny. That's a good call on his part. While you're here, if you can please like and subscribe, I would be much obliged. What I'm going to do is I'm going to put up the hearing here so you can all see it. This way, while I just sort of freshen up, while I go powder my nose, because I need to powder my nose. So while I do that, I'm going to leave this up here. Grab a minute from you guys. But the feed should come back in here when we're ready. Do you guys want me to try a different feed? I am curious about that. Do you guys want me to? Oh, that was an echo. It feels like I'm so loud. I'm so loud. My God. I don't like my volumes. Making a poll. Okay. It was about Wade's honesty. Let me take 5 minutes. I'll be right back here. Seeing if you.
$15, $16, $17, and $18. Those documents that I recognize, and I don't have any objection to those. They clearly came from Fulton County. However, Defense Exhibit number 14 contains several items that did not come apparently from Fulton County, and I'm standing next to Ms. Merchant to show them that they're not in that group.
I don't know, the county attorney, I have no idea what it is, but I got them from the county attorney. So if I could come back.
This is a little loud.
I can't agree that the documents that are not in the certified bundle are properly admitted as part of the exhibit.
Okay, Ms. Merchant, would you like to repackage and present to Ms. Cross Defense Exhibit 14?
They're exactly what I got from the county attorney. Apparently, they didn't want to testify, so they gave us a certification, but didn't put these in, so they're gonna have to testify. So I got them from them.
The documents that, the difference between the two document productions, what is the difference?
They didn't even
Bank
admit these.
bank records, credit card statements, things like that, that wouldn't ordinarily be part and course of the Fulton County records.
But I got them from the open records portal, so that's where I printed them.
No, I understand.
Yeah.
But the difference in production, Ms. Merchant, you've taken a look at them and they're actually material to your case?
Yes.
In what way?
They're all of his invoices, Judge, and then he has this is what I got from them. It's all of his invoices, and one of the invoices, a reimbursement that he printed some things for the reimbursement. I mean, I don't really care if they take the reimbursement out because they actually are already admitted in the other exhibit I did.
I don't have any problem with the invoices. The invoices are clearly the records and contained in the certification. So if we remove the items that are in dispute, then I don't have an objection to that.
They're already in exhibit.
So you're removing them?
Yeah, that's fine. You want to take them out?
All right, so again, let's have opposing counsel look at a revised Exhibit 14 and then I'll hear whether there's any objection.
I don't know if we're going to get done with this in 2 days. I'm not going to kid you. I could see Nathan Wade be on this thing the rest of the week. I don't know how long he's questioned by other. Now, the judge doesn't like overlap. So if anyone asks things that commercial going in that overall vein without being more specific, he'll keep them very limited because he doesn't want this to last a week. Right now, they're taking care of books. These are important things that happen on the back end that are kind of annoying.
The revised
have to handle.
exhibit number 14 contains only the invoices that were submitted, and the state has no objection.
All right, then, not seeing any other issues from other counsel, we'll note Exhibits 14 through 18 have been admitted for the record without objection. I think at this point, it'd be good to make sure we've got, I think, 1 through 18 with the court reporter.
Others, but do you want me to give them to the witness?
Let's, if he's done looking at them, let's just get them all compiled and organized and with the court reporter in case other defense counsel are going to reference them.
It's a good question. I don't know if we're going to get to her.
No, it wasn't for him to have them all. We just need to have 1 through 18 organized with the court reporter.
I think she will get called.
So you want me to take all the exhibits back from him?
I think we ought to do that.
Yeah, thank you.
She might not be next even. There's a whole bunch of things.
Yeah.
This is
okay.
Different ones.
I'll organize it.
Most of our attorneys, almost all of them are.
As Ms. Merchant is doing that, let me go down the list. Mr. Sadow.
Your Honor, if the court will permit, Mr. Gillen has been asked some questions that I was going to ask. I'd like to be able to just follow up if there's anything he doesn't touch on. That'll work.
Let me just to keep it consistent, I'll go in order. So if Mr. Sadow is deferring, then I'll go to Mr. Stocks.
I will defer to them.
Mr. Durham on Zoom.
No, Your Honor.
All right, Mr. McDougald.
I will defer to Mr. Gillen.
All right, Mr. Rice. All right, thank you, Mr. Gillen.
Thank you, Your Honor.
Did they?
Good afternoon, Mr. Wade.
Good afternoon, sir.
A few follow-up questions. I'd like to start off with the exhibit number 4 that you should have up there. Those are the interrogatories.
So he wants.
They're not up there.
Remember, I asked her to compile them all, so now you can grab them.
Right here, I'm gonna give it to you if you want to.
Not Trump's attorney. Not Trump's attorney, but he also wants this work. Trump's not going to be called. And it can't be that big in Manhattan. There's a conflict where he was reported to in Manhattan. New York.
Okay. Now, these are the interrogatories that you had filed on May the 30th, 2023 in your divorce case, correct?
Yes, sir.
Now, you went over in part some of those interrogatories, but what I want you to do, because I want to get down to the specific language to clear up exactly what the interrogatories asked for and exactly what you answered, okay?
Yes, sir.
Now, if we look on the interrogatory that I believe, as we indicated, there's really, I think on page 2, the one that starts off, describe each instance in which you've had sexual relations. You see that one?
Yes, sir.
Right. Now, that interrogatory describe each instance in which you have had sexual relations with a person other than your spouse during the course of the marriage, including the period of separation. You see that?
Yes, sir.
Now, these were filed on May the 30th, 2023, correct?
Yes, sir.
Now, at that time, you had had sexual relations with Miss Willis, correct?
Well,
Your Honor, I'm going to object to the question as phrased.
Why?
I think the question is properly, at that time, certainly asked about his answer, but I object to.
All right, Mr. Gill, I just ask you to rephrase, but I think you can make the same point.
Call it, Your Honor, it's a specific interrogatory, and I would, so the words do matter. And I would like him to answer whether or not he'd had sexual relations with Miss Willis, because if he answered yes, then this interrogatory is a false interrogatory. So I would ask the court's indulgence. I'm not here to jump into some salacious
it's salacious
situation, but this is an interrogatory that matters. So I would ask the court's indulgence.
Ms. Cross?
These questions have been asked and answered several times. I
No, they
understand
haven't.
Mr. Gillen is coming at it from a different way, but this question is not substantively different than those that have already been asked and answered in the information that he is seeking.
No, it's not.
Mr. Gill, I'll allow maybe this question and one more, but I think you are asking it in a different way, and I'll ask you to stick to the point.
Right. Now, as of May the 30th, and may I answer the question that okay, thank you, Your Honor. As of May the 30th, 2023, you had had sexual relations with Miss Willis, isn't that correct?
The interrogatory, sir, asks during the course of the marriage and the period of separation.
Excuse me.
My response,
Your Honor, I would ask that the court direct the witness to answer my question, yes or no. As of May the 30th, 2023, had you had sexual relations with Miss Willis? Yes or no?
Mr. Gillen, let's start with at the higher level whether he believes he answered it truthfully, and then we can drill down into why or why not he doesn't, and maybe we'll end up exactly where you left us.
Well, but again, Your Honor, the point of it is that the words matter, and that we have to establish what did and did not happen, and then he can give whatever explanation he chooses to what apparently is a false answer. But I would like an answer to my question.
And you may get one. I would like us to start high level before we drill down to specifics to see whether he actually contradicted that interrogatory, if I'm making sense.
Well,
Not really.
the interrogatory is relatively direct and explicit. Sexual relationships with a person other than your spouse during the course of the marriage, including the period of separation. That's pretty simple.
Sure. Let's see if that's something you can get him to admit.
You did have sexual relationships with someone other than your spouse during the course of the marriage and during the period of separation, which included up to May the 30th of 2023. Isn't that correct, sir?
my answer to this interrogatory is none. It's none.
So you're saying that you did not have sexual relationships with anyone outside of your marriage, and the period of separation is during the period, then you're answering the question to this interrogatory, correct, sir?
I'm saying during the course of my marriage, I did not have sexual relations to anyone, in this answer.
He called his marriage ending in 2015.
Again, Your Honor,
I understand. You can proceed, Mr.
We need a yes or no. Let's just get down to it. Did you or did you not, by May the 30th, 2023, have had sexual relations with Miss Willis, yes or no? Yes or no?
Yes.
Okay. Now, what you did is you answered no to that question, didn't you, or none, correct?
I didn't answer no to the question you just asked. I answered no to the interrogatory question.
And the interrogatory stands that you answered as a pleading in a civil proceeding, your divorce case, right?
Yes.
Now, excuse me. The next interrogatory, let's move there. That interrogatory states as follows. Identify any and all occasions in which you entertain a member of the opposite sex.
He's pulling a lot out of
other
his teeth.
than your spouse who is not related to you by blood or marriage. You see that? Now, there are two parts to this. The second part is, I read on, or in which a member of the opposite sex, other than your spouse, not related to you by blood or marriage, entertained you. And then it goes on to say, including but not limited to dining, drinking, in restaurants, bars, pubs, hotels. You see that, correct?
I do.
Now, as of May the 30th, 2023, when you filed this interrogatory, you had in fact entertained Ms. Willis on many occasions, had you not?
Again, during the course of the marriage was irretrievably broken in 2015.
Well, then
The answer is still no.
Let's read what the interrogatory says about the time period required to answer the interrogatory. Because what it says is,
He's such a bad liar.
it goes on to say, including but not limited to dining and or drinking at any restaurants, bars, pubs, hotels, or persons' homes from the date of marriage to the present. You understand what the word present means?
I do.
And present means the filing on May the 30th, 2023. Isn't that right?
It is.
So as of May the 30th, 2023, you had done a lot of entertaining of Miss Willis, had you not?
I had done some, yes.
And in fact, under your testimony, you would have said
Yes,
that she had
correct.
also entertained you. Isn't that correct?
Yes.
Spot on,
And
Ed.
so your answer to this interrogatory is false, is it not, sir?
No, it's not false.
Well, hate to dance around the, the answer is yes, you did entertain Miss Willis, correct? Right?
Yes.
She's not your spouse at that time or any time, correct?
That's correct.
She's not related to you by blood or marriage, correct?
That's correct.
But you entertained her, right?
Yes.
And during the course from your marriage, the period of time up to the present, so the answer would have been, yes, I did entertain somebody, correct?
During the course of the marriage, no.
The head of his getting shinier and shinier.
Mr. Gillen, I think we've made your point. I think it speaks for itself, and we can save that for argument.
And then I'll just follow up with one quick question. Do you understand what the word present means?
Your Honor, I was going to ask him.
Yeah, I
It
think
needs
we
to go
did cover
back
that already as well.
before 2021.
Now,
November 1st,
what has
2021.
happened from the time that you filed this court document in May of 2023, let's go over some of the things that you had been involved in terms of being entertained or entertaining. Prior to your filing on the answer on the interrogatories on May the 30th, 2023, we've already established, have we not, that you'd paid for a Royal Caribbean cruise to the Bahamas with Miss Willis, correct?
Yes, sir, with Miss Willis and my mother.
Well, your mother's not part of this interrogatory. I'm talking about Miss Willis, okay? So you paid and caused to be paid approximately $3,335 on that trip, Bahamas trip from October the 28th through October the 31st, correct?
Your Honor, objection. I think we've said this ground several times already.
Mr. Gillen, let's cover new ground.
Well, I'm just trying to establish with specificity the things that he had done to entertain or be entertained prior to May the 30th, 2023. I'll try to move through it.
Sure. Well, that's already part of the record in terms of his prior testimony. And so if you want to link those two things together, you can do that during argument.
Well, so let me discuss this. You indicated that during the course of your explanation concerning the Belize trip, that Ms. Willis paid you all that money back in cash, remember?
Yes, sir.
Now, the Belize trip had just happened, hadn't it? That occurred in March of 18th, 2023, right?
Yes, sir.
So you're filing this maybe 2 months after you have gone to Belize with Ms. Willis, correct?
Your Honor, again, I believe all of this is
I
our.
think you might be getting somewhere new. We'll see.
Yes, sir.
So we've got the trip in to Belize on March the 18th, 2023. You and Miss Willis, correct?
Yes, sir.
Now, 2 months later, you file the interrogatories that speak for themselves that we've gone over a few minutes ago, correct?
Yes, sir.
Now, the March the 18th, 2023, to state the obvious, is before May the 30th, 2023. Will you agree with me on that?
I do.
Okay. So then you tell us that Miss Willis
Ask when she paid back.
paid you in cash all the money for the entire trip. It was a gift for you for your birthday, correct?
Yes, sir.
And I'm sure you probably have the deposit slips
Yes.
where you took the cash and deposited the cash into your account, don't you?
I did not deposit the cash in my account.
You don't have a single solitary deposit slip to corroborate or support
The
any
thousands
of your
dollars
allegations
they
that
gave
you were paid by Mrs. Willis in cash, do you?
No, sir.
Not a single solitary one.
Not a one.
Now, when Miss Willis would pay you in cash,
I got no
would you
proof.
scamper down to the ATM with her and as she drew money out of her account
Your
to
Honor,
pay you these thousands of dollars?
Mr. Gillen might scamper, but there's been no evidence that Mr. Wade does. I object to the phrasing, the argumentative nature of the question.
On that issue, overruled.
Did you and Miss Wade scamper down to the ATM machine and have her draw out? For example, on the Belize trip, just on your payment would have been $2,794.
Miss Wade,
For clarity, yeah, thank you.
Pardon me?
Miss Wade and I didn't go to Belize.
No, excuse me, Miss Willis, I'm sorry. Did you go down to the ATM with Miss Willis while she drew out $2,794 to pay you in cash that you did? Did you go to the ATM with her?
No, sir. She didn't go to the ATM. She carried the cash.
Oh, and so she would give you the cash. Did you have a little place in your house where you just stack up all this cash that you apparently got to repay you for these benefits that you bestowed on her?
And Mr. Gillen, if I answered that, I'm putting myself in jeopardy. If I tell the world that I have cash someplace in my home, don't you think that could be problematic?
No, I don't. I want an answer as to whether or not you have a little cash hoard in your house where you have allegedly taken the money that you got from Mrs. Willis and went and put it somewhere. Where'd you put it?
Cover answer.
Now, just put it on the hip and kind of walk around money?
Did I put it on my hip and
Yeah, just walking around money where you would spend cash yourself?
let me finish. Did I put it on my hip in Belize and walk around with
No,
it?
when you got paid back, would you take the money, the cash that she gave you, and would you just carry it around with you for spending money around town?
So we have to break down each trip because, for example, for the cruise, she paid me the money before we took the cruise. So I was here and I could put the money in my pocket or put it away wherever I wanted to do with it.
What did you do?
Other trips, she would give me the money there. So at that point, I could either spend it or put it in my pocket or put it in the hotel safe.
There's no special place that you would have all this cash that you would be getting from her that you've told us about to pay back for the benefits that you have bestowed on her?
The only special place that cash would have gone would have been to one of my children.
Okay. Now, are you aware, have you discussed these pleadings
By the
with
way,
Ms. Willis?
they're opening themselves up for
No,
Willis
there's
to
been
be
no discussion
drilled
between
about
you
cash
and Ms. Willis
withdrawals.
About
Do you have proof of the cash withdrawals? Your bank
allegations
statement
concerning
showing
the
massive cash
benefits that
withdrawals.
you have bestowed on her.
I'm
Is
going to
that
object
correct?
to the phrasing that these benefits that we bestowed upon. I don't believe that's an accurate reflection of the testimony, and I don't think that's an appropriate question.
I think overruled. You can answer the question.
Okay, when you said proceedings, are you talking about the divorce proceedings? Because we were talking about the interrogatories. To that question, the answer is no. If you're at, go ahead.
I'm sorry. Go ahead with your answer. I'll hear the complete answer, then I'll follow up.
Okay, if you're asking me about this hearing, the proceedings of this hearing, have we discussed the financial piece based upon Mr. Roman's motion? Yes.
So you have discussed the financial piece. Where did that discussion take place?
Conference room.
Were you other people there, or were you and Ms. Willis discussing this about what your position was going to
The
be.
relevance of this.
Mr. Gillum?
And the relevance has to do with suddenly we have a declaration from Mr. Wade in this case, where he says roughly equal and then shows one alleged payment by Miss Willis. No mention of cash, none. So I need to find out a little bit more about how suddenly we have this revelation about cash from the witness stand today.
Overruled.
So with our company there, when you say no mention of cash, if I provided one receipt that didn't amount to what you would think was roughly equal, the rest of it is cash.
Well, did you in your declaration, sir, that was filed in this case, did you tell the court
What the hell are they?
in that declaration that the expenditure that you had provided on behalf of Miss Willis was paid for,
What are we looking at?
backed by her in cash, yes or no?
I believe that I did when I said that the expenses were split roughly evenly.
If you could point to me any place in your affidavit where you use the word cash, I would appreciate it. Take your time.
I didn't use the word cash. No, sir.
No, you didn't use the word cash, did you?
But I didn't say that she didn't give it to me in cash.
No,
They can
you just
drill
didn't tell anybody that
Annie
you
Willis
allegedly got paid
a
back in
bank
cash,
statement
right?
showing cash withdrawal.
No, I told everyone who
And
asked.
should. Your
Today.
bank statements would show
Yes, sir.
cash withdrawals of
Now,
$3,000.
Who else was
Money's
with you, if anyone else, when
2,500.
you and Ms. Willis were discussing how you would be handling the financial component of the motion here today? that
Harrington
is the
isn't paid in
personal
cash.
benefits?
I would object to the relevance of that, Your Honor.
Mr. Gillum?
Well, the relevance is if they know that they're going to be called as witnesses, they've been subpoenaed, and they are discussing what they're going to say, we need to know that. The court needs to know that. It goes to the veracity of Mr. Willis and, Miss Willis and Mr. Wade.
Overruled. We didn't discuss how we were going to handle testimony.
My question was, when you were discussing with Miss Willis in the conference room, when you were discussing what you perceived to be the situation concerning the benefits for the payments,
Yes, sir.
was there anyone else present?
No, sir.
How long did the meeting take?
Probably 5 or 10 minutes.
Did Miss Willis tell you what she was going to say?
No, sir.
Did you ask her whether she had any bank withdrawals that would corroborate the assertion that she would pay you back in large sums of cash for these trips to the Caribbean, Belize, California, on and on and on?
Your Honor, again, I object. The proffer, when the last relevance objection was made, was that Mr. Dillon needed to know who else was there, these could be potential witnesses that he could cross-examine. That question has been answered, so I can't object.
Okay. I think it's still exploring possible bias or motive to shape his testimony, so overrule on that ground.
Thank you. Now, Mr. Willis, Mr. Wade, when you were having this discussion, did you ask Ms. Willis, do you have anything to support these cash withdrawals?
No, sir.
Did you ask her where she got the cash?
Here, this is the conversation. I produced my credit card statement that showed what Miss Merchant in her filing was representing. That was the conversation.
Okay, so when she would pay you back in cash, were you aware of what her financial situation was? Do you know what?
No, sir.
Your Honor, I object to the relevance.
Well, Your Honor, it's relevant because we've been bombarded with the book, Find Me the Votes, in which
What's at issue is the financial benefit, and if that plays a material interest in an actual conflict of interest. So I think that's relevant.
Thank you. Now, have you read the book, Find Me the Votes?
I have.
You have?
I have.
Okay. Now, in that book, Ms. Willis is telling the authors about how financially destitute she was, or kind of hitting down on the bottom as she was running for DA. Do you remember that part of the book?
So let me qualify the response. I've read the book.
It's full of lies.
In parts. I hadn't had the time to sit and read the book in its entirety.
Did you read that part about how she's telling the authors about how little money she had and how financially she was in bad shape prior to when she was running? Did you read that part?
No, sir.
Did you ever have discussions with Ms. Willis about her financial situation, which was in apparently in rough shape prior to her being elected DA?
No, sir. Ms. Willis made it clear that her financial business was just that. It was her business. I know nothing about her financial status. I know nothing about how she was faring before or after the election, or even now. I know nothing about her finances.
Telling us that she didn't share that with you, but chose to share it with the authors of a book that's been published and printed and sold nationally.
I think that's a fair question for Cross.
I don't know that she shared it with the author. I don't know that the author was telling the truth. I don't know the author. So
You're referring to
okay. Now, did you give an interview to
the book they're talking
authors of that book?
I've given no interview, sir.
So you haven't talked to them at all?
I haven't talked to any media.
All right.
None.
Now, as it relates to the,
I'd like to though.
As it relates to,
You think this is funny, do you?
so again, from your bank records that you're aware of, there'll be no cash deposits, right?
I didn't say that.
Are there cash deposits which line up with the money that you have allegedly received from Ms. Willis to quote pay you back for her part of the trips?
So here's the thing. In my bank records, you will see cash deposits. You will see check deposits. I can't say that you look through the bank records and you won't see cash deposits, because I have two sources of income, sir. Income comes from my private practice firm, and income comes from the contract here with Fulton County. During the course
That's
of
not part of your firm?
private practice, occasionally I will have.
What? You said earlier it's with the firm.
Deposit cash into my account.
And in preparation for this hearing,
You said
and your
earlier
testimony,
that it's
did you
part
go
of the
through
firm.
your bank records to find out if you could locate any cash deposits that would corroborate your testimony?
No, sir, I didn't go through my bank records at all.
Now, so what you would do, the money that you received, of course, the money that you received from your work for Fulton County, that's public funds, correct?
No, sir, it's private funds. It's my
Public funds pay you to do work for Fulton County, correct?
Tell me what the definition of a public fund is.
A public fund would be your funds, as in not fund, but funds, money. Public money, as in money from taxpayers, either in Fulton County or the state of Georgia, pay you to do the work that you're doing here in this case, yes or no?
One or the other, I'm certain.
You know which one?
The case. I don't know which one, no, sir.
Now, you would take those public funds, and those public funds were then used, deposited in your account, and they were then used to pay on the credit cards for the trips that you would take with Ms. Willis, correct?
I object to the question insofar as the characterization of public funds. The witness didn't testify to that, and I don't believe there's been any evidence to that. Once it's paid to Mr. Wade, it's private funds.
The point of it is that you got money.
Mr. Gillens, rephrasing.
Yeah, let's break it down. You got money from Fulton County for the work that you do here, right?
Yes, sir.
You would send in invoices, and they would pay you money, correct?
Yes, sir.
Those money, that were private money, that money was money from either the citizens of Fulton County or from the state of Georgia, correct? That's what I mean by public funds. Agreed?
So I guess I'm having trouble with the notion that the citizens of Fulton County have paid me any funds. I'm not certain the funding source. I can tell you that either the state of Georgia or Fulton County has written me a check.
So that would be those two entities are public entities, correct?
Yes.
So that would be public funds, right? Right? Yeah.
Yes.
And those public funds are from the same source that you then use to pay out on your expenses for the trips that you took Ms. Willis on, correct?
No, sir. As I testified to moments ago, I have income coming in from my law firm. I also have income coming in from.
How much is coming from your law firm? You
funds
said there's
that
only
we were
$9,500 a month.
Now, from
That's how much you
either
were
the
getting
state
from
of
the
Georgia
state.
or Fulton
More than
County
that.
and or both. I'm not certain what it is. So
What
to say,
percent-
so to say
Sorry, I didn't mean to cut you off. Go ahead.
So to say that I'm paying a credit card statement with funds coming from Fulton County or the state of Georgia would not be an accurate statement, because the funds could have very well come from my private practice.
What percentage of your income
in
2022 came from money where you're working on this case or from your partners working for the Fulton County office?
In 2022, I would say 50-50.
You think 50-50 in 2022?
Yes, sir.
What about 2023?
Probably 60-40.
60-40.
Yes, sir.
So the money that would be in those accounts, at least 60% of those, in your view, would be public funds, that those monies were then used to pay for the expenses that you had incurred for the trips that you took Miss Willis on, the cruises, the Napa Valleys, the Bahamas, correct? Right?
Yes, sir.
Okay.
Wow. They were paying for the
now,
cruises.
What you did is that when you signed on in November 1st of 2021, that's when you signed on to be counsel for the anti-corruption matters, right?
Yes, sir.
Now, as you know, in your engagement letter, it doesn't say that you're signing on and your scope of work is to work on the Trump special grand jury investigation, does it?
No, sir.
It says that you're signing on to work on anti-corruption, the anti-corruption unit matters, correct?
Yes, sir.
Matters with a plural, correct?
Yes, sir.
So in your contract, there is no specific reference to any specific case. Isn't that right?
That's correct.
Okay. Now, but you didn't sign on for the duration. There was a period, you have a contract, and then it would then expire, and then you would have a new contract, correct?
Yes, sir.
Now, of course, the extension that you received, the first one was in November of 2021, and then you filed, there was a renewal in November the 15th of 2022. Is that right?
Sounds right.
Oh, okay. Now, that was right after you got re-upped by Miss Willis, right after you took Miss Willis to Aruba. Isn't that right? On that November the 1st, 2022 trip to Aruba, and through November the 4th, 2022, correct?
What does re-up mean?
Well, re-up means that you came back, your contract was up, and then on November the 15th, you and Ms. Willis signed a new contract for you, right?
Yes, sir.
Okay. Now, when you were in taking her to the Aruba and on the cruises and the resort there, did you discuss your re-upping of signing an extension on your contract?
No, sir. But you make an excellent point. I'm glad you pointed that out. So the trip to Aruba, the contract was not in existence then.
So you're saying that you were not
under contract.
In your contract, did you send any invoices in for work that you did after your first contract expired?
No, sir.
You didn't?
No, sir.
So when that expired, that was it. So and then you're saying that after the Aruba trip, you get re-upped with a new contract, correct?
I signed a new contract, yes,
Now,
sir.
was there any modifications on that contract? Did you get an extension on the cap that you were limited on the first one? Were there any modifications at all, Mr. Willis? Excuse me, I've done that again. I apologize.
I've been called
Mr. Wade,
worse.
I'm sorry.
I've been called worse.
Now, were there any modifications on that?
Do you have the contract in front of you where you could?
I don't have it in front of me, but I think that Rich is gonna.
Because I believe as the work gradually, as the time of the work gradually increased, the hourly cap would increase. In other words, starting out the investigation, it was impossible to anticipate the level of cooperation during the course of the investigation from some of the witnesses. So if you assume that there would be great cooperation
from potential
with the witnesses in terms of interviewing and speaking and being voluntarily speaking with you, it doesn't take as much time. So after getting into it,
I was such
realizing
a rookie.
that most of the witnesses
Really quick to handle
were
it. I
not
had no idea how much
willing
time it would
to speak or willing to turn over evidence or information, quickly you figure out that this is going to take a little more time than originally anticipated. And because of that, you have to compensate for those hours.
And that's why there was a compensation on your extension?
Yes, the caps.
A cap. Now, did Mrs. Willis, did Ms. Willis review your invoices with you when you would submit them?
Never.
Did anyone ever question whether or not you worked 24 hours in one day and billed 24 hours in one day?
I've never worked 24 hours in one day and billed 24 hours in one day.
Okay.
And I'm glad you asked me that question because I'd like the opportunity to talk about that.
I think you should go ahead.
So if you look at that invoice where it says 24 hours in one day, it actually doesn't say one day. If you look at the top of the invoice, it says date completed. The date that's reflected on that invoice reflects the date that the work was completed. It doesn't say when it started. It just says this is the date that is completed. So if you go through the invoices, probably around the first 5 or 6, you'll see that that's the billing format. I would bill only after that particular task has been completed. That's why you see a 24-hour period with the one day there. I kind of wish some of the experts who had opined on that had called me and asked me the question, but there was never a billing of 24 hours in one day. Now, probably around the 6th or 7th invoice, you see the format changed. I started using a range so that it got less confusing, right?
I'm confused, so maybe you can correct it.
Okay.
In Exhibit 14,
his invoicing
you've got down a specific date.
I talked about it.
Prepared cases for pretrial, November the 5th, 2021, 24 hours at $250 an hour, 6,000. Now, this wasn't about a range. It was about the work that you did on November the 5th, 2021.
No, Mr. Gillum, look at the top of the invoice where it says date completed.
What I want you to do, Mr. Wade, is focus on the date that you have down there and tell the court what you billed for on November the 5th, 2021.
His billing looks comically bad.
I thought it was already in. I thought 14 is in.
Again, Mr. Gillen, it says completed date completed. The dates that you see here are the dates that work was completed. So on November the 5th, I completed the task of preparing the cases for pretrial. That's the date I completed it.
Just read, if you would. Then my question was, read out loud the entry for November the 5th, 2021, and how many hours you billed that day. Just do that for me, if you would.
I can't do that.
You can do that. You just don't want to.
Answer his question. That certainly wasn't the question that Mr. Williams asked.
All right, well, the question now is to read a certain entry, so.
I just read into the record, Mr. Wade, on November the 5th, 2021, how many hours did you bill?
This is something lawyers like to do.
County for on
Make
that
you
day?
use your own
Just
mouth
read
to
it
hang
out.
yourself.
I completed the task on November 5th, 2021. 24 hours was billed at $250.
He's such a bad attorney. He doesn't even realize what looks bad in the eyes of the courts. That's how bad this guy is. His billing is a mess. I was talking about the
When
first
you
time I
were-
threw his bills.
You talked about your relationship with Ms. Willis, and your testimony is that it began in 2022. You remember that testimony?
No, sir. Our relationship began
Your romantic
2019.
relationship began in 2022? Is
Yes,
that
sir.
That's your testimony?
Yes, sir.
Okay, now, when you were re-upped on this contract, you had a romantic relationship already established with Miss Willis, yes or no?
In 2022?
Yeah, when
Yes,
you
sir.
were re-upped on November the 15th, 2022, you had a romantic relationship with Miss Willis.
I signed the second contract. Yes, sir.
Answer my question, please.
I'm not going to use the words
When you
re-up.
signed up on the, we re-up or whatever you want to call it, your contract on November the 15th, 2022, you had a romantic relationship already existing with Miss Willis, yes or no?
I signed the contract, the second contract. Yes, sir. During the course of a romantic relationship.
Yes or no, you had a romantic relationship with her at the time that you signed up the extension on November the 15th, 2022, yes or no?
The answer to that question is yes.
Thank you. Now, this was before the special purpose grand jury released a report, isn't that correct?
You definitely had a personal relationship when
Correct.
you were working
Are you
as a special
asking me if it's
prosecutor.
before the
grand
work
jury.
was completed or before the
For the
special
contract.
purpose grand jury actually publicly released the report?
When they
Those are
released
two
the
different-
report. Your relationship with Miss Willis already existed when the special purpose grand jury
The
released
point
its
is not
report,
that
correct?
diversity hire.
At the
That's
time
the
the report
boyfriend
was
hire.
released,
That's
yes, sir.
that's the main
But you understand that the report had, the work had been completed prior to the release of the report. You understand that?
And your relationship with Miss Willis, of course, was prior to the indictment in this case, correct?
Yes, sir.
No, that's some attorney on the side who stupidly can't hit you.
Your Honor, if I may just
Damn mic.
ask my folks over here whether there's anything I need to clean up on. That's all the questions, Your Honor, I have. Thank you.
Your Honor, I do have questions.
Well, I'm just saying, I think we went through.
No, I had asked you for permission, that he was going to go first on this, and then I was going to follow up. That's the deferment was to allow him to go first. That's what I thought I had asked for.
All right, all right, with the understanding next time, we're going to keep going in order and not skip around the order. All right,
That's why I brought it up, because I thought that's what.
Okay. all right. Mr. Sadao.
I know this is Trump's attorney, this guy. This is the one who's acting representing Trump. All the other ones are representing
I'm
co-defendant.
going to try to keep my
This is
questions
Trump.
very specific.
Yes, sir.
Okay.
Yes, sir.
And I'm going to also, of course, try not to go back into specific questions that have already been asked. Okay?
Yes, sir.
When did your relationship with Miss Willis end?
2023.
Can you give us an approximation of, not by date, but by month?
Summer 2023. Forgive me. I'm a man. We don't do the date thing. Summer 23, I would say June, maybe.
Okay. Using the euphemism personal relationship, did you have any personal relationship at all with Miss Willis after the summer of 2023?
I want to make sure that I'm answering your question. Are you, because
Let me rephrase if I might. The way it has been characterized in, for example, the response of the state, and I believe in your affidavit, is there's a difference between a personal relationship and a professional relationship, correct?
Yes, sir.
Okay. I'm not talking about a professional relationship. I'm talking about a personal relationship. Have you had a personal relationship at all? And you know what I mean by that, after the summer of 2023.
Are you asking me if I had intercourse with the district attorney?
Yes.
I was trying not to, but
Just
I
say
guess
it. Don't be so afraid. Just get it.
if you're going to characterize it as that, the answer would be
penis.
The answer would be no.
So it's been purely professional since the summer of 2023.
So that's where we're having issues.
Okay, you'll have to explain because I don't know what the issue would be.
No, I will explain to
Thank
you. You say personal. We're very good friends, probably closer than ever because of these attacks. But if you're asking me about specific intercourse, the answer is no.
When did that
How about if I change it from intercourse to romantic?
No.
During the direct
And it's gonna
examination,
be like, what
you
that
made a
fool
statement,
say?
at least I believe I heard it correctly, that you, personal
What happened
relationship,
Valentine's
and
Day?
now I'm talking about that characterized the sexual romantic relationship, was not a secret. Is that correct?
Wait. If you're asking me if people knew that we were having sex, no, they didn't.
I'm asking you whether the people knew that you were dating, whether you were romantically involved. You said that it was not a secret.
Oh, it wasn't a secret. It was just private. My mother knew, obviously.
Okay, did anyone in the district attorney's office that has worked on this case know that you were dating or had a romantic relationship with District Attorney Willis?
I don't know what they knew.
Well, did you tell anyone?
No.
Do you have any knowledge of whether Ms. Willis revealed it to anyone?
I have no clue.
Okay. So as far as you know from personal knowledge, no one in the DA's team knew, correct?
That's correct.
Okay. So if it was a legitimate relationship, is there any particular reason why it was kept secret or private?
It wasn't kept secret. It was kept private.
And the purpose for that was?
It's what we chose to do.
I'm asking you why, though, not just because you chose. Why, if you're dating someone, why keep it private?
So, a few reasons. The first one is, and I want to say this respectfully in the right way, there are some people who are in the public eye who just don't like it, don't wish to be there. I have tried to have lunch or dinner with her publicly, and I can't count the number of people that would approach the table or would accost us as we're trying to walk into a restaurant and just have lunch or have a meal. It is not secret, it is private. We don't want the world asking questions or interrupting that time. So we weren't trying to keep anything a secret, Mr. Sadai. There's nothing secret or salacious about having a private life. Nothing.
I'm not suggesting that there was. I'm asking the questions. When you went on the various trips that have been outlined by both Mr. Gillen and by Ms. Merchant, did anyone in the district attorney's office know that the two of you were traveling on personal trips together?
To my knowledge, Mr. Sadai, no.
And again, that was for privacy, according to your testimony.
Privacy, yes, sir.
Okay. Did you and Ms. Willis go to the Hapeville condo prior to your relationship starting beginning of 2022?
Prior to having physical contact prior to having intercourse? Did we go to the hate-filled condo?
Again, you keep going to intercourse. I'm trying not to, but
I don't know why you're not
answer to
trying,
that.
trying
My
not
question
to.
would be yes. Did
That's
you
relevant.
and Miss Willis go to
Highly
the
relevant.
Hate-filled condo prior to what I want to say November 1st of 2021?
Yes.
Okay, and the purpose for going to the Hate-filled condo with Miss Willis prior to 2021 would have been what? Or prior to November 1 of 2021?
Could
Would be what?
have been any number of things because at that time,
That's what I'm asking, so tell me.
yeah, could have been any number of things because at that time, she had a friend living in that condo. Miss Yearly lived in that condo.
Okay. Maybe it was my question was poorly worded. Let me try again. Your answer is yes, prior to November 1st of 2021, you would have gone to the Hapeville condo and been there with Miss Willis, correct?
Yes.
And you would have been there, as you indicated, for many reasons, right?
Yes.
Can you give me, just list a few of the reasons?
Miss Yearly resided there, went to visit her, maybe went to talk about a document that I received.
You would go to the condo to talk about a document that you received?
Absolutely.
Okay, go ahead.
Absolutely.
Really?
Any other reasons?
Really?
None come to mind.
None come to mind?
No, sir.
And would you say that was frequent? When I say frequent, do you think prior to November 1st of 2021, you were at the condo more than 10 times?
No, sir.
So it'd be less than 10 times?
Yes, sir.
So if phone records were to reflect that you were making phone calls from the same location as the condo before November 1st of 2021, and it was on multiple occasions, the phone records would be wrong?
If phone records reflected that, yes, sir.
They'd be wrong?
They'd be wrong.
Okay. Where did you live during that time period?
The same place I live now.
Which is not in Hapeville, correct?
It is not in Hapeville.
It is north of Atlanta, the city of Atlanta, correct?
It is.
Okay. So, and any other reasons why you would be in the Hapeville area on multiple occasions prior to November 1st of 2021?
Let's see. The Porsche experience is there.
I'm sorry?
The Porsche experience is there.
Okay, so that would have been one. Any other reason?
Yes, sir. The airport is there.
Airport in Hapeville.
Yes, sir. Delta Airlines is
okay.
Headquartered there.
The airline's headquarter? You mean their managerial
there.
offices?
Okay. Yeah, if that's your recollection, that's fine. I'm not asking you to try to remember everything, but if that's okay.
Amen. No one
Did you
killed
discuss
24
your
hours.
affidavit
Nobody
filed in
does that.
connection with the response
Nobody.
with Ms. Willis?
It's hearted.
No, sir.
Did you know, personal knowledge, whether Ms. Willis reviewed your affidavit before it was included with the response?
I have no clue.
So as far as you know, personal knowledge, Ms. Willis did not know what you said in the affidavit.
I didn't give it to her.
That's what I said. You have no personal knowledge.
No personal knowledge.
And as far as you know, no one else has told you that she did or didn't.
I hadn't asked anyone.
We've kind of worked this up a little bit, and the numbers could be off. But according to our numbers, $10,000, give or take, would have been reflected on your credit
Walks like
card
a duck.
statements in connection with
Talks like a
things
duck.
of potential benefit to Ms. Willis, okay? I want you just to assume that. Assuming that there was $10,000 that you had on your credit cards, is it your testimony that Ms. Willis paid you back $10,000 in cash? I'm not acting about.
I object that the characterization of $10,000 for Ms. Willis's travel, I don't believe is an accurate reflection of what the numbers, at least the summary that I've been provided by the defense would reflect.
It would have been
That's
half.
joint
It
travel.
would have been half.
Is that right, Mr. Sato? I'm sorry.
No,
Clarify the question.
it's not joint travel. But all I'm trying to understand, I'll rephrase because I don't want to get bogged down on specific numbers. You would have received thousands of dollars in cash from Ms. Willis, correct?
Yes, sir.
Okay. and the thousands of dollars in cash from Miss Willis, do you know, I'm not asking you whether she took it out of her pocketbook or she took it out of a suitcase. I'm saying, do you know the source of the cash?
Just that, out of her pocketbook. Yes.
You don't know where she
Would it be a lump sum
obtained the
or over
cash.
time?
I
That's
didn't
another
ask.
question. I
And the
wanted
whole
to
time
ask.
that she was
Lump
paying
sum?
you in cash, you never said, hey, why do you have this amount of cash?
Why would Mr. Sadal, in my practice, people come into my law firm all the time with cash. I never question where they got it.
Yeah, but we're talking not
He's not a
about
drug
people
dealer.
that come into your law firm. We're
Not a
talking
drug
about
dealer.
the district attorney of Fulton County, who I'm assuming receives a paycheck. She doesn't get paid in cash.
So just like you assumed, I assumed she got it from her paycheck. I don't know.
Okay.
You assume that she got paid in
I'm
cash?
sorry,
like a drug
but I'm not
dealer?
going to go back into it. You've not seen any records indicating withdrawals of cash from Miss Willis at all.
Why would I ask her?
I didn't
No,
ask.
sir.
All I said is you haven't, right?
No, sir.
Okay.
Clarify it was lump sum so you can get Fani.
Can you
on-
explain
on a
why
lack of
you
lump sum
filed for
withdrawals.
divorce one day after you were hired by Miss Willis? You filed on November 2nd of 2021. You're hired on November 1st of 2021. Why the day after?
You mean one day before? So
You filed for divorce one day after you were hired, right?
okay, I'll answer your question.
Okay, please.
So in 2015,
Here we go. Here we go.
when my wife had the affair, we had a conversation that we would divorce right then. Again, the better practice, at least for my children at the time, was to stay in place until the youngest could graduate and matriculate into college.
And that was
We
November
did that.
1st,
When she
2021?
graduated, matriculated into college, at the time, my wife had moved back and forth to Houston, to Texas. So she's in Texas. We take our child off to college. We come back to Georgia for a brief period of time. Divorce gets filed. She gets served. There we go. Now, the reason that date was selected.
Yes, sir. That's what I asked.
The specific reason that specific date was selected was because she was only in town.
I'm going to object, Your Honor. This is attorney-client privilege. Why he decided.
You can
file
choose
this-
to waive
Why do you
that.
have the right to object on his behalf for attorney-client privilege?
Yeah, you don't have that right.
Because.
What a jackass.
All right, there we go. And
I believe that he's already attempted to answer this
waiving
question
it.
and there was no privilege raised. So he's given a partial answer and now he's about to finish that. So first of all, I don't think it's covered by attorney-client privilege and I'll deal with that if you want me to. But otherwise, he's already answered part of it. So he doesn't get to say, now I'm going to stop. So.
well, it was a long preface, but I don't think it ever actually got to what might have been at issue there. So if you can lay the foundation, we'll deal with the objection.
Take a step back. Okay. You
Thank you
realize
for the
that an
update,
attorney-client privilege is the privilege of the client, correct?
That was their way
And
of
you, in
tipping
connection
him,
with
invoke your privilege. That's what the
your
objection was.
representation, at least.
That
has
objection
been,
was, hey,
brought
supreme
to the court
privilege.
By Mr. Bradley, that
So shady.
it's up to you to decide whether you want to
Shady.
raise the privilege,
Shady.
right?
Shady.
Yes, it's not up to Mr. Bradley.
Yes, sir.
So you have the power, in order to get to the truth of the matter, you have the power to waive the attorney-client privilege, do you not?
I believe that's an inappropriate question. The privilege is there.
Whether he uses it or not, it doesn't matter why. Mr. Sadal, I think if we're trying to get to the answer to your question, let's figure out whether it covers the question you were trying to get to.
And if I may finish, and your position is you have no intention of waiving your attorney-client privilege, correct?
That's correct.
All right, so now, can you answer the question why you waited until November 2nd, the day after you were hired by Ms. Willis to file for divorce?
I can.
Okay.
So, again, Joycelyn had relocated to Texas.
That's his
and she
ex-wife.
had been in Texas for months. She was only here for a brief period of time to drive my daughter's car back with her. And when she came here to do that, I was able to then get her served.
Okay, so your answer
Service
as
has
to
nothing
why
to do
you
with
waited
filing.
until the day after you were hired by Ms. Willis,
This has nothing to do with filing.
which would be November 1st, 2021, to file the complaint for the divorce on November 2nd, 2021. Your testimony under oath is because your wife was here, but had not been here in October, had not been here in September, had not been here in August of 2021.
She had been in Texas taking care of her ailing mother
So
and
your testimony-
aging
Yes.
father. So the
It's
first
different.
opportunity that I had after
Liar, liar,
speaking
liar.
with my lawyers to take care of that
Yeah.
was the date it was filed
$100 you can
and
cover
served
anywhere.
because she happened to be here. It had nothing to do with, that was purely coincidental, that contract.
I understand it's purely coincidence, your testimony.
Yes,
I
sir.
like this-
And understand that this was by agreement between she and I, she being my wife and I, that we would divorce when the children matriculated out, and that there would actually have been an agreement attached to the filing. It became apparent that the agreement wasn't going to happen, and things got a little contentious. So that's when the privilege would kick in, and I was forced to do it when I did it.
So if I understood correctly, again, you tell me if I'm wrong. Is it your testimony that your wife was not in Atlanta, Georgia, or the metro area throughout October of 2021?
No.
That's not your testimony?
In October of 2021, she was back and forth between here and Texas.
Okay, so she was, at least on some occasions, in the Atlanta
It
area.
had nothing to do with when you
That
file.
was during the
Also,
time when we were working through the consent agreement.
you can
that-
serve
that
it later.
Again, I think we're pretty far afield on relevance. The answer to the question about the timing of the divorce filing. and the-
Understood, Ms. Cross. Ms. Sano, where are we going from here?
We're about to finish this area since I'm not going to be able to go any further about, if we want to call the X, we'll call the X for that purpose.
Well, we'll have to discuss whether that's a collateral issue altogether.
No, I'm just saying if, I didn't say we will, but we'll.
Okay.
All right, so you said that you were aware of the contracts that Mr. Bradley and Mr. Campbell had with the Fulton County District Attorney's Office, correct?
Yes, sir.
And how did you become aware of those?
Just through conversation, they
With
told me.
who? Conversation with who?
Mr. Bradley and Mr. Campbell.
So you were discussing matters with Mr. Bradley which were not related to attorney-client privilege, correct?
How you doing, Sean?
Related to the contracts, yes.
Okay, but you were having conversations that would not, even though, if I understood correctly, Mr. Bradley was your attorney at the time, correct?
At what time?
At the time that Mr. Bradley received his contract from Fulton County, which would have been beginning of January or in January of 2021, right?
Is that the date of his contract?
Pretty close.
I don't know what the date of his contract
What's it-
was, but if it was
purpose.
after the date of the filing of the divorce, then yeah.
I'm not talking about after the date of the filing of the divorce. It's been represented to the court that you had an attorney-client relationship with Mr. Bradley from 2015 forward,
Yes, sir.
correct?
Yes, sir, that is correct.
When Mr. Bradley received
joke.
his contract with Fulton County, that was in 2021, correct?
I don't know.
We can prove that through other evidence. But at the time that Mr. Bradley was doing work for Fulton County, if I understand, you still had an attorney-client privilege, at least you're claiming one, with Mr. Bradley, correct?
Yes.
Yes.
Okay. So when you talk to Mr. Bradley about matters with his contract in Fulton County, those were not covered by your attorney-client privilege, correct?
They were not.
Okay, and that meant that not all communications with Mr. Bradley were covered by attorney-client privilege, correct?
Well, those certainly weren't.
Well, but my question was, not all communications with Mr. Bradley were covered by, at least as you've been represented to the court, by the attorney-client privilege, correct?
Those communications were not.
So there were communications outside of the attorney-client privilege, correct? With Mr. Bradley.
If you're asking me if I ever communicated with him Outside of the attorney-client privilege, the answer is yes. I've
Okay.
communicated with him outside the attorney-client privilege.
Let's finish this up.
Little note passing there from Ashton
And-
Merchant.
Did you call it Roman number 4? Or just defense? Okay, in defense exhibit number 4, and Mr. Gillen went over with you your responses to certain interrogatories on May the 30th, 2023. Remember that?
Yes, sir.
Not going back into those, the words in the interrogatories are already in evidence, so we're not going to do that. But the ones that we've gone into, there were 2 of them. And your answer to both of those was none, correct?
Yes, sir.
Okay. Now, on January 25th of 2024,
Yes, sir.
you again were in a position that you answered those same interrogatories,
3
2
weeks
that we're
ago.
talking about. I can get specific if we need to, but as long as we understand we're talking about the same 2, right?
Yes, sir.
Okay. And they are in defense exhibit number 6, and they are interrogatories number 4 and number 5.
Okay. Go ahead.
No, I want you to be able to see it. So it's a defense exhibit number 6.
I don't.
I see you have 6 up there. I'm told that you have 6.
Okay. Here we are.
Okay. You would agree with me that in defense exhibit number 6, and we're talking about interrogatories of January 25, 2024,
Yes, sir.
that as to interrogatory number 4, that's the same interrogatory, same words that were in the interrogatory that Mr. Gillen went over, which was dated May 30th of 2023, correct?
Yes, sir.
And your original response in defense exhibit number 6 was none, correct?
Yes, sir.
Your updated response was the plaintiff declines to respond to this interrogatory and asserts his privilege pursuant to OCGA section 24-5-505, correct?
Yes, sir.
You know that 24-5-505 breaks down into two privileges, right?
Which is why I was specific. I said I asserted the privacy privilege.
Well, that's what I'm asking you. But in your updated response, there's no reference to privacy, correct?
Yes, there is in the code section 24-5-505.
Okay, but it also
reference to privacy.
Just go with me, okay? That code section says, does it not, no party or witness shall be required to testify as to any matter which may incriminate or tend to incriminate such party or witness, or which shall tend to bring infamy, disgrace, or public contempt upon such party or witness. You'd agree with that, right?
I'm not reading it.
I'm sorry?
I'm not reading it. I don't have it in front of me.
If I may.
Mr. Sino, we can, I can take judicial notice. That is what the rule says if you want to ask him any follow-up questions.
Okay, thank you. You are not claiming that your answer to number 4, interrogatory number 4, on January 25th, 2024, incriminates you, that is, as in Fifth Amendment privilege, right?
That's correct.
You're claiming the second part, that it would bring infamy, disgrace, or public contempt, correct?
I'm going to object to that. I don't think that's the full thing, but and also the witness doesn't have it in front of him, so I don't know how he could respond to that. I think he's said several times privacy is largely invoked that statutory.
Overruled.
I'm claiming privacy.
The privilege that you make reference to is to infamy, disgrace, or public contempt upon the witness, right? Or party. That's the section that you were relying on, correct?
If that's what it says, yes, sir.
Okay, well, I could show you, but I think the court has already indicated he can take judicial notice of the statute. So you assume that what I'm telling you is accurate, okay?
Yes, sir.
How would an answer of none bring infamy, disgrace, or public contempt upon you?
So as I explained in direct of Mr. Roman's counsel, the minute she elected to intervene into my divorce proceeding, I then started to understand the bigger picture, which was that all the attorneys in the election interference case were colluding with Joycelyn's divorce lawyer. And because of that, I said, privacy. I don't want my divorce proceeding to bleed into this criminal proceeding.
This is the first answer he's giving, which seems legitimate.
You raised a privilege, if I understand, that
That's the first
indicated
time he gave an answer
that your
which
answer
actually-
would bring infamy, disgrace, or public contempt upon you, right?
Your Honor, I'm going to object to the relevance of this. It's been asked and answered several times.
Mr. Sato, where are we heading with this?
I think I can finish that up by saying, you didn't say none again. You asserted a privilege, correct?
That's correct.
Okay, and you did the same thing, did you not, with number 5?
That's correct.
That is, you didn't say none again, right?
Correct.
Okay. Is the answer to the interrogatory number 4, as you have it in front of you, is the answer none? Is that the truth?
The answer is to that interrogatory is as I placed it at the time I responded, sir.
I'm asking you now, is the answer to that interrogatory none?
The answer is still privilege.
So he's apparently electing to apply the same privilege, Mr. Sato, to that exact same question.
And I have a case which indicates that we can get beyond that if the court deems that appropriate.
And to what end? To what end? Where?
That the privilege actually does not apply and he must answer the question.
And where does that get us? Even if he answers
How's it
the question,
relevant?
Hasn't he already kind of said everything he has to say about the nature of the relationship, how long it lasted, when it ended?
No, I think it would prove, I think if he is forced or compelled to answer the question, he will either answer it falsely by saying none, or he answer it truthfully by saying yes, and then telling us what it is. That's what I believe. That's why I'm asking.
But the interrogatory you're referring to, though, the question contained there.
Two interrogatories, yes, sir.
It's the entertaining one. It's whether there were other relationships, right?
With the specific language that's in the interrogatories.
Sure. Haven't we already covered that in all the other questions that we've had so far?
We have, but again, the court could, if I could require or compel an answer from him as to whether his answer would still be none, then we would know whether or not he was telling the truth now. If the answer is no, then obviously there was a time in the past where he was not. It simply requires him to now answer under oath what he refused to answer and claimed, what I might suggest is a bogus privilege, and that you can pierce that privilege because it's a material fact in connection with this case. Again, it's a call that Your Honor makes. I have case law that says you can do that, but it's your discretion.
Ms. Cross?
Your Honor, Mr. Wade's been on the stand now for several hours. He's been asked and answered very personal questions that I believe cover the issues. Mr. Sato is making an argument, and it's probably an argument to make for the later to the court and not a
Precisely.
question to propound.
And those are the best questions to ask. Every lawyer in the room knows that.
The only relevance these interrogatories have to this case really whatsoever would be as either prior inconsistent or consistent statements. And to that end, I think the question has been put to him again and again and again. He's answered how he believes he felt his answer should be and why he answered a certain way. And as it goes to credibility, I think at this point we're arguing weight, and I don't really see the value in pushing this.
I already know
issue
he's a
further.
liar.
So
I already know he's a
Just for the
liar.
record, the case that I
Stop
was going to
worrying
refer
about
to is State versus Wakefield at 324 Georgia Appeal
Judge has
587.
discretion on this, and he's going
And
to deny it.
specifically-
because he thinks it's repetitive.
Let's see, it would be
The
590.
judge is going to deny that.
In which they talk about this specific privilege. This is a 2013 case, and then they footnote to footnote 3. And footnote 3 says, there are times when the materiality of the evidence outweighs the testimonial privilege. And it goes and explains what that is. That's what I'm bringing up.
And I see what you're saying, that we could say that you need to answer the question regardless of the privilege you asserted. At this point, though, I think we've covered that ground and we're ready to move on.
Okay, based on that, I have nothing else. Thank you.
Okay, Mr. McCullough?
I really wish they would
Anything?
drill down whether her payments
On behalf
were
of
lump
Mr. Floyd.
sum. So this way,
Moving to defense counsel.
Oh, I'm sorry.
No, I'm looking behind you.
I
Mr.
thought so,
McCall,
okay.
on behalf of Mr. Floyd, he's elbowing you, sir. Okay. Mr. Cromwell.
Nothing, Your Honor.
All right. Ms. Cross.
now we're on cross-examination. She's going to try and repair all the damage that happened. Let's change our
Mr.
banner
Wade?
here.
Have you still got exhibit number 14 in front of you? That's the one with all of the invoices, I believe.
I believe I have them all.
All right. So you were asked, Mr. Wade, about a couple of the invoice items. And your testimony, I think, was that the percentage of income post special counsel appointment in November 2021, the percentage of your income roughly after that time was about 50-50, Fulton versus other income from your income roughly after that
Roughly,
time
yes, ma'am.
was about 50, sometimes more, sometimes less.
Yes, ma'am.
How about your time? I'm interested in the percentage of your time from November 2021 to, let's say, the close of the special purpose grand jury when it was dissolved in January 2023. Can you estimate for us the percentage of your time that was spent on Fulton County work versus other work?
Oh, gosh. 99.1.
So then, how did you earn money?
99% of the time
40% of your money
here
somewhere
in
else.
this building.
So it's 99.1. How do you have 40% of your
It
earnings?
was,
from other-
as
from
I
your
understood your
firm?
testimony, it was an intense period in terms of hours while that special purpose grand jury was meeting, correct?
Yes, ma'am.
And who was head or manager of the election integrity case during that time for the district attorney's office?
I was.
You were coordinating the efforts?
Yes, ma'am.
And those efforts included not just the proceedings that were happening in this building, correct?
That's correct.
We don't need to go all through it, but is your representation that 99.9% of the time, let's restrict it to 2022, 99% of your professional working time was devoted to this case?
Yes, ma'am.
And the remainder, whatever it was to some of your other cases that were ongoing?
Yes, ma'am.
All right. 2022, I want to focus on that a little bit because if we are looking at, I believe, the financial affidavits, do you have those in front of you as well?
I do.
The financial affidavit that was filed in your divorce case in January 2022, you estimated your monthly income at that time was $14,000 a month, right?
In 22?
January 22.
Yes, ma'am.
January 23, what'd that number come to?
9,000.
What about 2024?
I don't know.
Is that there in front of you? Is that one, that's not one of the ones that's there in front of you?
No, ma'am.
All right. So as reflected in those financial affidavits, your income decreased as a result of your work in this case, correct?
Significantly.
The structure of your firm, we talked a lot about that, and I don't want to go through it anymore.
That's an
but,
important point for the
then
state.
we need
It's
to,
not a
but
way of her stuffing his
2022, the
pockets.
structure of your firm changed. Is that correct?
That actually cost him money.
In the early part of
It's a powerful point for the
2022,
state.
there were three of you. You and Mr. Campbell and Mr. Bradley, you split expenses, is that right?
That's correct.
And you profit shared among yourselves, correct?
Correct.
Right. After Mr. Bradley left the firm, then there were just two of you, correct?
That is the cause of the significant change. Yes, ma'am.
So now you have two people bringing in income, correct?
Correct.
And one of those people, you, is spending almost all of your time devoted to this election integrity case, correct?
Yes, ma'am.
And your income from this election integrity case is less than what it was the year before.
Yes, ma'am.
We talked about the monthly caps, or we didn't talk about it. There was talk about the monthly cap that was included in your contracts, indicating there was a certain threshold that you could reach, number of hours a month. And over that amount, you were not going to be compensated, correct?
That's correct.
All right. You kind of smiled when you said that. That's a little bittersweet there, isn't it?
That's bitter.
All right. Exhibit 14, is that still there in front of you?
It is.
I want you to take a look, please. That's a collection of exhibits that includes all of your invoices as was represented. I want you to take a look at invoice number 9.
Yes, ma'am.
Is that there in front of you?
I have it.
Invoice number 9, Mr. Wade, indicates that you performed hours of work that you were not compensated for because your cap had been reached.
Yes, ma'am.
I want you to take, and what did you do in those circumstances? When the hours that you worked per month were more than the cap that was in your contract that you were permitted to be paid for?
I was forced to lose that time. I didn't get paid for it.
Okay. And that's what exhibit number 9 shows?
Yes, ma'am.
All right. And in exhibit number 9, you've got a task, hours that were completed, and you just didn't bill for it. You noted the time and then a 0 beside it because you didn't bill the county for that time.
Yes, ma'am.
All right. What about exhibit number, invoice number 13? Can you flip to that for me?
I have it.
Is that a similar situation?
Yes, ma'am, it is.
And what is it on invoice number 13?
Yeah, but the judge says he's not gonna really weigh
This
on
invoice makes me cry. There's so many hours here that I worked that I couldn't get paid for.
Right. When I saw his
And you
invoice,
work
I
those
cried
hours anyway,
too.
Mr. Wade?
They were
Oh, absolutely.
so
This
stupidly
is not the type of job that you could walk away from just because you're not getting paid for it. I think there's some professional rules of responsibility to an attorney who's engaged in a case. You have to see it through. So it's not like I can just throw my hands up and say, well, I reached my monthly cap. I'm done. I can walk away. I can't do that. This is ongoing. It's constant. And I have to do the work.
Can you look at invoice number 23 for me there in exhibit number 14?
That doesn't mean at the outset it wasn't.
Does that reflect a similar situation, the hours worked that you were not compensated for?
Yes, ma'am.
Invoice number 24 and 27, can you take a look at those and let us know if that reflects the same situation?
Are you trying to depress me?
No,
Look
I'm
at
not.
the money I'm
I'm sorry.
It's the same, yes.
Okay. And there's no workaround to that? You didn't attempt to work around that contractual cap on your hours?
Oh, no, ma'am.
Oh no, ma'am. I'm just an honest,
All right.
hardworking lawyer.
You
Oh,
were
no,
asked a lot
ma'am.
of questions, Mr. Wade, about the affidavit that was submitted, correct? You recall those questions?
I'm sorry, I'm stuck on this invoice. You know, if I was gonna get a benefit, I'd like that benefit. That's the one I want.
Is this the tapper?
That didn't happen.
That didn't happen?
Okay.
All right. And there was no renegotiating your contract to reflect that those hours should be paid, right?
No, ma'am.
Okay. All right. Do you have your affidavit there in front of you?
I do.
The affidavit, of course, was attached to and provided in support of the state's response to Mr. Roman's motion, correct?
Yes, ma'am.
All right. And you prepared that affidavit?
I did.
You signed that affidavit?
I did.
All of the allegations and the representations in that affidavit are true. Is that right, Mr. Wade?
Every one of them.
Every one of them. You were asked a lot of questions about our line number 34. Can you turn to that for me, please? It's on page 4 of that affidavit.
Yes, ma'am.
Can you read it out loud for me, please?
The district attorney and I are both financially independent professionals. Expenses for personal travel were roughly divided equally between us. At times, I have made and purchased travel for District Attorney Willis and myself from my personal funds. At other times, District Attorney Willis has made and purchased travel for she and I from her personal
No mention
funds.
of cash.
Examples of District Attorney Willis is purchasing
No
plane
mention of
tickets
cash.
for she and I with her personal funds for our personal travel are attached.
Funds, Mr. Wade. As you understand the term funds, does that include cash?
Yes.
Does that include?
Why didn't you mention cash?
Does that include?
That is the stupidest thing in the world.
Yes.
You didn't represent in your affidavit, Mr. Wade, that you were including all of the receipts from funds or travel expenses that were paid
This is
on your behalf.
This is a
by
stupid
District
way to
Attorney
try to
Willis,
approach
correct?
this.
That's correct.
You had, I think your conversation with Ms. Merchant was, you produced the receipt that you had.
Yes, ma'am.
Are you aware of any other receipts? What, I may ask you this, or may I put you on there for just that sticker?
See, okay, so I like the fact that she raised that you're making less money. That's
I'm gonna mark this as
smart.
State's Exhibit number 1.
This line of
You
questioning is
testified,
trying
Mr.
like
Wade,
massage
that
in
District
cash
Attorney Willis
as if that's in the
purchased
affidavit.
and funded the entire trip to
Transparently
Belize.
stupid.
That was her treat to you for her birthday?
Yes, ma'am.
And you testified that she purchased the plane tickets for you, correct?
Yes, ma'am.
And while you may not have had the receipts on hand when you filled out the affidavit, because they weren't in your possession, are you aware now that there are receipts and that it reflects that the district attorney?
If this is gonna go into evidence, we'd like to look at it first.
I've got a copy.
Well, now we got new evidence. We got
Do you
drinkers
remember,
here.
Mr. Wade,
With
approximately
stupid mugs.
how much, and that's again, 6
The camera or mugs?
do you remember how much the flight was for you, your flight to Belize?
Oh, so now you didn't get paid cash? That's how
And
it
if you go
said
on
it
that
was?
tendering it through you, I'm just asking you to take a look at that and see if that refreshes your recollection as to the amount that that plane ticket cost that was extended by District Attorney. You may keep it.
I'm a little disappointed that they didn't drill him harder. Like, so she gave you $2,500 in one payment. I really wanted to see that.
Does that refresh your recollection, Mr. Wade?
It does. Thank you.
Approximately how much was the amount of the ticket that District Attorney Willis purchased for your travel to Belize?
$887.35.
So much sweat is dripping into his eyes. So much sweat.
And I'm not tendering it, Your Honor, but I will leave it with the court reporter for reference and inclusion in the record. All right, Mr. Wade. Your testimony here in court today and consistent with your affidavit was that the personal relationship, I think we've called it dating today as well, the personal or dating relationship between you and the district attorney began sometime in early 2022, March, I think was your testimony, is that right?
Yes, ma'am.
And that March date isn't included in the affidavit. The affidavit is less specific, but that was your testimony today?
Yes, ma'am.
And that there was no personal or dating relationship prior to that time, right?
No.
Okay. Mr. Wade, I'm sorry. I'm going to direct your attention to 2020. In 2020, were you dating the district attorney?
No,
2020, that was during the COVID pandemic, correct?
it was.
Was there a situation for you, Mr. Wade, that made you particularly vulnerable during the COVID period?
Yes, ma'am. And in 2020, and a portion of 21, I was battling cancer. And that prevented me from pretty much leaving environments that aren't sterile. And I had health on my mind.
You were particularly cautious during that time.
Yes, ma'am.
Were you dating anyone in 2020?
No, ma'am.
All right. Thank you, Mr. Wade. That's all I have.
Ms. Merchant, recross on those points only.
Yes. All right, Mr. Wade. The state asked you about how much money you're making now versus before, and you said
Maybe.
you're making significantly less since you've started working for Fulton County, correct?
Well, I did say that, but what we're talking about is because
It's not your tax return show.
now at this point, the splitting of the financial obligations in the firm are now there are two people carrying the weight of three.
Oh, there you
So
go. That's
that
exactly
would
what Coffee First
scale
is saying.
back on the amount of income, right?
Yeah.
Amount of profit.
Well, you're splitting the profits 50-50 though, instead of 1/3, correct?
The profits, yes.
Okay. So, but you did testify that you're making significantly less now. We heard about it for a few minutes, significantly less now that you work for Fulton County, right?
Yes.
Okay. Would you agree with me that $236,000 is more than $184,000?
Absolutely.
Would you agree with me that $262,000 is more than $236,000?
Absolutely.
All of these years, despite you saying that you were three-way partner with Wade and Campbell and Bradley, and now a two-way partner with Campbell. All of your corporate tax returns are filed in the law firm of Nathan Wade, though, correct?
My returns, yes, ma'am.
Yes, for your law firm.
Well, for my law firm, because I also have personal returns.
Right, and I'm not talking about your personal returns. I'm talking about your business returns.
Yeah, but the question contemplates that my bring home money is more or less. So I want to be clear that is reflected in my personal returns.
I didn't ask you anything about bring home money, though. I'm not sure what you're talking about.
What I'm talking about is your question was the portion of my testimony dealing with earning significantly less money.
No, my question is I'll just break it down. During 2019, you filed your business returns. I'm not talking about your personal, your business returns for the law firm of Nathan Wade only, correct?
I filed personal and business. Yes, ma'am.
And even though you said you were partners with Bradley and Campbell later on, you filed your business returns not with them, but as a solo practitioner, correct?
I see what we're going. There's a different return for that Wade, Bradley, Campbell entity.
And I'm not asking about that. What I'm asking about is during the years 2019, 2020, 2021, and 2022, you filed a business return for the law firm of Nathan Wade.
Yes, ma'am.
And in 2019, you said that the law firm of Nathan Wade made $184,000, correct?
No, I don't know.
Does that sound familiar? Does that sound about like what you made in 2019 and reported on your taxes as a business law firm?
If that's what's on the return, yes, ma'am, you're right.
Okay, and I'm happy. I can bring those up. I've got one copy. I'm not planning on admitting them because they're tax returns, but.
Refresh your recollection.
Okay.
Thank you. So in 2019, gross profit for the law firm of Nathan Wade is $184,000, correct?
Let's see.
The second line, number 2, gross profit.
Yes, ma'am. 184,824. Yes, ma'am.
Okay. And then in 2020, you also filed Nathan Wade, attorney at law, and your gross profit was $230,000, correct?
Yes, ma'am.
And in 2021, you also filed as a solo Nathan Wade PC attorney at law, and your gross profit was $236,000, correct?
Yes, ma'am.
And then in 2022, you filed as a solo practitioner Nathan Wade, and your gross income was $262,000, correct?
Yes, ma'am.
I'm not going to into this. I've got your but nowhere in these documents do you document that you received cash payments from Ms. Willis, correct?
I hadn't looked through them. I would be surprised if there were something in there that said that.
Do you want to look through?
Listen to the answer. I'd be shocked if there was something in there that said that I received some cash from Ms. Willis.
Okay. But there is itemized expenditures for travel in here. You did itemize that.
I didn't itemize anything.
Your accountant itemized it.
I hope so.
But you're responsible for your taxes, even if your accountant files them, right?
I agree.
And so you itemized your expenses for travel on all these documents, but you did not itemize, you didn't put anything in there about you being reimbursed for half of that travel.
Well, those are business returns.
Yes, you used your business card to pay for the travel, right?
But I wouldn't put a personal expense on a business return.
But you used a business card to pay for these personal travel.
I use a business card to pay for everything. And what I do is turn over the statement to the accountant, and the accountant then says, okay, this expense, that's personal. We'll put that over here. This expense, that's business. We'll put that over here. And they reconcile it. So you wouldn't find a reimbursement from Ms. Willis on a business return.
Okay, so they're not anywhere there.
Nor would you find
on a personal return.
Well, go ahead.
No, I'm just asking. So there's nowhere for any of that cash to be reconciled there, right?
On the business returns, no, ma'am.
Okay. We talked a lot about the financial affidavits. I know the state asked you a couple questions about them. You filed one in 2022. In that one, you stated that you only had $5,000 in cash, correct?
I believe you. Yes, ma'am.
That was sworn under oath.
At the time of filing, yes, ma'am.
Okay. And then in January of 2024, you filed another one that also swore that you only had $5,000 in cash, correct?
At the time of the filing, yes, ma'am.
Okay, so in 2022 and 2024, you only had $5,000 in cash.
At that time, yes, ma'am.
At that time, I'm sorry.
And then you also, all of those interrogatories, I'm not going to go through them in painstaking detail, but every single interrogatory you filed, there are 4 of them, all verified ones. Every single one, you said you didn't have any cash stored in a safe, a safety deposit box, or any other location. Plaintiff rarely carries cash. If plaintiff does carry cash, it's a nominal amount, correct?
That's correct.
Okay, so we've got what? 2021, you said you don't have cash. 2023, you said you don't have cash. Again in 2023, you said you don't have cash. And then in 2024, you don't have cash, right?
So you're assuming that I received the cash and I stored it. I received the cash and I saved it.
Well, you didn't put it in the bank, right?
What's wrong with receiving the cash, Ms. Merchant, and spending it?
Nothing's wrong with it, but you didn't put it in the bank.
That would contemplate why the response is what it is on the interrogatories.
So you spent the cash. That's because before when it was asked, you said you didn't want to disclose where the cash was.
No.
For privacy reasons.
No, well, I said that if I were to store cash in my home, then why would I share that with the world, is what I said. I didn't say that I had some cash stored up in some place.
This is so shady.
And you've talked a lot about this.
I spent every penny right away.
A third, I split with half. From the check you received from Fulton County, July 15th, 2022. So all the way back for July 2022, not a single check that you've received from Fulton County has gone into a joint banking account. Every single check has gone into your own personal banking account, correct?
All of them, with the exception of the checks that were going into the WBC firm, went into my business bank account, which is
so the
solely in my
$300,000
name.
came to you.
Your WBC account that you're talking about, that account was closed though in June of 2022.
Correct.
Okay. So everything after June of 2022 was put in a Nathan Wade bank account, not a corporate bank account with partners.
I think the question right before that only needed a yes or no.
So no, ma'am. The checks were deposited into firm accounts, law firm accounts.
Law firm of Nathan Wade PC.
Yes, ma'am.
As a solo practitioner.
Yes, ma'am.
Okay, so they were not deposited into
They were not
accounts
shared
with
a third,
Campbell or
the
Brown.
way you said
No,
earlier.
ma'am, they were not. However, there were checks written to Campbell and Bradley that will reflect the third.
But not
And
the
we've tried to get those
300,000.
bank records, but you've objected to those, correct?
You've tried to get what bank records?
We subpoenaed bank records and you've objected to all of those, right?
Your Honor, I'm going to object to the relevance.
It's relevant if he's saying he has all these records, but yet we've tried to get them and he's trying to keep them from us, but he doesn't bring all of the records. And you can make an inference if there's law that says you can make an inference if some documents are within the party's control and they won't provide them, that there's an inference that they're not positive.
Your Honor, there was no obligation for Mr. Wade to produce evidence that Ms. Merchant couldn't find an admissible way to produce. I believe it's irrelevant. We've covered the ground, and I object to any further questioning.
All right, I'll sustain that. Ms. Merchant, let's find some new ground here.
Okay, thank you. Are you willing to waive your privilege with Mr. Bradley so that he can testify?
I am not willing to waive attorney-client privilege.
Okay, thank you.
Only on the health questions that were asked on campus. And I can ask you from here, from immigration. I don't want to get into the type of cancer. I don't want to get into the medical condition itself. Did I understand you to say that you had cancer in the year of 2020?
Yes, sir.
And you explained that because of that, in 2020, you were or kept yourself in a sterile environment?
That's right, yes, sir.
Now, what about 2021?
2021, just focusing on my health, trying to get back to myself.
You remember I asked you some questions about Hateville?
Yes, sir.
And the condo?
Yes, sir.
And you indicated that prior to November 1st of 2021, you had spent time at the condo, the Hateville condo?
Yes, sir.
With Miss Willis, right?
Yes, sir.
And with someone else? You said Miss Yurty?
Miss Yurty, yes, sir.
Okay, so you were not concerned, that was not a sterile environment, was it?
Are you inferring that Miss Yurty and
No, I'm
D.A.
just saying
Willis
that-
is not sterile? Of course it's a sterile environment. It's a condo.
Isolated.
But don't you remember then I followed up and said Where else might you have been
Waste
to
this for
show your
saying they're
cell
not
phone
sterile.
records from Hapeville and you said the airport, right? Not a sterile environment though, the airport, you agree?
It is not.
Okay, what about restaurants? Not a sterile environment, right?
They are not.
And the Porsche, you said something about a Porsche what?
The Porsche experience.
That doesn't sound very sterile to me. Is that a sterile environment?
You're inside your vehicle.
Yeah, but don't you mingle with others?
You can.
Yeah, and you were doing all that in 2021 before November 1st. That's what you testified to, correct?
Yes, sir.
So there's no reason why you couldn't be dating in 2021, is there?
You mean 2020, Mr. Sato?
No, I said 2021.
All right.
Correct?
Dating? No.
No reason.
No
right?
reason.
Got it, thanks.
Good.
All right, Mr. Gillen.
I like Sado.
Okay.
Sado, the attorney just question is Trump's
Mr. Stocks.
personal attorney, as opposed to these
Stocks,
others
excuse
who are
me.
co-defendants attorneys.
Just real briefly, you said you started dating in early 2022, and you also used the term personal relationship. And there was no dating and no personal relationship prior to early 22. Is that correct?
Help me understand. I want to make sure I answer you. So let's be clear. 2022 was the start of any intimate sexual relationship with a district attorney.
Okay, and that's what I was wanting to
Okay,
make clear. In your affidavit, you used the term personal relationship.
got it.
Today, you've used the term dating. And your testimony today is that that includes the term basically physical or sexual or intimate relationship. Is that correct?
Yes, sir.
And there was nothing, according to your testimony, there was none of that prior to early 2020.
That is correct.
That's all I've got, Judge.
All right, not seeing anyone else. Ms. Cross, any redirect? All right, Ms. Merchant, can this witness be excused?
I'll tell you why he's smiling at that, because he doesn't realize how awful he looked at the witness. That's why.
Judge, we'd ask to keep him under subpoena. We might need him to come back after that.
All right. All right, you may step down, Mr. Wade, and please don't discuss your testimony with any other witnesses.
She mentioned subpoena, Judge. Let me just say this. That was an inference made that I was somehow evading service of a subpoena.
We can take that up. I don't think we need to have it on the record in this hearing. Understood, Bill.
Thank you.
All right, Ms. Merchant, any other witnesses?
Yes, we would call Fani Willis.
Oh, here comes Fani!
Ms. Cross.
Your Honor, I am going to adapt and remove to the motion to quash the district attorney. There's been now lots of testimony from Mr. Wade. I don't believe that there can be a showing for the need for the district attorney to testify as well.
He just said he paid cash.
For all of the reasons that were cited in the state's motion to quash initially, tremendously high burden to call opposing counsel. I don't believe it's been met, particularly given the cumulative nature that would be the subject of personal details that Mr. Wade's not testified to.
All right, Ms. Merchant, what do you think you can establish and have through the testimony of Ms. Willis? And let me start there.
Conflict in the evidence, Judge. Now that how Mr. Wade has testified, there's a conflict in multiple different issues. I'll just go through all the different issues. The first one is the reimbursement issue, the cash. That opened the door in and of itself. Ms. Willis testifying.
Well, what's the conflict there?
That he testified that he didn't have receipts, but we don't know if Ms. Willis has receipts. So that's one issue.
So we don't know. So there's no conflict. We just don't know.
We don't know. Right?
Okay. So it's a question, not a conflict. But what else?
That is a question. So, and there's a lot of different issues with different reasons. The first one would be the receipts. Whether or not these cash payments, cash payment receipts, the Belize trip, whether or not she paid for the entire thing in cash. Mr. Wade doesn't have knowledge of that. He couldn't remember a lot of things he couldn't remember. So now it goes to Ms. Willis, unfortunately. That he testified that she insists on paying her own way, gave him some cash, that's the quote, some cash. Miami trip, she booked it, balance out. A couple other other trips that we didn't get any information about, Tennessee, Alabama, Georgia, all of those.
He's
could
going to
be
let her testify. He's
Financial
gonna
benefits,
finish
we don't know.
this.
He didn't know.
My prediction.
But he was very vague about that. Yuri, her best friend, testified that it happened in 2019. And now Mr. Wade has testified that the relationship began to become romantic in 2022, I think is what his testimony was. So that is a conflict in and of itself. Right there, that's a big conflict. We've also got more receipts. But the biggest thing about the conflict is when the relationship started. He said he talked with Willis in the conference room after we filed our motion. He specifically didn't use cash, the term cash in the affidavit, but he told anybody who would ask about the cash.
We wouldn't talk about the relationship, but anyone who asked about the cash.
And the response. I think we have a right to.
All right, so you've highlighted the areas you'd like to go into. I think the central question may be, what is it other than, I'm just really curious what she has to say, you have to put on the record. And so that's what I'd like to go through. Ms. Cross?
I think you've identified, Ms. Merchant hasn't itemized inconsistencies for you. She's identified areas of inquiry. The testimony in the record from Mr. Wade is it's not inconsistent, it's unrebutted.
Well, the way we can rebut it is to vet out whether or not she withdrew cash. That's the way we can rebut it.
And so that I don't believe, given the testimony of
Where'd she
Mr.
get the
Wade
cash?
and
Where'd you
the
get the cash
extent of
from,
the questioning
Fanny?
of
Where'd you
him,
get the cash?
that
You
there
pulled it out of your
is
ass?
any reason at this point to go into the district attorney herself.
Ridiculous.
Again, I know the court's read all the pleadings. It really is such a compelling need, is the language of the case law, a compelling need to call opposing counsel.
Applies on
Given the
one
record that's
more
now
on you
before
too.
the court, I don't believe it's been
Your Honor, Mr. Gillum, very briefly, Ms. Willis needs to testify. Her best friend or good friend has directly contradicted the declaration that was made by Mr. Wade attached to the government's response. And it wasn't just the declaration of Mr. Wade, it was filed by the district attorney by and through her assistants here. She owns that.
Yep.
And so that affidavit is owned by her, and there are deep concerns that that affidavit is false. And then Ms. Willis knew it was false. And then she needs to come in here, and she wants to tell us about the cash. First time we've heard about the cash, oh yeah, we got cash. Don't have any deposit slips, don't have any record of it.
Withdrawal slip?
Maybe Ms. Willis can say, here, all my records where I paid $10,000 in cash back to Mr. Wade.
Yeah.
We need to know that.
Yeah.
Also,
Yeah.
Ms.
Get him,
Willis's,
Gilliam.
financial disclosure. We let's not forget that. We're talking about two people who went to extraordinary lengths to hide
the relationship.
their relationship.
Yep.
To hide the nature of their
Yep.
relationship.
Yep.
Extraordinary.
Go for it,
The
Gilliam.
district attorney needs to take the stand, and she needs
Yes,
to
she
tell
does.
this court
Yes,
and
she does.
this courtroom why
Motion to
she
quash
filed
denied. Get her ass up
financial disclosures identifying prohibited sources, which Mr. Wade clearly is a prohibited source. Did you get gifts and benefits? Now, we've seen all this. We've seen the trips. We've seen all of the things that total up to around $10,000 in cash.
Seriously, Matt.
On the financial declaration for 2021, which was filed in April of 2022, and the financial declaration for 2022, which was filed in
I'll
April
be very
of
disappointed in
2023.
this judge if he lets
There is
her
no listing
get out.
of any gifts whatsoever over $100 from a prohibited source. It cries out for her testimony. She needs to be able to get up there and say, why didn't you tell on the disclosure form, so that people will know the nature of the relationship between prohibited sources and the public official, in this case, the district attorney.
Yep.
Who happens to then make a decision to hire someone that ends up being paid hundreds of thousands of dollars, or his firm and him, and none of that is revealed. And the answer is, oh, it's unrebutted. He's explained it's all in cash. Let her get up and let's Yeah, and obviously, we are advocates in our position, but that explanation of cash does not pass the smell test or the straight face test. She needs to go on the record. She filed this motion.
I want the truth.
Declaration. We've seen what happened here. Now, I'll just 2 or 3 more sentences. We need to have the full picture.
It's Tom Cruise when we need him.
From Mr. Wade, this false interrogatory, serious business for a lawyer or anybody. And then suddenly he's changed. He files her financial declarations. Same problem. We need her in here to go over all of this and explain exactly what happened. Ask the court that the court allow Ms. Willis to be called and interrogated on these matters.
And I would, Your Honor.
Just a moment, Ms. Willis.
I'm
So,
ready to go.
Ms. Cross, I don't know if you want to speak with Ms. Willis now. It's sounding like maybe they're withdrawing
I believe I'm.
the objection to the motion,
I believe the motion to,
or does Ms. Willis want to take the lead here?
we'll withdraw the motion to quash Ms. Willis.
Based on the rule. I'm ready to go.
Okay, so the position of the district attorney at this point is that she's no longer contesting the subpoena. Ms. Merchant has called her as the next witness.
I would ask, I need 3 documents in front of me, and they're the 3 filings of Ms. Merchant.
3 filings.
Does anyone have the 3 filings of Ms. Merchant? Does the court have the 3 filings of Ms. Merchant?
When you say the filings, you mean like the pleadings?
The pleadings, yes, Your Honor.
Okay, I think we could locate those for you in the supplemental.
I want the one filed on January the 8th, the one filed immediately after we
I
filed
want-
ours.
I want this. Look at her making her
If you
freaking
want to
demand.
break to get them, I can make a copy.
It's not your courtroom, honey. I
Well,
want.
the only copy I have is going to have my notes on it. So if we don't have a clean copy,
We have a 5-minute break, Your Honor.
Let's
I'll get
take
the documents.
all right.
I'll sit
Oh,
here.
here we go. Here we go. Here we go. This is or cross your heart.
Did we elect someone who's actually making the copy?
Lavish.
You got it. Okay.
Yes.
Ms.
So,
Cross is yours.
There.
Fani Willis about to take the stand here. And oh my God. Oh my God. Here we go. Here we go. It's like the state is like, no, we're quashing this. We're quashing this. We need to quash this. And Fani Willis just marched on in there. She's like, I'm ready to go. Let's go. F the quashing. I want to take the stand. Give me that stand. Give me their papers. It's like, who the hell do you think you are? My God. The arrogance of this woman. The arrogance. I want to see their motion. I want to see their response. I want to see their pleadings. Oh my God. This is great. This is such great theater. Oh my God. She's getting up the stand. Fani Willis. So they need to ask her. I'll tell you this. I'm a little disappointed that all of those attorneys, none of them asked one key question to me. Because if, according to the testimony from Nathan Wade, that he's like, no, I didn't benefit. We shared our expenses, blah, blah, blah. She didn't benefit. She paid her share. She's a very independent woman. Oh, she's a very independent woman. Anyone who knows Fani Willis knows she's a very independent woman. You know what? So she paid me back cash. And I want to know, because I don't want her to be able to squirm around this. This is where you nail down. So it was like hundreds of dollars at a time she gave you? Hundreds of dollars? Or was it like multiple payments? And the reason that's so important is because, yeah, so Fani, if you pay back $3,000 in a shot, so first of all, was it paying 20s, hundreds? I would be asking Nathan Wade that. Then you bring in Fani Willis right afterwards, so they don't have time to sort of review all that crap, assuming that she's properly been kept from watching his testimony, and ask her, you paying 20s, you paying hundreds? Was it over multiple period of time? Oh, it was in lump sum? That's what he was implying. Everyone drew implications that it was over a lump sum. If it was a lump sum, in that case, we should be able to see withdrawals. I mean, where does Fani Willis have piles of cash in her house? We should be able to see withdrawals of $3,000 from her bank account, right? I mean, if she's making a payment on a Belize trip of $2,500, $2,700, we should be able to see. I mean, you can pull up your bank records. Pull up your bank records. Show us where you pulled out cash, $2,500. Because I think all that's crap. Everyone thinks it's crap. Everyone thinks it's a lie. So he's like, well, I just took the cash, I spent it. Like I'm a high roller. As soon as I got $2,500, it came in my pocket, it was out my pocket 10 minutes later. I'm going gambling, we're going on cruise ships. I'm just spending that money. Yeah, that's why it's not in a bank. That's why it's not in a bank. I spent it right away. Oh yeah, okay, fine. You spent it. There's no proof of it, no nothing. There's no evidence, no documentation whatsoever. Well, you know what? There should be documentation that she withdrew the money then. Right? But I'm afraid, because they're Weasley, and they don't mind basically saying whatever supports their position, that she's gonna be like, no, there was no massive cash withdrawal. I took a couple hundred here, a couple hundred there, and I would pay him back every few days, a couple $100 to catch up. That's what I'm worried she's going to say. So you want to prepare for that. The best way to be effective as a litigator is you sort of need to anticipate and think and assume that these people are the worst, scummiest lawyers on earth. Whatever story they can try and sell, which they think will help them escape culpability for what they did. That is what they're going to sell. Predict that. And the more you can predict that, the more you can ask questions to lock them in beforehand so that they're not able to squirm into a different position. If he comes in there, he's like, oh yeah, she came in 4 days after the trip and just dropped down $2,500 on my lap. Then if she tries coming in and saying I was paying $200 at a time, it's obvious that they're lying. But he never got him on. No one got him to actually say it was a lump sum payment, which I think was an important miss. It's a disappointing miss, considering that you have 12 different attorneys for these 12 different defendants, and not one of them actually locked him in on that. And that's a little disappointing. Not going to kid you. It's a little disappointing. I give more of a pass to Ashley Merchant on that, because, like I said, when you're there in the fray, you sort of, there's a lot of that's. I'm picking on one out of potentially 300 different things to try and cover. But if you're not in the fray, you're sort of standing on the sideline, watching it happen in a case that's relevant to your own client, but it's not you standing up there asking the questions. It's much easier to have the attorney clarity to say, what am I sort of planning for here as to which direction they may squirm? But if you can't predict which direction they're going to squirm, you're not being effective counsel and trying to lock off different corners. Boom, 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 until they're just penned in. Nowhere to go, nowhere to turn. That's your story. That's the story you're embracing. That's the story you're married to now. And then once they're married to a story, then you show how the documentation and the evidence shows that that's crap. And that's how you ultimately grasp a snake and just wrestle it to the ground and just twist. That's how you do it. You have to lock them in. And I don't feel like they locked him in enough. And he's a squirrely little snake. Squirrely as all get out. Squirrely as all get out. I'm still waiting over here. Don't think you're missing anything. You're not missing anything. I'm still waiting over here as we're watching the cam over there. So don't worry about missing any of that. But she did come in hotter than Ashley's chest. She came in very hot. Put me up there. I need the pleadings. I want their papers. I want their motion. Why does she have such attitude? Looks very suspicious. She has something big she thinks she can prove. It's because she thinks I'm Fani Willis. I'm Fani Willis. I'm very important. I'm the Lord's imperfect child. Where's Vince McMahon? That was seen straight out of WWE, just missing the entrance music. It was, right? And she's like, all of a sudden, it's like, whoa. It's like we're arguing about whether Fani should be brought in here. And there's Fani. Keep putting me on the stand. I want to go on the stand. Put me on the stand. Oh, so good. It was so good. And likely that's what's happening right now, but I don't want to impugn the integrity of counsel. You have to be a little scared about the timing of this break. Not going to kid you. She's corrupt. Of course, she was watching the court. That's why she's so mad. Yeah, probably. Her lawyer just went out with her to tell her what Wade said. Well, that's technically a violation and sanctionable. It's not supposed to be happening. But yeah. Oh, that's the woman with the camera who kept blocking our view there. You see that little white and black camera there? Kept blocking our view the whole time. I bet Willis about to fanny the flames. Nice. I like it. I like it. I like it. Let me make sure I'm not missing anything else here. Your Honor, get this amazing brave black woman a coffee. Oh my God, she's so brave. She's so brave. PC says, LFG, let's go. Let's go. Let's go. Let's go. Make sure I didn't miss anything over on locals. I do have a chat with my diggers going on here. What's happening there? Oh, there they are. There they are. Apparently, MSNBC is saying that Fani's in trouble. I'm going to tell you this. This is great theater. If they can't show that he's financially benefiting, if they struggle there, that is a way that Fani can escape this one. That's someone asked me earlier to comment on if I was Fani's counsel, how would I try and fight this? I would fight very, very hard in the two directions which they're doing. I don't think the district attorney's office, which is defending Fani and Nathan Wade here, I don't think they're doing an incompetent job. I think they're actually doing what attorneys should be doing, as much as I despise them and think they're scummy. But I'm saying that they're trying to find framing, and that framing which works for you is that the relationship, they didn't have a real relationship. That's what you're going to try and say. That's the position they've taken. I think that there's a lot of evidence. I think the Yurdi testimony was crushing for them. But on the other hand, here's how it plays with respect to the whole money thing, how much money he made. Because what the movements are trying to say essentially is Fani gave this job to Nathan Wade for the purposes of getting him more money for her own personal financial benefit. And that's why she and Wade have to be removed. Questions that basically come in. So one way that Fani's and her counsel are trying to fight against that is by saying there was no relationship prior to the start of his employment, and that he didn't make more money. Him not making more money, though, is not necessarily reflective of that there was not an intent for him to make more money. Just because he failed at making more money doesn't mean that wasn't the objective. So I don't know that thoroughly gets rid of it, but it looks good in the eyes of the court. In other words, if you had a plan and the plan failed, that doesn't mean that the plan itself doesn't make the entire concoction of this entire trial corrupt and wrong. It's something that should be shut down. So the plan itself, even if it doesn't work, is a reason to say that this thing should be dismissed. But it could be a basis for the judge to sort of lean more toward Fani Willis. So that's essentially why you're gonna bring that out there, and you try and gloss over the fact that it's not the plan, but it's the success of the plan, which is a reason for the taint. That's how you would play it if you're sitting there from the other side of the aisle. I thought that I think the judge is being relatively fair here. He's been relatively fair. Some decisions in Movement's favor, some on the other side.
All right, Mr. Cross, you can bring everyone in. Thank you.
There we go. Yes, moving across. Annie coming in hot in her pink suit.
Do you swear me, Your Honor?
Who the hell is she?
Never would like to.
What a freaking arrogant, stupid
Let's go.
biatch.
Everyone get situated, and then we'll go back on the record.
You swear me, Your Honor. Who the hell is she?
Sir, you have like tissue in here.
All right, we are back on the record. Deputy Scott, if you could swear in our next witness.
I would, and I do apologize. Hannah. Do me a favor. Put them on my knees, I'm gonna need glasses. After you swear me, tell me what I need. Swear, you can go ahead and swear, so I don't know what the court.
You swear on fire.
Yes, sir.
Okay, you have the first name?
District Attorney Fani, Fani.
That's part of her name. My name is District Attorney
Ms.
Fani
Willis,
Willis.
how did you know to come into the courtroom right then?
Because there were people I was pacing in my office.
Oh, good
I
question.
heard someone yell, "His testimony is done." It only made sense to me.
You were watching.
And I've been very anxious
That's what
to
she's
have this
getting at.
conversation with you today. So
Great
I
opening
ran
question.
to the courtroom.
So as soon as you heard that Mr. Wade was done testifying, that's when you just assumed you would be the next witness?
It only makes sense.
Did you listen to any of the testimony?
I've been in my office pacing, ma'am.
Did you listen to any of the arguments?
I did hear the arguments this morning. It's ridiculous to me that you lied on Monday and yet here we still are. And I did listen to that argument.
She is not a good witness.
All right, so that was it, just the argument, no testimony.
Right, I listened to the argument this morning where Adam Abadi, I thought, did an excellent job pointing out how dishonest you were with the court on Monday. And I'm
She's so
actually
angry.
surprised that the hearing continued. But since
You're an
it did,
idiot.
Here I am.
Great. So let's just talk about what you did in preparation for today. Did you meet with Mr. Wade at all? Once the motion was filed, did you meet with Mr. Wade and talk to him about the motion that I filed to disqualify you?
On this first January motion?
Yes.
I don't know if you could say talked about. I probably had some choice words about some of the things that you said that were dishonest within this motion. So I don't know that it was a conversation. As you know, Mr. Wade is a Southern gentleman. Me, not so much.
Okay, but my question was, did you have a
I'm a
conversation
viper.
with
I didn't
him?
have a substantive conversation.
I'm a
I did
viper.
not.
I'm a fighter.
I read this motion, skimmed it more so, and
That's very effective,
I
Kevin.
probably said some choice things to him about some of the lies that were told.
Okay.
And then printed in the media because, we used to be in a day and time where you had 60 minutes and people did stories and they verified information and you had this great reporting. But it seems today that a lawyer writes a lie and then it's printed for all of the world to see.
Well, I just want to make sure that you answer the question I asked though. So my question was,
I'm gonna object. It's been asked and answered.
Overruled, Mr. Abadi.
I told you what happened. I read the motion. I am sure I told him what my opinion of it is. And past that, we had no substantive conversation.
you did not.
Is there something you didn't understand?
No, I just wanted to make sure
What a
that
bitch.
you did not have a meeting with him in the conference room to discuss the motion.
Next question,
No.
Ms. Merchant.
So in the conference room of my office, within this week, you produced some financial document. That financial document was given to me, something, and I'm not even sure who was giving it to him by me or Mr. Abadi gave it to me. And I think he showed me a document in our conference room. But as far as a substantive conversation, I don't believe I've had any conversation with him that is substantive related to this.
Okay.
I have had conversations with him since you filed the motion, but they wouldn't be substantive to this. He's sent me very nice sermons that have been done. And so we've had conversations about, did you listen to that sermon?
Oh, like the
things
sermon
like
I
that.
did,
And
where I
would say
said
they
I'm
were in
God's
relationship
imperfect
to this,
child.
and I think he did it to be kind.
I'm being persecuted like Jesus.
Let's start back in 2019.
Yep.
So you
Yep.
and Mr. Wade
Shut
met
up.
in October 2019 at a conference?
That is correct. And I think in one of your motions, you tried to implicate I slept with him at that conference, which I find to be extremely offensive. I stayed at that
No one
conference.
implied that.
Mr. Wade was my teacher. I did not
No one
meet him
implied that.
when he taught the class.
No, there wasn't.
I was standing outside talking to Lisa Reeves, who is a judge. Me and her were just having a conversation. Mr. Wade walks up.
Have you ever
and they
seen
hug
something
each
like this?
other.
Tankrat
They
is an
have some brief
attorney.
Conversation. She introduces us.
Your Honor, I'm going to object. We kind of thought that when you asked a question, you had answered the question, not a speech, so I object to the speech.
I believe I'm able to explain my answers.
I believe she's able to explain her answers.
And that's,
Ms. Merchant, that's okay. I can handle it. Ms. Willis, I'll ask you to just listen to the answer, or excuse me, the question, and keep the answers confined to the question as best you can. I think you'll have more than enough ample opportunity on when the state.
Well,
She's
it's
out of
highly
control.
offensive when someone lies on you.
She's
It's
out of
highly
control.
offensive when they try to implicate.
She's
that you
losing it.
slept with somebody the first day
She's
you met
she's
with
out
them,
of control.
and I take exception to it.
All right, well, Ms. Willis, she'll have the opportunity to explain all of that when it's the state's turn to ask more open-ended questions.
Yeah.
Ms. Merchant.
Thank you, Judge. So again, my question was, you all met at that conference, though, right?
We did the meeting. He, as I stated. he
It's a
taught
yes
the
or no
class.
question.
I did not actually.
Reel
meet
her
him
in,
when he taught
Ashley.
the class. I walked
Reel her in.
out of the class, and I'm not sure if it was that exact
It
class.
was a
we
yes
went
or
to
no
lunch,
question.
But we were standing in the vestibule, like outside of the class. Me and Judge Reeves were having a conversation. She had worked at a law firm I worked at back in 1996.
We're getting way far. I mean, I don't mind her explaining her answers, but I literally just asked if they met at that
She's
conference.
explaining how she met Mr. Wade, which was
It was a
exactly the
yes or
question
no.
asked by Ms. Merchant.
No, it's not.
Answers are
It was a
more
yes or no
appropriate.
question.
Ms. Merchant, if you want more concise answers, perhaps you could lead the witness.
I will. Thank you, Judge. Isn't it true that you met Mr. Wade in October
I'm
2019
gonna
at the
object.
judges
We
conference?
haven't gotten to the point where Ms. Willis should be treated hostily in this situation.
I think we
And
have.
I'm
The
very
judge
much
just
want to be
said,
here, so I'm
yeah.
not a hostile witness. I very much want to be.
It's not so much that you're hostile, Ms. Willis.
You are
have been the
hostile.
first witness. Your interests are opposed to Ms. Merchant's.
Thank you. Interests are contrary to democracy, Your Honor, not to my.
Democracy. Oh, this is all about democracy.
Just ask that we.
Keep things moving. Ms. Merchant, next question,
Thank you.
please.
She is digging her own
Okay,
grave.
so we've confirmed when you met. After that, isn't it true?
No, I need to explain this, and I think I get to explain.
No,
my
no,
answer.
there's no question
When I
pending.
met him, Judge Reeves introduced us. He handed me his business card. I'm unsure if I handed him my business card, but we exchanged information. He said, if you ever need any help, give me a call. And
Yep.
he walked to the parking lot.
So after that, you
It's so
started
weird
dating
that she's
shortly
single
thereafter,
now.
correct?
That's a lie. That's one of your lies.
Do you know Robin Yurdy?
I know her as Robin Bryant. I knew her. So Robin did not go to my college. She went to the college of, I went to Howard University.
How do you know
which
what
was
Robin
Morgan
said?
State. I met her through some people I knew.
How do you know what Robin
In
said?
college, we hung out a bit, not much
You weren't
because
supposed to
she
walk
was
her
in
testimony.
Baltimore and I was in Washington DC. But we hung out a bit. After college, I lost contact with her. I probably didn't see Robin again until maybe 7 or 8 years ago, a chance meeting here
She's
in
losing it.
Atlanta.
She's
So we did
losing
not
it.
have a consistent relationship from when I left college and came to Emory Law School here in Atlanta. But 8 to 10 years ago, just by happenstance, I ran into her.
So
she was in Atlanta.
You have been friends with Robin for 30-something years.
Did you hear my answer, ma'am?
Yes, and I'm asking if you've been friends with her for 30-something years.
I've known her for 30-something years. We certainly hung out and partied together in college. She was from the DC area. She would come home, we'd party together. Wasn't close, but she was certainly in the girlfriends that partied together. And then, like I said, I ran into her about 10 years ago in Atlanta, Georgia. So we didn't talk throughout that time period. I didn't see her. I didn't even know where she was. When I ran into her, I was surprised she was in Atlanta. And so, yes, I have known her probably since 1990, 1991, but we have not maintained a consistent relationship that whole time.
For the last 10 years or 5, whatever you'd like to classify it as. Have you been friends with her?
I have not spoken to Robin in over a year. I certainly do not consider her a friend now. I think that she, there's a saying, no good deed goes unpunished. And I think that she betrayed our friendship.
So let's narrow it down the timeline now. So my questions are going to be from the time period of 2019
At what point
until
did she betray your friendship?
no longer was employed for you, the last time you all talked. So all of my next questions are just focused on that time frame, okay?
Yes, ma'am.
Up until she left your office.
Yes, ma'am.
During 2019, you all were friends, correct?
Yes, we knew each other in 2019.
During 2020, you all were friends, correct?
We were friends during that time period.
During 2021, you all were friends, correct?
Yes.
Okay. And such good friends that when you needed a place to stay, you asked her if you could take over her lease.
That's a lie.
You did
That's
not move into her apartment?
I
or her
did, but
condo?
that's not the way you characterize it. Is wrong.
I asked if you could take over her lease.
I did not ask if I could take over her lease.
Did you move into her apartment?
I moved into her condo in April of 21. The circumstances around that were that Robin met her husband. They wanted to move into another and separate place. She wanted to get rid of her condo. My father was living with me at the house. Because of this case and because of my stance on gangs, my life was being threatened regularly. My father urged me to leave our home. At the same time, as luck would have it, Robin wanted to give up her lease because she wanted to move in with this new man she met, who eventually became her husband. And so, as life circumstances work, my dad was begging me to leave the house. He was afraid for me, afraid for his grandchildren. She wanted someone to take over her lease so that she didn't, have to pay a fee or get abandoned. And so, I don't remember when, but probably March or April of 21, I moved in and take over her lease.
And did you pay her or did you pay the leasing agent?
No, I don't even know who the leasing agent was. I paid her.
You paid her. Did you pay her cash or did you use card?
There were some times that I would give her cash, but mostly I paid her via Cash App. That would be the most convenient thing. So I would not only give her rent,
Oh,
but then,
interesting.
like when the utilities would come in, whatever the utility was, she might be like, I need
I heard
$70.
of making online payments, not using cash.
And we never had a problem with money. Whatever she told me it was, I never asked to see a bill. I never questioned her. I just gave it to her.
What percentage would you say you paid cash versus Cash App?
Oh, the vast majority was Cash App. I don't know what percentage. I'm not gonna guess that. But the vast majority was Cash App. But there would be times she would say, this bill came in at $70. Here goes $70.
Did you have a monthly rent amount that you paid her?
I can't remember. It was $1,500. I can't remember what it was. And it would vary, which I don't understand to this day. But like I said, I never questioned her.
When did
Whatever
you move out?
she said it was, that's what I paid.
When did
I
you move out?
abruptly moved out in February of either late January or early February of 22.
Of 22.
Yes,
February 2022, is that what you said?
January, February of 22. I believe it is January, but I paid her half the rent of February of 22 is what I remember. And because I was offering to pay the whole rent, even though I didn't live there, I didn't think it was right. And I ended up just paying her half the rent.
So that's after you moved out. You said you paid her half the rent. Okay. And the time that you said you had to move out of your house because you were scared, did your dad stay there at your house?
My father was concerned. Yes, we were both concerned.
Okay. But he remained there.
My father's 80 years old. He would have been 79. He was scared to death of COVID. You have to go back to when this was. My father's an older man. I wanted him to move out.
Questioning whether or not he was afraid of
discussions about him moving out, and what he decided was
angry.
The risk of COVID was more dangerous than the risk of the people that were threatening. Typical man, more worried about his daughter and his grandchildren than his own safety. You'll get to meet him, and you'll understand he doesn't scare too easily.
I don't think we're going to get to meet him.
So your his grandkids were living at the house as well at that time?
Well, I don't know how old your children are, but when you have adult children, they leave and they come back. They leave and they come back. So there have been periods of time that they're there, they come, they do whatever they want to do. Children do what children do. As long as their mother has a house, they'll come to it. Unfortunately, now the threats because of this case have gotten so extreme. I just pay a mortgage and no one lives there.
And that's what I was going to ask you. So when you moved out in, I think you said April 2021, you left your dad and your two kids at the house?
My dad and my two kids were not at the house.
They were not? Okay, so they didn't still live at your house?
My youngest daughter certainly did not live there. Okay. My oldest daughter would come back and forth. I can't say month for month when she was there or when she was not there. I know that she has been there post me moving out. At this time, no one is at my house.
Okay. So at some point after you moved out for the safety reasons, at least one of your children did come back to the house.
Can we get to the relationship?
Yeah, get to the relationship.
Yes.
Yeah, no one cares about the kids going.
So let's see, we were back at 2021. So you were still friends with Miss Yeardy then. Were you also friends with Mr. Bradley?
I've never been friends with
That's
Mr. Bradley.
You've never been friends with Mr. Bradley?
Just
No,
get
I
to
don't,
Wade, Ashley.
I don't.
Development the
consider us to be
relationship with
friends.
Wade.
I certainly-
How
I
often
don't
did you talk? Things of that nature.
dislike Mr.
Like,
Bradley,
ask
but-
Wade.
I don't consider us to be friends.
Is he someone that you would have in your phone and you would message with?
No one cares about Bradley.
I might have text messaged him.
Okay. Would you text message him and Mr. Wade on the same conversations?
I don't recall doing that, but if it happened, it wouldn't surprise me.
Okay, so that wouldn't surprise you, the three of you. Okay. How frequently would you think that the three of you would have texted?
Not very.
No one
I
cares
wouldn't
about
say very
Bradley.
often, but you're asking me to recall. I don't even know what time period you're asking me to recall, but I'm not going to speak to that because I just really don't know the answer to that. And so I don't want to speculate as to how often that would happen. But it's not out of my practice to text two people on one text message. So if you told me that happened and showed it to me, it wouldn't surprise me, although I have no recollection of it.
But there would be some record of it in your phone, or the phone records would have some record of this.
What are you getting to?
Perhaps.
No one cares about the three-way calls, unless you think they were having a three-way relationship.
Talk about, you said that sometimes you paid Miss Yurdy cash. When you went on vacation with Mr. Wade, let's just go one by one. Let's start with the first one. What's the first time you went on vacation with Mr. Wade?
You got this, Ashley.
I think the first time we went on vacation was around April of 22, and it's a vacation is a stretch, but I'm trying to be comprehensive.
Get to the relationship with Wade. Let's do it.
April of 22. His birthday is March the 18th. So that would have been his 49th birthday. I took him to like Tennessee for the day. I think we went to a museum. I think we might have stayed the night. I'm not sure.
Yeah.
But I mean, Tennessee's kind of hard to call a vacation, but I just am trying to be inclusive. And it, like I said, I know it wasn't more than a day.
So you're gonna spend the night?
I think that we did. That's what I'm telling you. I think that there's a possibility that we stayed that night in April of 22.
Who paid for the hotel?
I think I did. It was his birthday.
And would you have used a credit card?
Probably, maybe a debit.
What? What the heck? What the heck? Oh my God. Oh my God. Oh my God.
And, when did you start dating?
When I started dating Mr. Wade, it was right around then.
April 2022?
22, yes.
2022.
It was around then. I don't know, like, it's not like when you're in grade school and you send a little letter and it says, will you be my girlfriend, and you check it. I don't know the day that we started seeing each other, but it was early 22 is my recollection.
Okay, early 22. And you all went to Florida on vacation as well?
I don't recall going to Florida on vacation with him.
You never went to Florida with Mr. Wade?
When we went to get on the cruise ship, we went to Miami.
Okay, that's the only time that you went to Florida with him?
I think we went to Miami and spent the night. That's my recollection.
Okay.
I think we spent one night so that we wouldn't miss the ship. That's my recollection of our
Who paid for that hotel?
In Miami? I don't remember that.
And how'd you get to Miami?
We would have flown. And we've done that, so that I'm clear, we've done that twice. I think one time we stayed, and I honestly can't tell you, did we stay when the ship left or did we stay when the ship came back? I also can't tell you, so there's 2 cruises out of Miami. There's one that's in that October time period that was with his mom. And then there was another that was a New Year's Eve trip. I know I paid for the New Year's Eve trip because the tickets were $697 each. And I thought this is ridiculous that the tickets are $700 to go to Miami. But when you travel during New Year's Eve, they get you.
So let's just back up and talk about the first time that you went to Florida with Mr. Wade. That was the time that you said you stayed in Miami at the hotel the first night?
That's the time I told you I am not sure. So I'm not sure of 2 things. So I want to make sure that my testimony is clear. I'm not sure if we stayed in Miami on the October trip. I'm not sure if we stayed in Miami on the December trip. I just can't remember that. And I also don't remember, so that the record is clear, I don't remember if the necessity was as we got on the ship or we got off the ship. But I do remember there was a night spent in Miami because either whatever, I don't remember. But I think that there was a night spent in Miami.
That cruise is the one that you took in October, right?
Ma'am, if you have something to refresh my recollection, I'm intentionally trying to not be difficult with you, but I don't want to make up something.
Right.
I know that on one of those 2 trips.
At this point, she sounds.
I am not sure right now. You're asking me
comes
about.
across
I'm sorry, you misunderstood. I was not asking you which night you stayed in Miami. I'm asking if you took a cruise in October 2022 with Mr. Wade.
Yes, and his mom.
And his mother. That's what I was asking.
Yes.
Is that the first time you met his mother?
Yes.
It was on that cruise, and that was Royal Caribbean, I believe.
I honestly don't remember what ship. I know we're taking 2 cruises. I don't know what the ships were.
But he paid for the flight and the cruise on Royal Caribbean that time.
So yes, he paid, he is the original one that does it. He has something called, Mr. Wade is a world traveler. I'm not as versed as him. He's been to 6 of the 7 continents. And so he has both a personal travel agent and he also has a cruise travel agent. I don't know anything about either of those kind of travel agents. So he is the one that would book the travel, but we need to be clear when we're talking about just because he booked it doesn't mean, like, I don't consider him having taken me anyplace. Let me just be honest. The only one that's ever taken somebody someplace is for his 50th birthday. I consider that I took him to Belize. And I took him to Belize because, I don't want to discuss his personal business, but I'm happy Mr. Wade is still here with us. And I did 50 big, very big.
So still on that October Royal Caribbean cruise, even though he had a travel agent, I'm sorry?
If you do me a favor, I don't know what cruise ship, what time. So if you'll help me and say October cruise with Mama, or the New Year's Eve trip, with his sisters, I'll be able to, we can communicate. I just don't know what ship.
October cruise with Mama, that's what I'm talking about.
Yeah.
He paid for the cruise and the flights for that trip.
Yep.
So he called his cruise agent and he booked that through them because he has a cruise agent.
Right.
He also has a regular agent. I don't know the cruise agent's name.
So I wasn't asking about his travel agent. I was just asking
But
if
I'm
he
trying to-
paid for those.
He did not though.
Okay.
Because the reason I consider that he did not is I gave him his money back.
And I was about to ask that, but initially he paid for that.
Yeah, he called his cruise agent. Like, I think they have his card on record. They do whatever.
Okay. So initially he paid for the cruise and the flight to Miami and the Royal Caribbean cruise.
And my understanding of that October cruise is like it was a package the lady did for him.
It's because she's a DA.
So, and I'll get to the reimbursements and all that. I'm just trying to confirm he paid for the flight
getting
and the
much better
cruise
latitude.
in October.
Because she's
And I think that when you say things that way, I want this record to be
Initially.
abundantly clear that he calls his travel agent, he calls his cruise agent. They do whatever he tells them. He's like on a first name basis with these people. They do it. And then he tells me how much it is and I give him the money back. I don't, just like you're asking me about the money with Robin, I don't do my friends like that. So if you tell me it's a G, then you're gonna get $1,000. Whatever it is, I didn't ever make him produce receipts to me. Whatever he told me it was, I gave him the money back.
Isn't it true that he paid for the cruise and the flight on his credit card? I'm not asking about reimbursement or after. He used his credit card to buy the cruise and buy the flight, correct?
I have no idea how he paid for it, if it's a credit card, if it's a debit card, but certainly he called his cruise agent. Like how many people have a cruise agent? He calls his cruise agent, tells them where they want to go. They tell him what's booked. You have to remember, he paid for that initial was me, him, and his mother.
And then after that cruise, you all flew to Aruba and spent a couple days in a hotel there, correct?
Right, and his mother was not happy.
He
that we left her
initially
behind.
paid for that. He initially paid for that.
For Aruba, yes, ma'am.
So let's talk about both of those. I know he initially paid for it. Did you pay him back?
For the cruise and for Aruba, yeah, I gave him his money before we ever went on that trip.
You gave him cash before you ever went on the trip?
Mm-hmm.
Okay. And so when you got cash to pay him back on these trips, would you go to the ATM?
No, lady.
You would not go to the ATM?
No.
Okay. So Fulton County pays you direct deposit, I assume?
Did you get cash from?
Yes, Fulton County and the state of Georgia both pay me direct deposits.
Okay. So the cash that you would pay him, you wouldn't get it out of the bank?
I have money in my house.
You have money in your house. So it was just money that was there.
What's the source?
When you meet my father, he's going to tell you as a woman, you should always have, which I don't have, so let's don't tell him that. You should have at least 6 months in cash at your house at all times. Now, I don't know why this old black man feels like that, but he does. When I was growing up, my daddy had 3 safes in the house. So my father's bought me a lockbox, and I always keep cash in the house. Now, I don't do it to the degree that my father would do it, so he would probably be ashamed with me. I always have cash at the house.
Oh my
That has
God,
been,
this is well prepared.
I don't know, all my life. If you're a woman and you go on a date with a man, you better have $200 in your pocket. So if that man acts up, you can go where you want to go. So I keep cash in my house, and I don't keep cash as good in my purse like I used to, because I don't go on many dates. But when you go on a date, you should have cash in your pocket.
I would think she's on dates
So
all
my
the time.
question was, where did that cash
Everyone
originally
wants to
come
take her
from?
out.
If it came out of the bank?
cash is fungible. We've had cash for years in my house. So for me to tell you the source of when it comes from, when you go to Publix and you buy something, you get $50, you throw it in there. It's been my whole life. When I took out a large amount of money on my first campaign, I kept some of the cash of that. Like, to tell you, I just have cash in my house. I don't have as much today as I
like a drug dealer. She got all this
have,
cash
but
just hanging around
I'm building
her
back up
house.
now. So you just
That's
put
what her
money
daddy
in. It's a
told her
very
to.
good practice. I would advise it to all women.
So you can't identify when you came into this cash or where the cash came from?
I didn't say I couldn't identify it. No, nobody gives me anything. I am sure that the source of the money is always the work, sweat, and tears of me.
Work, sweat, and
What
tears.
you
I'm
asked
a
me
hard-working
for
woman.
is, when did the money go in there? What I am trying to tell you is, so I got divorced in 2005 from my husband. No, it's important. You said, where did the money come from? And I need to tell you where the money came from. And so for many, many years, I have kept money in my house. That money in my worst days has probably only been $500 or $1,000. At my best days, I probably had $15,000 in my house at cash. At all times, there's going to be cash in my house or wherever I'm laying my head.
The money that you paid Mr. Wade, the cash, in October of 2022, you do not know where that money came from.
I do know where it came from. It came from my sweat and tears.
You know which
fine.
job it came from. Did it come from Fulton County or did it come from a private job?
It came from, what are you talking about? So it could have come from a private job because before I was DA, I was in private practice. So I earned money during that time period. That's probably in there.
You don't
It
know
could have, what do you mean? I don't know where it came from. I absolutely.
understand the situation. We can move on.
Okay, thanks. Same with Aruba. You don't know where that cash came from either, right?
Ma'am, you are mischaracterizing my testimony greatly. I'm not going to allow you to mischaracterize my testimony. I know that I keep money in my house. The amounts of money I gave Mr. Wade, it was never that serious. I don't think I've ever handed him more than $2,500 in a reimbursement. So we're not talking about $20,000 in cash. I don't have $20,000 in cash right now. The most I ever gave him, I know I gave him $2,500 when we went to Belize because we went to one hotel and then we went to a second hotel. That $2,500 I actually gave him while we were still in Belize. I know that the Aruba trip, the one that you described with his mom, I think I gave him about $2,000 for that trip for like total.
His mom went to Aruba with you?
The Aruba trip. So I consider that to be one trip. So we got off of a cruise ship and then we went to Aruba, which is why I cannot remember is that the time that we had to stay in Miami to wait for the flight for Aruba. So I consider that one trip that we didn't like come back to Atlanta and leave. We flew down to Miami. We got on a cruise ship. We spent a couple of days with his mama. We came back to Miami. When we came back to Miami, either that day or the next day, we flew to Aruba. We spent a few days in Aruba and we came back. That was really one trip. Even though we went two places, it was one trip.
So let's talk about the California trip. Is that when you were moving your daughter out to California? When you all went, or did you have two trips to California?
My daughter doesn't live in California.
Did she ever live in California?
I'm not discussing to you the location of my child.
So how many times did you go with Mr. Wade to California?
Once.
And you all stayed in Napa Valley and he paid for the plane tickets and the hotel?
He paid for the plane tickets and the hotel.
And what did you pay for on that trip?
I gave him much less cash that time, probably $400 or $500, and then I paid for a bunch of stuff. I think we did 2 different wine tours that you do, which are pretty expensive. I think I bought him. He likes wine. I don't really like wine, to be honest with you. I like Grey Goose.
I'm gonna comment on this
I
later.
bought him a bottle of wine while we were there, and the sippings that you do. I can't remember how many, like 4 or 5 different places you go. I remember we went to this place that they do pairings. That was the most expensive thing that I think that we did while we were there. So they would pair champagne, chocolate, and
She's getting a lot more latitude than most would because she's
Sweden, Russia, someplace else. I'll make that up.
Few witnesses would get to know
That was
latitude.
the most expensive thing we did that trip.
Very.
And I paid for that.
You pay cash?
For us doing that?
Mm-hmm.
Yeah, that trip did not cost me a lot of money. I might have took like $750 in cash on me because we weren't gone very long.
I
I'd
only asked if you paid in cash. I don't even know the amounts.
When I travel, I always take cash.
And is the cash that you keep in your house, or do you keep it at the condo that you're living in?
So at that point, it wouldn't be at my house, and I'm sorry if I was not clear. The money would be wherever I laid my head. So I wouldn't leave the money at the house.
Feel you on that.
So if I was unclear, no, money's gonna be where I stay.
How much did you pay for your trip to Panama?
To where?
Panama, I believe.
I didn't go
I
to
may have the,
Panama.
I may have the location wrong.
I never went to Panama.
So after
Wade went to Panama with his frat brother.
Oh, he went to Panama with his frat brothers. So tell me about, let's see. So I want to make sure I've got them. I've got Belize. You already covered Belize. You covered the.
So let me tell you our road trips. In October, we went on the cruise with his mom. We got back from the cruise with his mom and we went to Aruba. I consider that one trip. Second trip, New Year's Eve, we went on a cruise to the Bahamas. That's the second trip. Let me make sure I get this right. Third trip, 100% on me. I think he might have spent $200 on that entire trip. We went to Belize. That was my trip. That was, his 50th. And then Napa Valley, we went around May. I don't know the dates, but it seems to me like it was close to Mother's Day.
And those are the only trips?
So that the record is complete. I can remember one time driving to, where were we? South Carolina, and we met my sister for lunch with her man. We didn't stay I don't know, but we didn't stay the night there. But I guess people would consider that a trip if you drive somewhere and you come back. That was insane because it was like 5 hours to drive. We ate lunch and we drove right back. I can remember driving to some little town in Georgia. I don't even know where I was. I had never been there before or after. There's some boat you can get on over to, and there's like a slave thing, if that gives anyone any reference. We didn't do that. I remember doing that. I remember driving one time to Charlotte. We had lunch with one of my very close girlfriends. And again, we drove to Charlotte, met my girlfriend for lunch, and drove right back. So that's a trip. We didn't stay the night there, but I just want to be complete in my testimony.
Jamal Bowman's not there.
Had lunch, drove back.
Where's Jamal Bowman when you need him?
Driving someplace distant for lunch and coming back to Charlotte to see a girlfriend, to meet my sister in South Carolina. We went by ourselves when I told you about that remote place in Georgia. We could have driven someplace else and had lunch and came back, but that's all that comes to my recollection right now. There could have been another place we drove and had lunch. My security team was very clear to me. I'm not to be out and about in Atlanta without them. And so for me to do something just very normal that a normal person would get to do, if they weren't prosecuting this case, I got to drive 4 hours to do it.
And that's what I was going to ask you. Your security detail, did they take you to and from your house?
So I haven't been able to enjoy my home.
Condo, I'm sorry.
Since March of
where you lay your head? Did they take you to and from where you lay your head?
99% of the time.
Would they take Mr. Wade to and from wherever you laid your head?
That has never in the history of ever happened, ever, okay?
Your security team has never taken him?
From my house? That's a lie.
I'm asking if they've ever taken him in.
And I'm telling you that that's never happened.
So your security team has never taken Mr.
My
Wade
security team has never taken Mr. Wade from any place where I have lived and brought him here.
For someone who skimmed through the papers, she seems to know about every freaking lie.
The two of you together?
Every freaking lie.
Anywhere.
We've left this building and gone to lunch, but I go to lunch so rarely that is a very rare occasion. I am sure, and let me be clear, it wouldn't just be Mr. Wade. So I'm sure my security team has taken me to lunch. Probably been a time I've left here 7 o'clock, gone to get something to eat. And I don't even know that they would have taken him or if he would have driven himself, but they've taken me to do that. But we're talking very few, very far in between. Most days I don't even eat lunch. And when I do, it's because my assistant has heated up some bag, something, and I eat through meetings and eat in my office. It's not a practice of mine to go to lunch.
During the time period that you were dating, would your security team ever take you two together anywhere?
No.
Never.
If there was a lunch that occurred that I just described, if there was a meal that occurred that I just described, anything outside of that, And it needs to be very clear. Not often, once, twice, because I want to be over inclusive. I'm saying once or twice. I'm not certain that it happened, but I'd rather be over inclusive with you.
So your office objected to us getting Delta records for flights that you may have taken with Mr. Wade.
Well, no. I object to you getting records. You've been intrusive into people's personal lives. You're confused. You think I'm on trial. These people are on trial for
No,
trying
you're
to
on
steal an
trial.
election in
You
2020.
are on trial.
I'm not on trial, no matter how
You are
hard you
on
try to put
trial.
me on trial.
So my
That's
question
what this is an evidentiary hearing. You are on
I
trial.
object to you getting any personal records of mine.
We're not dealing with privilege through a witness.
And I'm not, no, I'm not dealing with privilege. What we had offered to put them in camera for the court to review, and I just want to know if she has any
That's not
problem.
something to deal with a witness.
Okay, you have to file as part of your job something called an income and financial disclosure report, correct?
That's correct.
And you filed your first one, so you filed 2 today, is that right?
Is it 2 or 3? I probably would have filed 21, 22, and maybe I haven't filed 23 yet, because isn't it due like June of the next year?
April, I believe. So you filed, let's see, you filed your first one, it looks like April 15th, 2022, and your second one, April 17th, 2023. Does that sound familiar?
That I don't remember the dates, but you're an officer of the court. I'm gonna hope you're telling the truth now.
May I approach the witness?
You may.
Thank you. I already gave the state a copy, exhibit 20 and 21, if you take a look at those. They're part of the certified records that we got.
A lot of your
Somebody
commenting that the
yeah.
judge seems cocked. I will
Guys
admit
are getting a little old.
that he does seem to be obsequious to Fani Willis before she's Fani Willis.
Yes.
Okay.
Yes, ma'am.
And that
Those
is
are the ones that you
disconcerting.
filed.
This looks like me for sure. Yes,
The
ma'am.
reason she's acting so
Yes,
high and
ma'am.
mighty is because she's sensing that it's
Should we
working.
need to admit 20 and 21?
I think you need to delineate which ones. Which
20
one's which.
is
Because at this point,
2021,
it
so
seems
it accounts for
very
the
much
time period, Your Honor, January the 1st, 21 through December the 31st, 2021. That is Defendant's Exhibit 20. Defendant's Exhibit 2021, it accounts for the time period, January the 1st, 2022 through December the 1st of 2022.
I would ask
Any
about
objection
their
to
intimate
exhibits 20
relationship.
and 21
Nope.
Sorry.
from other counsel? Admitted without objection.
When did your personal relationship with Mr. Wade end?
Oh, here we go. Oh, end.
Our personal relationship ended in this year. So let's be very clear so that we don't mix words. I don't want to mix words in here. Mr. Wade is my friend right now. Mr. Wade, I would say, has been my friend since 2020.
That's why I hate the whole
I think he
personal
started
relationship.
out
I'm
as
so
like a
afraid of
mentor
saying
and professional
sexual,
colleague.
intimate. Just say what it is.
Became my
Personal is
friend and somebody
weird
that I
use.
really
Have a
respected.
romantic relation.
I feel very indebted to Mr. Wade for taking on the
Oh,
task of
crying
this
out
job.
loud. Here we go.
And he is certainly my friend and one of the people that I respect the most. So if you ask about a personal relationship,
So you're giving her a
I
chance to get
consider
on her
myself to have a personal relationship right now, Mr. Wade.
all over
I
again.
consider myself to have a personal relationship with Anna Cross. I consider myself to have a
Oh my
personal
God.
relationship
There
with
we
Mr. Abadi.
You see,
I consider
she's
myself
taking
to have
advantage of
a
the fact that
personal
you're being
relationship with Andrew Evans.
Okay, let me just clarify that.
I
Stop
have
it.
a
What is-
personal relationship with him
So
as
stupid.
we speak right now.
A romantic
I don't think that's what you're asking. I think that's what
romantic
you're asking.
relationship.
my
When did
God.
your romantic relationship with Mr. Wade end?
My-
Did it end?
Me and Mr. Wade, we are good friends.
Oh my God.
My respect for him has grown over these 7 weeks of attack.
Oh my God.
We are very good friends. I think, but for these attacks, it would have been a friendship that, as life goes, you would have stopped having. I think that you have
Who
cemented
cares
that
about
we'll be
that?
friends to the day we die.
Nobody cares about that.
Could we just have an answer to the question?
I can handle this, say that. Let's have it.
She asked about a personal relationship.
She asked when the romantic relationship ended. That's the question.
It's sometime in, I'd say late summer of 2023. So I don't believe me in.
Through the summer. He said
This is what
before
you're
the
really asking
summer.
about. This is the salaciousness of all of this, right?
He said
No, I'm
June.
just asking about your romantic relationship, when you stopped dating. I'm asking.
I think that me and Mr. Wade, so he's a man, he probably would say June or July. I would say we had a tough conversation.
Oh, I think she realized she got caught.
So that men in relationships at the end of physical intimacy, women in relationships when that tough conversation takes place.
And where, when
This was
did
totally
he come
collusion.
to, I guess, the condo, I'm not sure what you called it, condo apartment, would he come and stay at that condo or visit you there? I'm sorry, visit you there?
What condo, what apartment? I want to be clear.
So not your house. I know you classified one as house and one as condo, so I'm trying to use those terms.
So there's been more, see, what you don't understand is because of this case, I got to move. And so I
Ms.
need
Merchant, if you
to,
could ask a more precise question.
yes, please, give me the time period.
Mr. Wade visits you at the place you laid your head.
When?
Has he ever visited you at the place you laid your head?
So let's be clear, because you lied in this, let me tell you which one you lied in, right here.
God.
I think you lied right here.
I think you should.
No,
No, you should
It's
object.
not true.
No, you should object.
It is
It's not
a
relevant.
lie. It is a lie.
Ms. Willis?
You see.
Mr. Sayana, thank you. We're going to take 5 minutes.
That is
That'd be fine.
obscene. She should be chastised by the court. This is ridiculous. She gets like basically that was just what the hell's wrong with you?
May I go to the next one?
That was crazy. That was crazy. But she's enabled. She's enabled because no one is reeling her back and saying, what the hell? They started finally to say that was just like, what the hell is going on here? She's sitting here saying your thing is a lie. It's not your place to say as a witness. It's an interesting question. It's an interesting question. I don't know if it would be deemed relevant though. And it's the sort of thing which would likely, if it's not obviously relevant, it's the sort of thing which would aggravate the judge that you're trying to pry about something that's not relevant to his determination of the motion. So that I would not ask that question. It's very tough because you really want to ask, you really want to probe into, we all need to remember contextually what the objective is here for the move-ins. The objective is to show that she hired Nathan Wade for the purposes of enriching her boyfriend. That's what your objective is. So, a lot of you, I want to weigh in on some of these comments here, then some of these questions. So, I was asked if I had a pertinent question, what would it be? I'm telling you right now, I would ask a lot more about their physical relationship and the frequency of the phone calls. She didn't ask anything about the frequency of phone calls in 2020, 2021 to show that there was this growing relationship that led into November because the key date here is the date that he's retained by the state through Fani Willis, which is November 1st, 2021. So they met in 2019. You basically want to build up as to the level of intimacy of their phone call. Like, so when is the first time, did you get to a point in your relationship where you wouldn't go 3 days without talking to him? When did that start? Or texting him? When, things of that nature. You might not have been sleeping with him. So he wrote in his affidavit, we didn't start dating until April. All of a sudden, she's talking about like when a relationship starts and ends. And he says that, it's different for a woman than a man. That's what she just threw out there. It's different for a woman than a man. For a man, it's when the physical relationship ends. For a woman, it's when the there's that conversation. Okay, what about the start? How is he both came to the same start? Really? Is it the moment that you had the conversation? Is that like it was like some sort of like Disney movie that all of a sudden you just fell? There was a bed that magically appeared out of thin air, and the two of you just fell onto this bed of pillows and roses as soon as you had the conversation. That you both came up with the exact same time for the start. So I would ask a lot. I would find out a lot more about the physical relationship and about the level of and the frequency of phone calls, textings, and things of that nature that were leading into it. And I want to know how many times a week were they texting and or conversating with each other. If she went 48 hours during the main part of the relationship, without talking to him and not communicating, would that be unusual? Would that be common? That sort of thing, and sort of start tracing back to show that sort of level of intimacy was going back even earlier. So that's what I'd be asking. And I want to talk about this. Two things. Judge has to be seen through his obfuscation, and can someone be a more terrible witness? I want to talk about that and level of effectiveness here. Because even though she's coming across like a grade A biatch, which she is, even though she's coming across that way, that doesn't mean she's not doing enough to satisfy this judge, because we see this judge is deferential to her. We see this judge is not looking to reel her in, and he seems almost a little cowed by her. So that should be disconcerting. I'm just looking realistically as to the likelihood of this motion being successful. And we're seeing, and some of the things we're seeing about how he views Fani Willis is a little bit frustrating, because I'm seeing the same thing you're seeing. Okay? I'm seeing the same thing. She's acting like a bitch, and she's basically acting hostile and angry and defensive and like a bit of a crazy person. And I'll tell you right now, he's giving her a lot of latitude. Ashley Merchant has given her a little bit too much, has given her too much latitude as opposed to just reeling her down. Sometimes you want a witness to go on and on and on, but she's unlikely to be the type of witness who's going to say something that's completely stupid, because she definitely is more intelligent than Nathan Wade. It's not even close. She's much more intelligent than Nathan Wade, in my opinion, what we've seen of her testimony versus this. And she has her stuff all scripted. So do I think that she's full of crap? Yes. Do I think that despite her being full of crap, that she might not have given the judge enough here to hang his hat on to say, yeah, I don't know that they're really benefiting. Cash. We can't prove that he's being paid back cash. We don't know for sure. The burden of proof is on the move-in. And I don't know for sure that she's paying cash for money that she keeps around her house. It sounds like, I don't know. I'm not a woman. Maybe women do keep money in the house. I can totally see a judge, unfortunately, falling for that crap. Especially a judge who's looking to fall for it, because he doesn't really, because he's like, do I want to knock this attorney off a case? So, yeah, can someone be a more terrible witness as far as her personality and the way she comes across as being abrasive and a jerk? Probably not. That doesn't mean she's not effective. That's the difference there, especially if you have a judge who's looking for her to be effective, so he doesn't have to put in the uncomfortable position of telling this attorney to take off the case. Politically uncomfortable for him. So,
yeah, you go.
Thank you.
We're back on the record. Before we proceed, though, I advise everyone here, this being a room mostly full of lawyers who have spent their lives in a courtroom. We all know what professionalism looks like, what decorum looks like, and devoting ourselves to the rule of law and proper advocacy. I would urge everyone to keep those principles in mind, starting with the fact that we won't talk over each other. And from there,
see, this is cuckery. This is cuckery.
Thank you, Judge.
You don't say that she's being crazy.
How often did Mr. Wade visit you at a place where you were living between 2019 and 2021?
So you want to start with the lie that he lived with me in South Fulton in
See,
2019, a home he's never been to?
That's not part of the question.
One lie you told him you got.
No, objection. Objection. That's not answering.
Ms. Merchant, I want you to ask a very precise question. I think she's saying and answering that he did not live with her. So why don't we break that up into smaller parts?
I didn't ask about living.
But you put in your, while we're talking about
oh my God.
no, while we're talking
objection.
about professionalism,
Objection.
You put 3 different documents he lived with me.
Full opportunity to respond.
See, you should be shutting her up.
In 2019.
Ashley should be objecting.
He's never been to South Fulton. In 2019, I lived in South Fulton. He has never been to my residence in 2019, ever, not once.
In 2019, he's never been to your residence, any place.
I lived in my home in South Fulton before I started getting the threats that were here, a house I paid for with my own sweat and tears. I'm no longer able to live there. But in 2019, I did. And in the 2 months of 2019 that I knew Mr. Wade, 3 months, the beginning of October, all of November, and all of December, Mr. Wade never came to my house in South Fulton. Let me help you out. I lived there in 2020. He never came to my house in 2020, let alone live with me, as you put falsely in these documents. In the first 3 months of 2021, when I could still enjoy my home, Mr. Wade never came to South Fulton, and it is certainly a lie that he lived with me.
When did he come? When's the first time he came?
So in 2020, so you said 2019, 2020. Did Mr. Wade ever visit you at a place that you resided?
He has never been to my home in South Fulton. 2020 was before I knew that a phone call was going to be made and I was going to have to abandon my home. As a result thereof, he never visited, lived at, came to, or has seen South Fulton.
You qualified that with your home in South Fulton.
That's where I lived in 2020.
In 20, did he ever visit you at a place that you resided?
Okay, I don't understand you about to that. In 2020, I lived in South Fulton.
Okay.
That's the only place I lived in South Fulton. That's before I had to abandon my home, Judge.
All right.
And at my home in
We're
South
gonna clarify
Fulton,
this. We'll break it down.
he never came there, okay? So if you don't come someplace, you can't live there.
Ms. Willis, that's, I'm gonna have to caution you. This is gonna be the first time I have to caution you. We have to listen to the questions as asked. And if this happens again and again, I'm gonna have no choice but to strike your testimony. So we need to break this down. Ms. Merchant's question, I believe, was asking whether you lived anywhere other than South Fulton.
I did not live anywhere but South Fulton, Georgia in 2020. That is before I began my prosecution of this case, and it was my plan to only live there.
Did Mr. Wade ever visit you at the condo that you leased from Miss Yurdi?
He visited that condo, yes.
He did?
Yes.
Did you ever sleep in that condo?
Did he ever spend the night at that condo?
No.
Just visited?
Yeah, but he did visit for sure.
Did you ever go out to eat together, other than the lunches you talked about, during 2019 or 2020?
I would think that we probably went to lunch, but it wouldn't have been, let me think, 2019. I'm going to say, I don't know. I'm going to say we probably broke bread someplace in 2019. I don't remember it, but it seems like we would have broke bread sometime in 2019. So I'm going to say yes, although I have no recollection. But it seems to me like I go out to eat and drink with pretty much everyone. So I'm going to say yes.
So outside of the vacations that we've already talked about, did you ever go out to dinner?
I mentioned to you that
I'm going to object as to what time period. Like we're asking very vague questions. I thought we were treating the witness as hostile under 611. We're no longer doing that. So we're going to go back and
You can ask a hostile witness an open question.
We're
Shut
gonna
up.
treat her as hostile.
Sit down. Good.
All right, Ms. Merchant, it's not so much. I think you can elect between
Leading
and open-ended questions, but I think we are still wondering about, and I think we need to get back on track of focusing on the financial benefit or the relationship.
That is the
My
relationship.
Next question about
What
if
is
you
the
did go
relationship
out
if
to
not
dinner,
eating?
who paid when you went out to dinner?
He paid, I paid.
You both paid.
Okay, so let me be real clear. We didn't say, oh, the bill is $102. You give $51, I'll give $51. I don't operate like that with my girlfriends. I don't operate like that with anyone. He caught the bill, I caught the bill, whomever.
Did you ever pay him through Cash App?
No.
You only ever paid him through cash?
Well, yes.
Why not?
We're talking about, I'm very confused.
You've never
now.
given Mr. Wade money through Cash App?
No.
The only money you've ever given him outside of a contract is cash.
I didn't give him money in a contract, so that was cute, but I didn't give him money outside in a contract. What happened is, no, we're gonna answer it since you said it. He worked more hours than he was paid, and the county paid him for the work that he did. So don't be cute with me and then think that you're not gonna get an answer.
And I will ask you about the contract in a minute. I asked you about cash. Did you ever pay him anything? And I'm trying to qualify my questions. I'm not talking about the contract with Fulton County that was paid. I'm not talking about that. I'm talking about outside of that. Did you ever pay him anything other than cash?
I've only given cash a few times in the course of what we're talking about.
So you've
If
never
we
used
would
your
go to
credit card?
dinner,
Let her finish her answer.
if we would go to dinner, I wouldn't give him cash because he paid for dinner or I paid for dinner. I've given him cash only a few times in life, probably 4. Probably the most money I've ever handed him is $2,500. The least amount of money I've handed him, probably between $500 and $1,000.
You never wrote him a check?
Great catch there, Cash.
I don't have checks.
Okay.
Great catch
So you have
there.
no proof of any reimbursement for any of these things because it was all cash, right?
The testimony of one witness is enough to prove a fact.
So my
No, that's
question
not
was,
the
do you have
question.
any
That's
proof?
not
Is that what you're
objection.
insinuating right here?
Objection.
I'm asking if you have any proof that you.
Documentation.
The proof is what I just told you.
You have you have no
You have no
documentation.
written proof. Is that correct?
So I have some, probably some transactions like in Belize. I probably spent $500 on my card in Belize. I spent $800, I can't remember, $900 on each of our tickets to go to Belize. I did the $700. I probably got some minor expenses in Aruba that would be on a card. But for the most part, for those trips, other than, so the 2 cruises, I gave them money for those before we ever left. Because they were pre-booked. Let me answer.
Well, the question was if you had any written proof. And so
I've answered you that I've had written
we
proof.
can move to the next question. If you've answered if you had any written proof, and that was my question.
I want to make sure that we're clear that for the 2 cruises.
Oh my
God.
We're not going to talk over each other. Ms. Merchant, she answered your question, so
next question.
You can ask the next question. Ms. Willis and Ms. Cross will have plenty of opportunities to let you clarify your answers when it's
There
your
you go.
turn.
Thank you, Judge. Knowing
Most
your role
polite
as
way to tell a witness to
know
shut
that
up.
public funds are scrutinized and money is scrutinized and things like that. You understand.
I'm sorry, go ahead.
You understand you're under a microscope. You have reporting requirements, all of those types of things. You have no record other than your testimony of the money that you've given Mr. Wade.
You've already asked that question. Let's keep going.
When you took office, you had a tax lien of $4,600. Did you pay that with cash when you made that tax lien whole?
I probably paid through, however you pay.
Okay, so, but you were saying that you had amounts of cash. You still had that lien in 2022 when you were dating Wade and going on these trips. So the cash that you gave him, that could have been used to pay this tax lien off?
You gonna tell me how to pay my
I'm gonna
bills?
object. This is not relevant as it relates to why we're here today.
The credibility as to whether or not.
Are you trying to establish that she was insolvent in some way?
I definitely was trying to establish that she did not have these mass amounts of cash that she's talking about, yes.
All right.
Re-ask the question.
There you go.
You had a tax lien in 2022, $4,600.
Did you say I did?
And you did not use this cash that you had to reimburse Mr. Wade to pay that off, correct?
No.
Okay.
I went shopping too when I didn't pay it off.
And you talked about, you gave a lot of interviews to some authors of a book called Fani, right?
I would not characterize it as a lot. I probably have spoken to them 2 or 3 times.
My question is relevant as to.
I think it's already come up. Finances are discussed in the book. I'll overrule that.
Thank you.
Ms. Wilson, you can continue your answer.
What came up with Mr. Wade as it relates to hearsay.
Oh my
statements
God,
that he
shut
was asked
up.
about in relation to
No
what
one
Ms.
you've
Willis
lost.
may or may not have said in relation to an author. So it's not relevant to the testimony that's occurring.
It's relevant to whether or not she's
Merchant has said
cash
that
fluid, the way she
inside the
said.
book, she also makes a statement as to her own finances, and that's at issue.
So you gave interviews to the authors of this book, correct?
Once or twice.
Okay. And
just to be comprehensive, I don't know if it was 3 times, 2 or 3 times, I think.
you were quoted in the book, and I will give you a chance to say if this is a misquote. You were quoted, when they asked you about if you wanted to run for office for DA, you were quoted, "I really don't want to be financially effed up again." Do you remember saying that?
So what that refers to,
My question first is if you remember saying that.
I remember saying something similar to that, but I would like to be able to explain what that's in reference to. That's not in reference to anything else. It was a huge sacrifice to be district attorney in Fulton County, huge. I was doing just fine.
Exactly what I meant by
I had a municipal court
enabling.
judgeship that was paying me $100,000 a year, and like you got to show up twice a week. Easiest thing I've ever done in life. I also had private clients that were paying me to represent them. So I was able to have a law practice and that. Raising 2 daughters by myself, there were times in life where things were hard. And so
Questions have
I
to be
was
way
telling people,
tighter.
I don't really run for DA. I don't want to run for DA.
Right.
I'm in a good position right now. I got this easy job that I enjoy, being the chief judge of the
Oh,
city
yeah.
of South Fulton.
Here she's on her
I'm
cross.
making money
Oh, here
at,
she's on her
the
cross.
law firm.
They
And
made
I'm
me
not
do
sure
it.
that I want to make this sacrifice. And why does it always have to be me?
Oh,
Eventually,
I'm
I prayed.
persecuted.
I think that I
Oh,
was
I'm
the
so
appropriate
persecuted.
person. I think
Oh,
that
this is
I
so
did
rough.
that. So when you're referring to that, what I'm saying is, why should I make a sacrifice again? And what I was not talking about is being district attorney. Once you get elected district attorney, you're in a fine financial position. I make over $200,000 a year. What I was talking about is I ran for judge.
So
When I ran for
untainted.
judge, I took $50,000 of my personal money out of my retirement. And that money ended up being lost. And I know when you bet on yourself, you're going to have to bet money on yourself. And so what I was talking about was not wanting to go through the personal financial expense of running for office. By no means did I think that I was going to be financially in a bad position once I won. Let's talk about what I was up against, because it's important to understand that comment. I had a district attorney who had been here for 24 years. No, this is it's very relevant as to what my mindset was about this. So I'm trying to answer your question. So what I was saying is
Taylor, still into finance.
right, but it is about my finances. If I didn't, nobody put me in this seat. So I had already run for office once. I had spent $50,000 of my own money running, and it was vamoose, nothing. And so when I'm talking to those offers, I'm talking about the contemplation of the sacrifice of the run, not the sacrifice of once you become DA. The odds were against me. I was likely going to lose the election based on who I was running against. So that needs to be in the appropriate context.
Isn't it true that the authors also wrote, and you can dispute this if you'd like, that you were broke after that race?
The 2018 race.
Yes.
Yeah, that was a hard race. I wasn't
She's
broke
flush
like
with cash
I didn't have any.
Pay him off.
So broke is relative to depending where you are, but that hurt to lose that $50,000. So I'm sure my mental mindset was like, I just gave $50,000 away.
Right. So they characterized it from their conversations with you that you were broke, you had poured your own money into the campaign, and you weren't able to pay your own bills because of your clients couldn't pay their bills to you, and you had a paltry array of family and asset forfeiture cases. It says you were trying to make it month to month. Is that an accurate depiction of your financial situation at that point?
I would want to read that, but I don't remember clients not being able to pay their bills or.
Yeah, registration.
You can't.
You may.
Page 30.
And this is all getting into her cash fluidity, which she says that she was keeping stacks of cash around the house, which is why she didn't have to go to the ATM to pay off $2,500 in cash to Nathan Wade.
So like this back here, her ex-husband Fred had run into a financial. I have no information about
I didn't
that.
ask you about that. I just asked about if what they represent from their interviews with you, that you were broke and that you had clients that weren't able to pay their bills.
Can you show me where that is? Because this is where you put the tab, so that's where I read.
Broke, couldn't pay their bills.
Yeah, I'm sure I characterized myself as broke as leaving that $50,000. I don't know that I had her nascent law practice at paltry array.
Well,
I didn't have.
Ms. Merchant.
I thought I had a law practice. So this is not correct. I'm sure it's just, I didn't have any asset forfeiture cases. So I had one case where they had took one of my clients' money at the airport. I don't know if that's what they're carrying. I don't know. Paltry array. I did have family law cases. I guess that's what they're talking about. And clients who couldn't pay their bills ain't clients. So no.
So my question was just if this was a fair and accurate representation where it says you were trying to make it month to month at that point.
No, I don't think that is actually a fair and accurate representation, but I am certain that after the 2018 election, I'm still
Hopefully
not really happy about having
better.
that 50,000.
I don't like the way Ashley
You know when you paid your tax on?
I don't.
You don't? You know if you paid it?
I know I've paid some taxes. I don't know. I don't want to speculate.
Did you tell anyone at Fulton County Board of County Commissioners about your relationship with Mr. Wade?
No.
Did you disclose your relationship to anybody at Fulton County?
No, I don't think so.
And as the chief law enforcement officer of Fulton County, I assume that you're familiar with the county code and ordinances?
I've said we're not going to cover that in this hearing, Ms. Merchant.
I'm sorry, Judge?
We said we weren't going to cover the county regulations.
Okay, and I won't. Let me ask you this then. So are you aware that you're required to disclose any relationship with someone that you contract with in Fulton County?
I'm going to object to the court fire ruling that you made this morning.
Would this be different because it's a potential for impeachment?
Yes.
Oh.
What did you ask me?
Ms. Merchant, if you could re-ask the question.
Okay. Are you aware that Fulton County requires you to disclose any relationship with someone that you're doing business with?
I'm not aware, and I know often that things are confused with state constitutional officers in county, but I'm not aware.
Okay, so it's your understanding that you don't have a duty to disclose the relationship?
She's answered that question. Let's keep going.
Did you keep track of this cash that you paid him? at all?
What are you talking? I don't understand.
Did you keep track? Did you keep a ledger? Did you keep track of it?
So I've only given him cash, as I mentioned, 3 or 4 times. There's no ledger. This is friends handing money off to each other.
So the answer is no, you didn't keep
And I think
track.
you've already asked whether there was any written proof whatsoever, and she's
Yes.
answered that.
Okay.
So we've covered this. Let's move on.
Ashley's running out of questions.
Who were you referring to when you suggested that Mr. Roman's motion to disqualify was racially motivated?
We already said we're not talking about the forensic misconduct that's been alleged.
And
And just so the record is clear, I don't believe I said that his motion was racially motivated, so I don't want that to stay there. I've never said his motion was racially motivated, so that should not be
Lois,
true.
I think it would be best if we don't need to go down that road. We're going to save that for argument.
You once said that you would not engage with a personal relationship with anyone that worked for Fulton County. Is that correct?
An employee?
Anyone that worked for Fulton County.
I think I said an employee.
Okay. So that's the qualification you give an employee? You wouldn't.
I think that's the statement that I made, so if you want to quote me accurately.
So it's your position because Mr. Wade was not an employee, or it's your position he wasn't an employee,
It's not
correct?
helping
Mr. Wade
you.
is not an employee, and he
That's
will
not
tell you that over and over again.
Just one moment, Judge.
Ashley, you got Sadao there. He's gonna fill in.
I'm
I
sorry,
have
the
something.
statement, just so I make sure I accurately quote you. What you said was you won't sleep with people who work under you. Do you not consider Mr. Wade working under you?
I consider Mr. Wade to be an agent.
An agent?
Yeah,
All right.
an appointee is what I really
I just want to hear about it.
think of him as.
Your point, whatever merit it has, Ms. Merchant, is on the record. Next question. All right. Do we need any moments in a minute? Mr. Sadao.
No, I'm ready to go, Your Honor.
All right.
There we go. This is Trump's attorney. All the other attorneys you're going to hear asking questions, that's from the other co-defendants. That's from co-defendant Michael Roman. This
I'm
is
going to
Trump's
try to ask
attorney.
you questions that you can actually answer without having to explain, okay?
Yes, sir. My comprehension skills are pretty good, so we should do all right.
We shall soon see.
Good.
If I heard you correctly, you moved into what I will refer to as the Yurti condo in either March or April of 2021. Is that correct?
Sometime between late February and April, yes, I don't, just so we're clear, yes. But in that time period, you're in the ballpark. We're in the ballpark.
And is that Yurti condo, would you say that it is in Hapeville?
It is in Hapeville, yes, sir.
And you moved in there for safety reasons?
My father, yes, I moved in there. We were concerned. My father was terribly concerned about me continuing to live at the house. And so that we're clear, people came to my house at 5:00 in the morning about the police brutality cases, saying I was going to have a wake-up call. There were security threats due to gang cases, and there were concerns due to that was at the very beginning of this, looking into that.
Oh my gosh, stop filibustering.
All of those reasons
It's
and what
yes.
was happening, my father wanted me out the house and
Stop with the
begrudgingly I
filib.
left.
Oh, Jesus.
Okay, so the answer to the question was a yes for safety reasons, correct?
Those were all of the things that caused the safety concerns. I'm
I'm
sorry.
not questioning whether they are or are not safety concerns. I just asked that you moved into this condo,
Good.
Yurti condo,
Right.
for safety reasons, right?
Yes,
At the time that you moved into the condo,
Good. This
be
is
it
how you
from
read something
February
in the
to
witness.
April of 2021,
yes,
was your father still living in your house?
right, because my father,
That's
yeah,
all I ask you.
but I get to explain the answers.
No.
I don't know if there's an explanation. If I ask you, was your father still living at your house? The answer is either he was or he wasn't.
Yes, but you are going to get to argue at the end of this, as we both
I'm
know.
not gonna argue
And so
anything.
I
I'm
would
gonna
like to
ask-
be able to explain why.
I'm
No,
gonna-
So,
okay,
yes,
no,
Let's move the strike.
because my father is an older gentleman, he was worried about COVID and he stayed.
Ms. Willis, I'm going to have to say that's the second time. Whenever we have to put a pause, stop testifying, okay? You'll have a chance to explain yourself. The question was whether your father was not staying there at the time, and you're clarifying that in your answer as well. You can have a brief clarification, but it shouldn't be something that reaches well beyond the question.
Why are you gonna
All right, Mr. Sadao, we can re-ask the question. We'll
answer?
see where it takes us.
Okay, thank you. was your father still living in your house at the time you moved to what I would refer to as a Yurti condo?
Yes, sir, he was due to his concerns related to COVID.
Okay. The safety concern was that there was potential danger at your house. Is that correct?
Yes, my address had been exposed, so yes, there was concerns about potential
So,
danger.
no
at my
worry
house.
about your
Okay, so anyone staying at your house in the time period after you went to the Yurti condo was still in danger, correct?
Yeah, well, no, he did.
I think you have to, it's your attorney, Ms. Willis. Sorry, Mr. Bott, your objection is speculation
Yes.
to the question of
Speculation.
whether someone was still in danger at her condo.
Just let her answer the question.
Or Mr. Sadon wants to rephrase.
No, yeah,
I'm not
I
sure.
was able to
I've got
understand it.
I've got the objection, and then I have.
It's not your ability to understand it. It's what the
So, and I
ability
don't remember
to
the question,
answer
so I can answer it.
based on factual knowledge.
You can now that the objection's been withdrawn. Can you try to answer that question?
Yes,
Was there still a safety concern
I was.
for people staying at the house?
Yes, I was very concerned about my father still living at the house. However, if you have dealt with an older gentleman, he was not leaving the house despite my urging him that I thought he should leave as well. He did not want to
What
leave
does
the
that
house
mean?
because he was particularly worried at his age about COVID. But that became I don't want to say I was not happy with that decision of my father's, but I can't ultimately make him leave, and he stayed there too long, in my opinion.
Okay, thank you. During that period that you left to go to the Yurti condo, did any of your children stay at your house?
So I don't think that they were there at that point. Certainly my baby wasn't there.
I'm talking about this entire period. We're talking about, if I remember correctly, and you'll correct me, I'm sure, you said that you stayed there at what I would call the Yurti condo until January of 2022, correct?
Yes.
Okay, so I'm asking you in that period, which would be February to April of 2021 until January of 22, did any of your children stay at your house?
And you don't have to yell at me. I'm able to understand. So I would ask you to not yell at me.
Oh my
That
God.
being said,
Stop
I
the
don't
attitude.
actually expressly remember, but I can tell you, since I have left my home, there have been times my oldest daughter came in, but I can't tell you with certainty the time window that you said, if they did or not. So I don't want to speculate to that, but there was some time that my oldest daughter came back. Whether it was that period or after I left the Yurti residence, I'm not sure, okay?
Okay, so if I continue to go into more detail on this, you're not going to be able to give me an answer of whether or not, in fact, any of your children were still at the house or stayed at your house during that time period, correct?
What I can give you clarity of so that we are clear is from the time I moved out in February-ish of 2021, after I left there was a time period that my oldest daughter came back. But if you're asking me, was it in that window or after, I just don't have a recollection of that because, the kids come and they go. And so I don't remember the specific time period, and I apologize for that.
Did your children ever stay with you at the Yurti condo?
Like maybe a night, like for a girls' night or something, but live with, no.
Okay. Did anyone else stay with you at the Yurti condo, including Miss Yurti?
Never. Miss Yurti never lived in the condo. She met her husband and they moved. They weren't quite married, but they moved. Nobody ever lived with me in the condo. That was
my word was stayed, not lived. Stayed with you at the condo.
I guess I don't understand the distinction, but no one ever.
Just moving in.
My baby's
It is
my oldest
nice.
child. I think she spent one night with me, maybe my oldest and my youngest. But I think that whole time I was in that place, other than that one night, I don't think anyone ever, this was a very lonely period in my time. Like, I don't think anyone ever spent the night other than maybe one night. I remember a picture of my baby sitting on the couch in that place, and I'm thinking she spent that night. But just a very lonely time in life.
Okay, we'll stay with the lonely theme just for a minute. Did Nathan Wade visit you at the Yurti condo from the time you moved in until he was hired on November the 1st of 2021?
Good question.
So I moved out of that condo, but during that time period, I'm sure he came to visit.
Alone?
He came to visit. I can remember us going, I think the restaurant's lickety split. I can remember him picking me up, going to
Oh,
lickety
you go
split,
to restaurants.
ordering some food, and coming and sitting at my table and eating.
Oh!
So I remember times that he visited me at that
House.
condo. Yeah.
Okay, could you give us an approximation of how many times Mr. Wade visited you at the condo between the time you moved in and prior to November 1 of 2020?
I don't think often, but I don't want to speculate.
Can we say more than 5, more than 10?
I'm gonna tell you the problem I'm having here.
Tell us. I want to know.
Let's say more than 10, but I'm not sure that that's even accurate. He certainly has come and picked me up, gone and grabbed some food to eat. I don't remember him being in that condo a lot.
That's a relationship. You're in a relationship. He's thinking about
I'm
10 times
sorry.
for dinner.
You want a number, and what I don't want
You're
to
giving me your current and best recollection is all I'm asking for.
That's all I can give you. Sir.
That's a relationship.
How many times
You
did
in a
any of the
relationship,
prosecution team, how many times did Anna Cross come to that condo between the time you moved in and November 1st of 2021?
I don't think Anna's ever been to that condo.
What about any other prosecutor that's involved in the prosecution of this case?
I don't think any of them have.
Oh,
Just
so he's-
Mr. Wade.
That's correct, sir.
Oh, there we go. This guy's
It
good.
was a lonely time.
Nice.
Oh my God, that 2021.
Oh, yeah.
I have a lot of guilt about this time period in my life. Let me tell you why. But yes,
that
it
I
was
was
a lonely
good.
time. I was very appreciative to the citizens for giving me this responsibility and this duty. But what I very, very quickly learned is that this is a very isolating job, and 2021 was a lonely time. I turned 50 in 2021. That's probably one of the worst birthdays I've ever had. I spent it alone. So I have a clear recollection of 2021 being lonely.
Okay. Did Mr. Wade ever come visit you at the condo, the time period I'm talking about, prior to November of 2021, when Ms. Yerty was at the condo?
So Miss Yurdy and me, we didn't share the condo at the same time,
So the answer would be no.
but we never stayed there together. So it's an
Oh, I'm saying-
impossibility.
It's an impossibility.
Yeah.
Okay.
Now, Miss Yurdy, because we need to get clarification on this. Miss Yurdy stayed in that place. There may have been a time that me and Mr. Wade visited, like went and saw Miss Yurdy, but me and Miss Yurdy never lived there together. Just so we're clear.
Well, maybe that was clear, but I'm going to have to try again.
Okay.
Was Ms. Yerty still living in the condo when you moved in?
Not a day.
Okay. So what I'm talking,
misrepresentation in this. We never lived together. I
Not the
never
whole-
lived with Miss Yurdy.
But this is
my
not
question though, I'm trying to
a
understand
witness for once.
that after you moved in to the condo, Ms. Yerty she was out of the condo, right?
She got a house.
That's all I'm asking. She's not in the condo.
We never stayed,
Okay.
Miss Yurty and I
Move
never
on.
stayed
Okay.
a day
Answer.
together in the condo.
Got it.
All of her stuff was out of the
Oh my
condo.
God. We got
and all
it.
My stuff,
We
some
got
of my
it.
stuff, not all of it, obviously, was moved into the condo. So we never stayed there together. No, sir.
All right. So when I asked you about Mr. Wade visiting the condo, when you were staying there,
Yes,
Ms. Yerty wasn't staying there, correct?
that would be correct. Yes.
She wouldn't be at the condo, correct?
No, she would not have been.
It would be you and Mr. Wade alone at the condo, correct?
Yes.
That is, there weren't any other witnesses to Mr. Wade and you at the condo, correct?
Yes.
No security, none of your security detail.
Would object. She said it was just her and Mr. Wade.
You made your point, Mr. Sadow. Let's move on to the next one.
Yes, Your Honor. Who in the prosecution team prior to, I guess, the motion being filed by Defendant Roman, who in the prosecution team knew of your personal relationship, and now I'm talking romantic, with Mr. Wade?
So, sir, I am extremely private.
All I ask
No,
you
no,
is
no,
who
no.
knew. It's not, the answer is no one knew, that's fine.
No.
I ask you who knew.
You answer,
me just tell
answer
you
it
this.
and then explain this, Willis.
I am very private. When I supervised Mr. Body and Mr. McAfee, they didn't know who I was dating, but I can assure you I was dating somebody. So that I kept something private, that's my private life, is not any mystery to anyone.
Nobody.
It's like a woman doesn't have the right to keep her private life private. And I'm speaking on this because there have been all these intimations.
You still haven't answered the question, Ms. Willis.
I'm sorry, what was the question, then, Your Honor?
Is there anyone else who knew about it? And then you can explain.
I don't know. I don't think so. I certainly didn't go out telling my business to the world.
Okay, so the best of your recollection, you didn't inform anyone on the prosecution team that the individual that you had chosen to lead the prosecution team had a personal relationship with you.
So
is that correct?
That's inaccurate. Your question is inaccurate.
What?
Because you stated that the person I chose, we had a personal relationship. So we had a friendship. We have all these distinguishing factors. Remember, when I chose him in November of 21, first of all, let's get this straight. Mr. Wade was not actually my first choice. That's no insult to him. No, it is you because of the way you phrased the question. You said, when I chose him, I didn't inform people of a personal relationship. We have defined personal as romantic. It is an inaccurate way to state the question.
And I will certainly restate it so it is very accurate.
Okay, and please do not yell at me.
No.
You hired Mr. Wade for the first time on November 1st of 2021, correct?
November of 2021, yes, sir.
Your testimony is, whether one accepts it or not, your testimony is that at the time you hired Mr. Wade, there had never been a romantic relationship with Mr. Wade before you hired him, correct?
Yes, my testimony is that we were very good friends, but we're talking about a sex, so let's just don't.
No, I'm not talking about, I'm saying romantic relationship doesn't necessarily have to be just sex. It can be dating, it can be holding hands, it can be any of those things that one might call romantic. I'm asking you whether or not prior to November 1st of 2021, there was a romantic relationship with Mr. Wade. It's very simple. It's either a yes or a no.
You're the one who made
I don't consider my relationship with him to be romantic before that. I'm not a hand holder, so no.
That's fine. Now, let's move beyond November 1st of 2020, 2021, excuse me. If I understand your testimony, there was no romantic relationship with Mr. Wade until early in 2022, whether it be January or February or March, early in 2022, correct?
I would say sometime between February and April. Yes, sir.
All right. Now I'm asking you about that time period when it became romantic.
Yes.
Okay?
Thank you.
Okay. You didn't see the need, if I understand, to tell any of the people on the prosecution team when you had established a romantic relationship with Mr. Wade that the lead prosecutor, that is the man that was basically giving orders to others, was dating or having a romantic relationship with you, correct?
I'm going to object to relevance at this point, Your Honor.
Relevance?
Just to prove or attempting to show that there is an issue on the credibility about the relationship. The failure to have informed anyone on her team that she was having a romantic relationship with the lead prosecutor, I suggest gives rise to that inference. That's the relevance.
The inference that
they were concealing this because it was not as it's been characterized to the court, and that in fact it started earlier than what they say.
All right, overruled. Mr. Sadon.
I just want to make sure that we're clear. From at least 2020, me and Mr. Wade were friends. At least that time period.
Okay, I'm not talking about.
So no, I want to be clear because my credibility is being evaluated here, right? We were friends. We hung out prior to November of 2021. In November of 2021, I hired him. I do not consider our relationship to have become romantic until early of 2022. Because I don't know a date and time, I'm saying sometime between February and April of 2022.
So it's just semantics.
And very early April of 2022. Because I know that the trip that I discussed with you was like the first week of 2022. that the relationship had become romantic. I hope that answered your question, but I can't have it where
Say he wasn't married.
we're saying something
You
different.
weren't romantically
All
involved.
right, so you established the timeline as you put it. The question originally was, at that time, did you tell any other prosecutors?
I never tell people at work who I'm dating.
All right, Mr. Seda.
Okay. Did you take any trips to DC with Mr. Wade?
Never.
Did you take, okay, so you have no, what I would call personal trips or business trips to DC with Mr. Wade?
I never went to DC with Mr. Wade, personal, business, otherwise, never.
Okay, so.
I've never been in the District of Columbia with Mr. Wade or Maryland, Virginia, the DMV as they call it.
So as I understand it, to be clear, any trips that you would have taken to see DC
That was a pretty clear answer.
Huh?
That was a pretty clear answer.
Well,
She just said no.
twice.
So you have a variation or something new to bring up.
I'll ask it and we'll see. Did you take trips to DC that were non-business during the time period that this case or this matter was under investigation?
I'm going to object as to relevance as it relates to the matter that we're here before Your Honor.
Well, again, the question already asked is, did you take personal or business trips? She said.
But that was with Mr. Wade. That was with Mr. Wade. This I asked her alone
Not with
whether
him,
she
and how's it
took.
relevant?
Okay.
What's the relevance?
And what would be the relevance of that?
I tried to understand whether or not we have the ability to show a personal trip in which Mr. Wade is there at the same time. I understand her answer. Okay, I understand her answer, but we have documents, we have records that.
How do you show her that? Use the documents.
Well, this could be something that's maybe not part of the record yet, but if he has I think there have been other things discussed in this case, and they have evidence that Mr. Wade may have been in DC at the same time. If you want to ask about that exact specific date, Mr. Sadon, you can do that.
I would reference to the court that that was not asked of Mr. Wade.
So?
Anything about any trips to
So?
DC.
So what? You don't
And
have
so
to.
that's going to
Who
limit
cares?
its merit and
What is
impact
stupid
and
objection?
credibility. So Mr. Sadon, ask the question.
So
I understand your testimony is you never took a trip to DC with Mr. Wade,
that's correct.
personal or business.
That's correct.
Were you ever in DC at the same time as Mr. Wade?
I was not.
On personal or business?
No, me and Mr. Wade have not been to DC at the same time. However, since Mr. Wade has been on this case, he's been to DC. Since Mr. Wade has been on to this case, I've been to DC. What has not happened is we have not been in the District of Columbia at the same time. Now, the only thing I'm not sure about with what you asked me is if I've been to DC personally, because I got a lot of personal friends in that area, but I know that I have been to DC. I did an interview at Howard University.
Right.
I went to DC for that.
I question the credibility
Seems
of
like I've
her
been to
having
DC one
friends.
other time. Oh, I went to DC for the Global Summit. Actually, yeah, those were two separate trips.
My next question is based on her opening the door, and therefore I'll just ask it and Your Honor can decide whether or not it's appropriate. When you went to DC, did you go to the White House?
Object.
I did not go to the White House.
No, well,
Apparently, I'm going to get the answer anyhow.
there you have it. Next question.
Okay. You indicated your best recollection was that your relationship with Mr. Wade, the romantic relationship, ended, you left it in August of 2023. That sound right?
That's the hard conversation. That's not the,
We've covered this. Next question.
And you characterized it as a tough conversation, correct?
yes,
I'm not going to get into the conversation per
we
se.
should.
Well, if he doesn't want to, we won't go there. So Mr. Sadon, next question.
You know, it's kind of hard to say no when you've got that opportunity. But all I'm going to say is, was it pre-indictment in this case?
So,
We know the timeline that the indictment was delivered. Well,
but,
actually,
and so that
I'll
we're
give you
clear,
that.
the
Okay.
physical relationship ended pre-indictment.
And is that when you were talking about the tough conversation?
But I'm not sure that the tough conversation didn't happen until after, but the physical relationship, so I'm sure if you ask Mr. Wade, because he's a male, he would say we ended June or July, because physical contact ended then. Just in my mind, being a woman, it's over when you have that like hard conversation. I just think women and men think differently.
And I think the answer, Mr. Sadell, to your question was she's not sure whether it was before or after the indictment.
Well, I'm not sure that was her answer, but let's see if I can get specific.
That is what I said. That's what I said.
I'll let you, next question, Mr. Sadell. If you need to
Want to say
clarify.
one more? The romantic relationship ended before the indictment was returned, yes or no?
I don't know.
To a man, yes.
Well, to a man, yes. To you, no?
She's explained this, Mr. Sadell. She's explained this.
She said she doesn't
And
remember.
did the forthcoming indictment have anything to do with that? Or was it just a coincidence?
Mr. Let's go on and have the conversation.
I've just asked you whether or not it was a coincidence.
Had absolutely nothing to do with this. It's interesting that we're here about this money. Mr. Wade is used to women that, as he told me one time, the only thing a woman can do for him is make him a sandwich. We would have brutal arguments about the fact that I am your equal. I don't need anything from a man. A man is not a plan. A man is a companion. And so there was tension always in our relationship, which is why I would give him his money back. I don't need anybody to foot my bills. The only man who's ever foot my bills completely is my daddy.
Is there anything else you would like to add to that?
No.
Sure.
I'm sure we'll talk about it further.
No, we're not going to talk about it further.
All right, no back and forth, Mr. Sadell. Next question.
My next question is something that that has to do with what I've characterized as the church speech. Let me just tell you what the question is, because I know that's not something.
Preserve it for the record.
Huh?
You can preserve the question for the record, but then we'll move on.
That's correct. Thank you. When you gave what I've referred to as the Martin Luther King weekend church speech, you know what I'm referring to?
A great honor of mine. That's a historic African-American church. Yes, I do.
Okay. Did you have handwritten notes with you that you were reading from during the speech?
And on second thought, Mr. Sadell, because you might have a number of questions about this, why don't we just bullet point what you would want to cover on this, preserved for the record, and then we'll move on to the
You're
next
not allowed
topic.
to ask about her publicity. That's
Okay.
what he said. He limited
Laid out
your
before the forensic misconduct.
the extent that she used
Do I
this
not get an
to
answer for
make
that?
herself
That's
famous.
right.
He's not allowed to
Did
ask
you
questions.
read your speech?
Well, no, Mr. Sadell, for everything related to any forensic.
Oh, you just want me to stay out of it now?
We're just not, we can do it in a bullet form if you just want to cover what you would have asked, but it's not in a question and answer format.
Okay, so I should do that at this point or do it
Sure.
when you're ready?
We can do it right now, so it's fresh on.
I'm going to ask her about, did she prepare the speech? Did she have notes on the speech? Did she read the speech? When did she do this? When did she write the speech? Who was she referring to when she was talking about others? Who was she referring to when she said they? Who she was referring to when she spoke in terms of their, that is.
I would love to answer those questions.
Well, Ms. Willis, you could certainly do that in some other format, but for today, that's what we decided we're not going to cover.
Who was she talking about that was playing the race card, and why she didn't tell people at the church that she had had a personal / romantic relationship with the, all due respect, the way it was characterized, the black man that she was referring to, and was the black man she referring to, was that Mr. Wade?
Okay.
That's that area of inquiry.
Noted for the record, Mr. Sadell. Next topic.
Okay.
Yeah, the judge wasn't going to let him do that.
I realize that you testified that you have no records that with regard to cash payments,
Yes.
correct?
Mhm.
Would your bank records reflect that you withdrew cash from your bank accounts during the time period of 2020, 2021, 2022, or 2023? I'm not asking you, I'm just asking whether they would reflect that you withdrew cash from any of your bank accounts.
So the exact amounts?
No, just
But yeah,
that you did.
Of course, I withdrew money throughout that time period, throughout my life. I withdrawn money from the bank. Yes, of course.
Talking about cash from, that is that you go to a
Cash,
bank
right.
or you go to an ATM
Cash.
and you take cash out.
Either that way, or you go to Publix and you overpay, or you go to another store and you overpay. So yes, both through that, yes, of course they would reflect that at times.
Okay, and so those records, if we had them, would show
Right.
that, correct?
that throughout the course of my life, I took out money?
I was very specific. I said
Yes, during the course of
2020.
that time period, I would have taken money out, yes.
So do you have a problem with?
I absolutely, yes.
You don't want the bank records to be made available for the court and the court
I'm
alone?
going to object as to the relevance, and this has already been addressed earlier as it relates to other records. This is an improper line of questioning. He's doing it for the purpose of harassment. Right, Your Honor.
I'm just going
Called badgering. Lawyers call
Mr.
badgering.
Sarah, if that's something you want to follow up privately, you can do that.
Last area, briefly.
Yes, sir.
You had contact with Mr. Wade in the year 2020, correct?
Ooh, I had some contact with Mr. Wade.
Would you explain when you say some contact? Please tell us, talking about 2020.
I had some contact with Mr. Wade in 2020. One of the reasons your allegations are so preposterous, or Ms. Merchants that you have joined, is.
Ma'am,
No,
I didn't ask you about the allegations. I asked you about your contact. That's all I ask you, okay? I appreciate that you want to say something, but I'm interested in, did you have contacts with Mr. Wade in 2020? And your answer so far has been yes, correct?
Very limited contact because Mr. Wade had a form of cancer that makes your allegations somewhat ridiculous.
And I do appreciate the
I'm not going
characterization.
to emasculate a black man, but I'm just telling you.
I'm sorry, what?
I'm not going to emasculate
What?
a black man. Did you understand that?
Oh, you would have.
Well, I don't think we should
Back on
discuss
track.
further.
Mr. Seda, next question.
Trying to, Your Honor. Would you tell us on the occasions in 2020?
White man, I'll be happy to try emasculating, but black man, no.
Contact with Mr. Wade.
I'm sorry, I thought I had answered that. Yes, sir. There were times in 2020 I had contact, but 2020 was a year I was running for office. It was a year that he was going through some serious medical issues, and I did not have much contact, but I certainly had contact with him in 2020.
Did you go out to eat with him?
Maybe, probably.
Did you visit him in any location, his office, or did he visit you in your office in 2020?
I am sure I'm sure, ooh, that's a very good question. I'm sure he came to 750 in 2020.
750
was my office.
Okay.
Not often, but maybe once or twice. Maybe I went to his office once or twice, but maybe once.
And the purpose for going to his office would have been what?
Maybe we would have went to Mellow Mushrooms for pizza, or
I'd give
maybe he
this
would
me
have come
too.
for lunch. I'm sure we went by each other's office though, but not often, not a lot. We both grinded, trying to make a living.
I understand what you've said about the cancer, and I'm not going into that. But when you were going out with him to restaurants, or when he would come to your office, right? Those were not sterile environments, were they?
Oh, very sterile, because it was.
The restaurants were sterile environments?
A lot of times we wouldn't eat there. We would pick up something and go in, but they were.
I'm listening to you. You pick up and take it to where?
Very sterile.
Maybe eat at our office, but it did not happen much. That's what I'm trying to explain to you. And my office in 2020, nobody was coming in. I was stir crazy, so I would still go into my office. You remember when I started this, I said, I am not even sure if we came to each other's offices, but I am trying to be over cautious. So I think I can recall him at 750 a couple of times. I just think I can recall him at 750 once, but let's say twice. I have seen his office. I remember all the awards in the lobby, but I'm not sure in 2020 I went. I'm not even sure I went in 2020
He's won
at
all
I
these
just wanna
massive
tell you,
awards.
Yes, because I'm not sure.
Won the Golden Key
But
National
I have
Honor
a
Society
distinct
Award.
recollection of him at 750. I actually don't have a distinct recollection of me at his office in 2020, but maybe I went to his office in 2020, maybe.
Did you have ongoing phone conversations during 2020 with Mr. Wade?
Oh, yeah, I talked to, yes, absolutely. Yes,
Yes, no question about that.
no question. I talked to him on the phone in 2020.
I understood, and this is, maybe I was confused. The Belize trip was for
His 50th birthday.
his 50th birthday, and that was in
March. He turned 50 March 18th, 2023. If you look at the dates of the trip, I think we were there about 6 days. We stayed at 2 different locations.
and you paid for it.
100%. He said, not only, I paid for the hotel, I paid for the flights, I had a birthday luncheon for him, I paid for massages, I paid for everything.
And would those payments be reflected
Deshaun
on your
Watson
credit
type
card?
massages?
You paid them in cash?
So liberal are you?
Cabs. I was telling you all the different things.
I'm asking you whether or not those payments would be reflected on credit card bills of yours.
So there was about $500 that I think is reflected on a debit card. What my recollection is, I took about 4 in cash with me to that.
400 or 4,000?
4,000. But I remember I handed him 2,500, and then the rest was just the money we spent. I probably gave $300 or $400 to this guy who was a taxi driver. He would drive us every day around the 2 or 3 days we went. Took him to eat like it was my trip money.
And you had, to be clear, to end this up, the 4,000 that you've just told us.
But I didn't give it all to him. Remember, I only gave the 2,500 to him.
I didn't ask you that. I was going to ask you that 4,000 is part of your, my words, cash hoard that you had collected over time.
Cash what?
Hoard, H-O-R-D-E.
Oh, I thought you said something different, sir.
No, I'm afraid I wouldn't say that under any circumstances to you or in court.
All right, back on track.
So hoard, cash hoard debt.
I would not classify it in that way, but I have money at my house. Yes, sir.
And the money, when you had money at your house,
But I was speaking too loosely. I had money wherever I was staying. So I was not referring to my house in 750. I'm saying I had money wherever I was laying my head. Yes, sir. That was my fault that I wasn't clear.
so when you were at what we said, the Yerti condo, during the time period we've always discussed, that's where you would keep your cash.
When I stayed there, yes.
Okay, that's all I have. Thank you.
Where'd you hoard your cash?
All right, now let's see if we can get through a few more defense counsel possible before breaking for today. Mr. Stockton.
Sounds like they're gonna break at 5 o'clock.
Madam District Attorney, I'm Alan Stocks, and I don't think we've had the pleasure of meeting.
It's a pleasure to meet you, sir.
Madam DA, you described these various trips, and Mr. Sadow asked you about going to Washington. Did you and Mr. Wade go to New York?
I've gone to New York.
Yeah, they're with him.
I've gone to New York twice since I've been district attorney. I'm trying to think if it's 2 or 3 times. I went to do a domestic violence thing there for sure. And I was honored, and I went to the Apollo there. Those are the only 2 trips that come to mind. I went. He was not with me.
You also said that he was a world traveler and had been on many of the continents.
I've been to 6.
Have you been on any of those continents with him?
I'm excited about the 6 continents.
Besides this one?
Where's Belize? What continent is it? I'm not being funny. I don't know.
Let's say with the
I've been
exception of.
to Belize with him. I've been to the Bahamas with him. I've been with Aruba with him. Don't embarrass me. I'm not sure what continents those are on. Whatever continents those are, that's where I've been. I'm sure if I gave it some thought, I would tell you. But whatever continents those are, that I've been to those locations, sir.
But not Australia or any other continents?
I don't even want to go to Australia. I do know he took a trip in December to Australia. I have no idea, I don't know anything about that trip.
When Mr. Wade began working with your office,
Yes,
he had 2 other gentlemen that worked in his firm with him. Is that correct?
yes, Terrence Bradley worked for him, and Chris Campbell worked not for him. They worked with each other.
Did you understand what their partnership arrangement was?
No.
Did he ever make you aware of how fees were divided or anything?
No.
Now, since you have been district attorney, the 2 gentlemen that worked with Mr. Wade and his firm, they also had contracts with your office. Is that correct?
I probably had
I don't know if we've covered this in Ms. Willis, but I still don't know what the relevance would be of her testimony to this.
But I've had about 10. Oh, I'm sorry. Do you want me to answer?
Let's
or
figure
no?
this out.
Judge, respectfully, I think based on Mr. Wade's testimony, he had an interest in those contracts.
Sure. And then, but how's that been imputed to Ms. Willis?
I don't know if whether or not she knew she was giving him that benefit. That's what I was trying to explore.
Okay. Well, maybe we can start with that question, and then if she doesn't know about it, then the ins and outs of all the contracts wouldn't be quite as relevant.
Just to lay a foundation for that, though,
Let's see where it
respectfully,
takes us. Go ahead.
The two gentlemen that were in Mr. Wade's office, did they have what I think's been referred to as a taint contract?
So let me be clear, and I may get the names wrong. When I first became DA, the office was not properly staffed. And so I'm surprised any lawyer would take it, but I did a contract for like $60 an hour to help us out with first appearance. That lasted a few months. Okay. So I can't remember if Bradley or Campbell had that. I'm sure we can have records and I can tell you which one, but I just can't remember now. I liked their experience. Bradley had been a probation officer and a defense attorney. Campbell had been a police officer and a defense attorney. There's a reason I'm telling you this. Then that contract, like I said, it didn't last long. It was just, I was aggressively hiring. As soon as I got where I felt like I had first appearance, enough lawyers for that, I let them go. Then we had what's called a filter contract, but it was not filter for this particular case. I do have a lawyer who does the filter for this election interference case. When we're talking about filter, the contract they had that neither one of them has any longer, I now have another lawyer that does that for me. It was only for police brutality cases. It's for what I call the, so when I first got to be the DA, I had, the whole unit was called anti-corruption. It dealt with both elections and police brutality cases. I actually took a trip to Houston and visited the district attorney in Houston. They divided their work up, and I thought the way she was doing it was better than me. And so I made a civil rights unit. And so they did what we would classify as civil rights cases. Those are specifically the police brutality cases. When I first took over, I was told Paul had not filtered 5 cases. That was a joke. It ended up being the 101 cases. They weren't filtered, which is why I hired 2 of them. Eventually, we got it down enough that it was one of them.
I'm the only people on the planet I can find.
Now I still have one lawyer that does it.
The only ones I
I've been
can
able
find
to cut those cases down to like 30.
My boyfriend's partner.
Can you tell me help me understand what the purpose of the filter is?
Yes, sir. So what a filter is police officers make statements in the line of duty, and you are not allowed as the prosecutor to know what those statements are if they're done in the furtherance of their employment. And in fact, if you know what those statements are, you're basically disqualified from the case. You can't have it anymore. So what our policy is, I think I pay them like a $50 flat fee. They pick the case up directly from the GBI because that's where those cases go to. And then what they are to do is to go through the entire file. So the body cam, which is important because sometimes they'll make a statement to their supervisor on body cam, in the police reports where they write things. It would be easy if it was just some statement of the police officer, but what you find out is these statements are embedded in it. And so what your filter lawyer does is they go through it, they either redact it out electronically or they cross it out. And then once it is crossed out, then they provide it to my team, and then we're able to look at it. That was not being done appropriately when I became district attorney. I thought that it had only been, so Mr. Howard had some Chinese wall thing that I didn't think worked at all, where
Chinese walls where
those cases were properly redacted. That ended up being a joke. And so the 5 cases really turned into, I'm not going to say all 101, but a vast majority. That is the work that Mr. Bradley and Mr. Campbell did for me. They did a really good job. All of those cases that we originally came with, they're done. Those cases they're not just done for Mr. Bradley and Mr. Campbell, they're done through my office. But obviously life is not stagnant. There have been new police cases. I do have a lawyer that is doing that work now. That doesn't work for me. That's same kind of deal. I have another lawyer that does filtering for this case, completely separate.
So in the same private office, you had a filter contract, then you had somebody else handling first appearances and so forth, and then you had a special prosecutor. Is that correct?
I'm just not. Ultimately, the answer to your question is yes.
I only hire
but
black
I'm not
people.
sure that they did it at the same time.
Very limited in my
The first
choices.
appearance contract was
I only hire black
60 or
people.
$90. I don't know really how I convinced them to be able to take that, but I think because it was for such a short amount of time. And then I think
burden
I
was
paid
so
my
great.
filter lawyers, which I still don't know how I get away with,
me.
about $150 an hour. And I want you to understand, the AG pays special prosecutors $1,000 an hour. So I'm a tough negotiator. Paul was paying people up to $375 an hour. I won't pay anyone more than $250 is my max. I have a lot of lawyers for what I have that work at $250, and I cap every month. You can't go past a certain amount of hours.
Would you agree that if Mr. Wade and the two other gentlemen that were in his firm were splitting fees in equal thirds, would you agree that he would benefit from the tank contract and also from the other first appearance contract?
I would agree he would make money. Yeah, so to make money is a benefit.
Just a thought, guy.
Mr. Jerem, if you're still with us on Zoom.
How that came.
No questions, Your Honor.
Mr. McDougald.
I do have a couple, Your Honor, but it's a little awkward from back here. Do you want me to?
Yeah, why don't you go ahead and make your way up?
We haven't seen this guy yet. We don't know who's lawyer.
How you doing?
I'm very well. How are you, Mr. McDougall? I think this is our first in-person meeting, correct?
Second.
Second? Well, I apologize for not remembering you more clear.
That's quite all right. I'm referring now to exhibit number 21,
Yes, sir.
which was your financial disclosure form for 2022.
Not sure.
Yes, sir.
And it has a question which requires you to disclose any gifts or favors from a single prohibited source in the aggregate amount of $100 or more. Do you see that?
I don't, but I believe you.
It would be on page 2 in the middle, paragraph number 3.
Yes.
And what is your understanding of a prohibited source for purposes of this form?
I believe there's some classification of somebody you like don't have a personal relationship with that gives you $100.
All right, if you look under there, it's subparagraph 2, Romanet 2. It defines it as someone that you know or should know is seeking to do or is doing business with the county, correct?
Yes, but yes.
That includes Mr. Wade as of the date you filled out this form, correct?
Yes, but he never gave me a gift of $100 or more. The only thing that I would say maybe went over that, but I don't think it ever did, is if we went to dinner and my meal was $100, but I don't think I've ever eaten $100 worth of food at a restaurant, because I would not pay him back if we went to lunch or went to dinner. But trips I paid him back for, I never thought about the money until y'all brought it up. And I would be less than honest that says I was giving him the money back because I was the district attorney. I didn't take gifts from him.
Nice.
For a lot of personal reasons. Anyway, I did not take gifts from him.
And so your reason for not disclosing any gifts from Mr. Wade on exhibit number 21 is that the aggregate amount on a net basis was less than $100 in the year 2022. Is that correct?
Total amount for the year.
I did not accept a gift of him of more than $100 in 2022. The one exception to that, because I want us to be clear, is we probably went out to eat multiple times in the year. If you're considering eating a meal, because we went out multiple times, that probably went to the level of more than $100. But if we're doing tit for tat like that, I probably paid for as many meals as he paid for. And so I did not receive any gifts
He's
from
a
him.
business associate, and
The
it's
question on the form,
if he's a
I understand
boyfriend,
the
in
question.
aggregate in excess of $100, and your testimony is that you did not receive in the aggregate more than $100.
All right, Mr. McDougal, you can sit down now.
I don't believe she answered that question, Your Honor. She answered as to specific individual gifts.
And you're not listening to my answer either, so we're done.
Very well.
Okay, Mr. Rice,
No further questions.
Mr. Gillen.
I don't know why I disagree with the judge now. That's the first real call that he made. Look, I hate the way he handled this witness in general. He was a cuck. But
Good afternoon.
Good afternoon, sir.
as far as making a call,
A few questions here. I want to, you saw the book here, Find Me the Votes. That was shown to you, correct?
Yes, sir.
Your Honor, I would like to just tender this as an exhibit, number 22.
Is that your copy?
It is,
All right, what exhibit is that going to be?
22.
All right.
I'm making the
Is that,
evidentiary contribution here to
Yep.
this. Now,
well,
says
so
he-
you're tendering it, is it with position of the state?
Then objected to the relevance at this point as to, we haven't, there's no relevance at this point.
Mr. Gillen, are you using this to confront her with prior statements?
yes, Your Honor, and statements that she made concerning her financial situation and laying the foundation for that, and that she gave these interviews to the authors. And so this would document that. Don't ask her, get this in the record, ask her questions about it.
Well, we could mark it for impeachment purposes. I'm a little wary of entering an entire 300-page book because I don't know exactly what every single
how many
line
lies
or
are in there?
past Hearsay or relevance or.
How do we know
et
how many
cetera,
lies?
but
Oh,
I don't think it needs to be admitted as an actual evidence for the record for you to do what you need to do with it. So
Well, Your Honor, I understand. I just would,
it's marked as
again-
exhibit 22, and we'll move from there.
thank you, Your Honor. Now, you were asked a little bit about this book before, correct?
I think Mrs. Merchant
Ms. Merchant did.
asked me some questions, yes?
And you gave about 6 interviews to the authors of this book in a sit down?
No, sir.
You didn't? And
No.
Was it,
She answered how many interviews she gave in her opinion.
how many, in your opinion, do you believe you gave, and how long did they last?
2 to 3, maybe 20, 30 minutes.
So your testimony is at most, you think that you gave maybe an hour to an hour and a half's interview to the authors of this book?
Oh, you mean in total?
In total, yeah.
Maybe, yeah. Anywhere between, definitely not more than 2-ish hours.
Okay, but you also were telling, when they were, the title of the book, of course, is A Hard-Charging Georgia Prosecutor, a Rogue President, and the Plot to Steal American Election. You've
Why is the title of the book relevant, sir?
And I had no,
And then I'm going to ask her whether or not that was the theme that they gave her when they talked with her.
What the thing gave her, what do you mean by that?
Well, because they were sat down and they told her why they were there to interview her.
And why does that matter?
Well, I think it matters because it shows, but they want her to give her version of what her life story is. This is almost a life story of her. So that's why it's relevant. But if the court thinks it's not, then.
No, it could be relevant to your issue of the forensic misconduct that has been alleged and maybe some of the motives at play when it comes to forensic misconduct. But I'm not seeing, again, what we're here for today was the relationship and or any financial elements of it.
Correct. Well, I think it clearly relevant to the forensic misconduct, also relevant to personal interest in terms of the finances.
I didn't make 10 cents off that book.
Pardon me?
I didn't make 10 cents off that book.
Didn't ask whether you made any money.
Okay, I just,
Didn't ask whether you made any money.
Do you have any other statements that she hadn't already been confronted with by Ms. Merchant?
Well, other than, I want to focus on when you were telling them about your financial straits and you were living kind of month to month, that is what your financial status was back in 2018 after your election.
Mr. Gillen, we covered that at length. And you're at the end of the line. I'm sorry about that, but we've got to find new ground.
Well, let me move on to my point here. So the point is that what you're telling us is that you were in financial straits, but really that your testimony today is you had a cash hoard of maybe up to $10,000 in cash where you laid your head at night so that you would dip out and there would be no record of it, correct?
That's not what I'm telling you, sir. That's not at all what I'm telling you. What I'm telling you is that throughout the course of my life, I have always kept cash in my house. That cash has ranged from times, my father would probably be ashamed of this because he would say it should be more. But that cash at times has ranged from $500 to maybe $9,000. And he would be like, that is not what I told you to do. I've always had that amount of money. What I've told you is that when I travel, you do better negotiating when you travel. If you have cash, you go to get the cab. They say, oh, we're going to charge you $300 for the day. Well, I got American cash. Will you take it for $150? And so it's my practice to take money when I travel. We're not talking about a whole lot of money. We're going to the Bahamas. $1,500 in cash is in my pocket, or at the most $2,500. Belize was actually probably the most money I've ever taken. And it was taken because it was a big deal. My 50th birthday sucked. His 50th birthday, it sucked. It was terrible. No.
Your Honor,
And
I'd
so
like to get back to some questions here.
I'm trying to answer
Rather
it.
than narrative.
It would help if we.
So let's
Good question.
move to the specific yes or no's here. Have you told us today that you would keep a cash hoard in your residence up to about $9,000? Yes or no?
And throughout the course of my adult life. And so let's even be more specific than that. Probably from the time.
Your Honor, I'm only asking for yes or no rather than speak.
And we have already covered this, so I
But yeah,
think
but
to get
I'm
to that
trying-
point.
I'm
I know
trying
you're laying
to
the foundation, but it's already been laid. So
Yes.
The filibuster is here. I'm trying to move through the filibuster.
Yeah, but we're not talking about a lot of, and so it could be 2,000, it could be 1,500, it could be 7,500. It just depends on what you're doing at that time. What I'm telling you is when I traveled, I took cash. I find that when you travel, especially to foreign countries, the American dollar does well, and it's good to have cash. You can negotiate with the taxi driver, with the jet skis, and it's not a lot of money we're talking about.
Your Honor.
Okay,
we
understood,
need
Ms.
to-
Wells.
we need
Let's
to
get
cut
to-
off the
Let's get to a
narrative.
question, Mr. Gill.
And so you have cash in your house, but you had a lien, a tax lien on your property, is that right?
I don't believe I had a tax lien on my
You
property.
didn't have a tax lien on your property?
You gotta talk about it, Mr. Hunt.
Cumulative, Your Honor.
Okay, we already covered that, Mr. Gillen. I need new ground here.
I'm asking the question, I'm trying to figure out how someone can have a tax lien,
Then ask that question.
but not use the money that they allegedly said they had.
Judge doesn't like.
I think Ms. Merchant asked that exact same question, since you didn't use the money to pay your tax. So what's your question? It's new.
So I was going to build on that to say,
No more building. It's already built.
all right.
It's the same way you pay a bill.
So just put
It's
the
a-
top on it if you need to,
It's
okay?
the same way you owe a bill and go shopping.
Well, now, have you ever did you say earlier that you used Cash App?
When I would pay Robin Bryant, I used Cash App.
What is Cash App for the record?
I don't need to know that for the record. Let's keep going.
Well, so if you're paying Robin with Cash App, why aren't you allegedly paying Mr.?
There's no alleged here.
Why aren't you paying allegedly Mr. Wade with Cash App?
I don't think Mr. Wade does Cash App.
Did you ask him?
I think he's told me he doesn't do Cash App.
Okay, so that's the reason why you didn't use Cash App,
He's sitting next to me. I hand him the money.
because there would be a record in Cash App of your making payments, correct?
Yes,
Sure.
but I didn't think that I was making a record in a personal relationship.
Because when you're filing and I know that I'm going to move into this financial statement here. You were asked just a second ago about your non-disclosure form, or your disclosure form of an Exhibit 21, where we agree that Mr. Wade is a prohibited source, correct?
What I agree to is, I don't believe he's giving me gifts. You would like to classify these trips as gifts, but I've always paid my fair share on these trips, so I did not look at them as gifts. I don't think that what this is disclosing, and they can tell me if they mean something different, I don't think it means that if you go to dinner with somebody over the course of a year and it gets to 100, you're supposed to report it. If my understanding of that is wrong, I've probably been to lunches with a couple of people that over the course of a year, they paid, I paid.
Prohibited source means.
We already went over this, Mr. Gillen. Mr. McDougal.
Well, Your Honor, I have to lay the foundation here before I can follow up with my next question.
I don't know why you have to.
Well,
It's already,
okay,
questions have been made.
Then your 2022 disclosure form did not list any of the thousands and thousands of dollars that Mr. Wade paid for on trips that you were on. Isn't that correct?
That's because Mr. Wade was paid that money back, or he was paid due to the fact that I bought the plane ticket or I paid for the hotel. There were never money that he gave me. That wasn't the nature of our relationship. You know, there's so many men, and Mr. Wade is one of them, where the nature of the relationship is they're just paying a woman. The nature of our relationship is companionship and friendship. Despite the way people would like to paint certain women, it's just not true.
Final question. And not a single solitary documentary piece of evidence showing that you have withdrawn the cash to pay him back.
That's not accurate.
Thank you.
Okay, Mr. McCullough, on behalf of Mr. Floyd. All right, and Mr. Cromwell on behalf of Ms. Latham.
Great thing about coming last is, I had one question, Ms. Willis, can you hear me?
Yes, sir.
In the time period between February 2021 and January 2022, while you were staying at the Yurdi condo, did your father ever come and visit you during that time period at the Yurdi condo?
He did not.
That's all I have. Thank you, Ron.
All right, Ms. Cross, I would imagine you have a number of
Let's do cross
topics to
tomorrow.
cover with Ms. Willis that'll take more than 10 to 15 minutes.
I did.
Okay, then I think we've reached a stopping point for today. And so, Ms. Willis.
Back up tomorrow morning, 9:30.
Now, and I also remind you that you're not to discuss your testimony or that of anyone back here. And we'll begin again at 9 a.m.
9 a.m.
9 a.m. We'll do 9 a.m. this time tomorrow.
9 a.m.
Before we recess for today, I want to check in on logistics, and I'll ask Ms. Merchant.
He really wants us to wrap up tomorrow.
Once the testimony of Ms. Willis is concluded, how many other witnesses do you anticipate calling?
And then we subpoenaed Delta records, the state objected.
We can handle that now. Ms. Willis, you can step down. You're done for the day.
You want me to leave the courtroom?
Or you can sit at the council table. We don't need you in the witness box. All right, so 2 witnesses, and then querying other defense counsel. I know Mr. Gillen, there was a potential witness that was objected to by the state, so there's another one there. And we can talk about that. Were there any other witnesses anticipated from any defense counsel? All right, seeing no show of hands, and then Ms. Cross, any witnesses on your behalf?
I expect so, Your Honor, and I expect that to take 4 to 5 hours.
Okay, and how many witnesses would you imagine?
Without committing myself to a final number, my best guess at this point would be 3 to 4.
Okay. All right.
And you know who, I mean, I gave them our witnesses. I know we're supposed to give witnesses for an evidentiary hearing. I'm guessing that one is John Floyd, but I don't know anything else.
All right. No, I understand, Ms. Merchant. However, I don't think at this point there's any statutory requirement. We have the standing order that, for expert witnesses, and if state doesn't want to extend that courtesy, then I think you're stuck with it. All right.
I'm certainly happy to represent that Mr. Floyd will be a witness, that the other witnesses will be impeaching of Ms. Yurdi.
Okay. All right. Let's take up these last couple issues here before we break. Then the issue of the Delta Airlines records. The motion to quash was filed by the state on behalf of Mr. Willis, I believe.
I didn't file a motion, Your Honor.
Oh, excuse me.
But my representation was that I just got notice of them, I think it was yesterday.
Okay.
And so now that I've had the review of them, I object to the general fishing expeditions. I've introduced a new record today that was from Delta. To my knowledge, that there's going to be no further new production in the Delta records. I don't want to burden the court with anything. If the court wants to take a look at it and see if there's anything
Sweet.
different
See you
than
here
that,
tomorrow.
I don't have an objection. I don't like the idea that we're just looking for anything. And I don't want to put an obligation on the court, but I'm happy to agree to it in camera if that's
And so, Ms. Merchant, I take it.
Tomorrow, 5 points.
All right. So, Ms. Merchant, I take it the purpose of this subpoena.
On Martin Luther King Jr. Drive Southwest.
I need you to step out.
Step out, man.
Judge, the purpose is to show travel records.
Right. Is it because you suspect there are other travel records, or just you think there might be something else in there?
It's, well, one is to prove some of the travel records that they traveled together. And so we have no problem, like I told the state, putting them in camera. I don't even do.
I mean, what I'm saying is if we've heard about the trips today in detail. Is there anything else that's in these records that you're saying is going to prove some additional trip, or is it just further corroborating what really is kind of uncontested at this point?
There may be some additional trips.
But you don't know of any specifically. You
No,
just
I
think
do
there
not
might be a
documents
few.
back.
Okay. All right. Well, then let's continue with that. Then, if you want to send them or instruct Delta to send them to us in chambers, we'll take a look. And I think essentially, if there's, you can tell us, Ms. Merchant, what you think we should be looking for and what you think is relevant, and we'll do that.
Thank you.
Okay. All right. And then when it comes to Mr. Schaefer's witness, there was an issue raised about this kind of being a summary versus an expert witness. And so I reviewed the motions, and I think there was the essentially kind of the summary document that Mr. Gillen's witness would, the sole purpose of this witness introduce. Was there something about, I don't know whether it's from Mr. Abadi or Ms. Cross, was there something about this attachment substantively that you think is inaccurate, or is it literally just a summary document?
I can't tell because the documents to support it were on a thumb drive and there's tens of thousands of those documents. And so I don't know whether that is accurate or not. I can point to some characterizations on it that I would quibble with.
Sure.
I think the result is wrong, but I just can't agree to include the documents or someone testifying from the documents that I just can't verify. It may well be that there isn't anything ultimately, but I can't represent that and I can't agree. The document itself isn't authored or identified as being authored by any particular person.
Okay, give me a second while I pull it back up.
Thank you.
So what I was provided by Mr. Gillen is a 3-page document. It starts with a timeline, usually dates, events, and sources. And it ends with an Excel sheet with some more figures. And Mr. Gillen, what do you have to say on this?
Or we would tend to call Bill Sawinski as a summary witness, not expert, not giving expert testimony. And what we've done is that we have, and we got the bulk of sort of what was in the download we got last week as a chamber team. So what we have here is the source information over here. If we look at that, Your Honor, that's largely, all of this information essentially is material that is material of Mr. Wade's. This isn't something that's some different company or bank account. And largely what it is a situation where, and as it now stands, most of these source documents are already in evidence. And so, whether it's 1006 or frankly a demonstrative aid under 611.
That's what I was about to say. Why couldn't this just be used as a demonstrative? What would the state's objection be then if Mr. Gillen was just to say in closing, hey, I put all these records together, and here's my demonstrative?
I don't think I have an objection to that. I might quibble with some characterization and some language.
Sure.
But to call it a summary and to represent that the records is an accurate reflection of the records, I just can't agree to because there's so many records they were disclosed on Wednesday, and I just don't know.
Well, except, Your Honor, if you look at the sources, I mean, literally, we're describing things that were introduced today. They've seen all this. And
No,
the
she's
documents that we have sourced really came from Mr. Wade.
Arguments.
So it's not like they're surprised. So we would ask that the witness be allowed to testify and just put it in the record and put the summary charts in the record and have them admitted. And that way, off we go. This isn't a situation where we have a jury and, they're overwhelmed with whether or not there is some kind of factual misunderstanding here. They could look through this probably at lunch and determine whether the source is accurate or not. The second sheet, Fulton County payments, that just came from them. So to say that they can't determine or decipher whether the documents they gave to us is accurate doesn't seem to carry the water. This isn't a situation where we have tens of thousands of new and different documents from different corporations and different banks, and then suddenly we've put it on them. We've done our best. We got these things last week. I've gone through them all, and we've called it down to what we think is a very concise summary charge to the board's consideration.
All right, so Ms. Cross, what I would ask is, it sounds like most of the morning is likely going to be taken up with the remainder of Ms. Willis's testimony, as well as any additional witnesses from Ms. Merchant. And so perhaps we can use that time between then and then the lunch break to take a look and see if these sources are inaccurately cited. I mean, the characterization isn't something that's going to be determinative. I don't think I'm bound by whatever he describes as the event. But if this is just, I really don't really see much of a substantive distinction between a demonstrative and a witness. But if he wants to put it up through a witness, and it's not something that you need to rebut with expert testimony of some kind, then I really don't see this as being much ado about nothing.
I'm sure you can understand why I couldn't agree.
Sure, no, that's fine.
Without having gone
But I don't know if it's something that we need to bar outright until you've had a chance to look at it, if you see some incredible inaccuracy in it or something like that. All right, anything else from the state?
No, Your Honor.
Anything else from defense counsel? Mr. Let me go in order. Mr. Sadow.
One quick question. I understand the court and the bullet point where I was going to go. Do we need to put into the record the speech itself in the transcript, or is the court taking notice from what we've already filed?
I think it's extensively quoted in all of the pleadings. If you feel that's something that we need to have officially recognized, I think certainly we can do that. I don't know if the state has a particular version or a pleading that they want to double check for accuracy.
He's referring to the speech
or it can just be something that's
that
assumed as a
Fani
matter
Willis
of law
gave in church, which was
pleaded
how
by
prosecuted
defense
Ian
counsel, and then
and
you can
Nathan
make a
Wade.
ruling on it from there. But
There's certainly no certified transcript that I'm aware of. If they want to give me the version that they believe to be accurate, then I'll certainly take a look at it.
okay.
I have a USB that my paralegal downloaded onto a USB drive to take it home.
All right, and that's also not something I think we need to have done by tomorrow. I'm not going to be ruling on. Yeah, I mean, I'm not ruling on any of this tomorrow. I mean, this is something that's going to be taken under advisement on all aspects. So the forensic issue we can bring up, and we may need to bring everyone back if everyone needs an extensive, not even extensive, but if everyone just wants to be heard in argument in some way, we probably not have time for that tomorrow either. So my hope is perhaps we can just close the evidence tomorrow, and we'll
I
take it
think
from
that
there.
people are going to want to have argument, and I've already requested, depending on how busy the court reporter is between now.
Yeah, the answer is they're all busy, and we don't have enough of them. So
I don't know. This court reporter was giving me a potential of a reasonable time period, but is that what you just turned over to Ms. Cross? Does that also have a transcript, or is it just have the video?
It's a video, the USB video. I believe that's all it is. But
again, I think that's something I'll just wait for direction from the parties on. I don't think that's something we've got enough to deal with tomorrow, and I think we can handle that as it comes once we've had a chance to take a look. Okay.
So no arguments on the motion.
I doubt we're going to reach it if the state has 4 to 5 hours of witnesses. And
That's not just a question of preparation.
yeah, I don't think that's going to be needed. Okay, Mr.
Your
McDougal.
Honor, just a very short housekeeping matter. You ruled on Monday, you didn't want to hear any evidence about the county ordinances and so forth. The statute 24-2-221 requires that they be put into evidence as opposed to being cited as law. So before the defense evidence closes, I would like to tender certified copies of those. I don't need a witness for that. And then I've got one other certified copy that I want to tender. I don't need a witness for that. So that would just be a little mechanical thing right before the defense evidence closes. Your Honor.
Understood. Any thoughts from the state on that? Okay.
As a representation, if that's what the exhibits are, then I'd consider it a proffer more than evidentiary, but that's fine.
Okay.
I think I want to upset the court's expectations tomorrow when I get.
Okay. Well, Mr. McDougal, my expectation tomorrow will be that when I talk, I get to take prominence, right?
You're the boss.
Thank you, sir. Okay. Anything else?
Not from the state, Your Honor.
All right. Nothing, Your Honor. We'll be in recess 9 o'clock. Thank you all.
All right, there you go.
Sorry.
If you're done. I have a lot to share with you, and you're very welcome, Stephen. Thank you for the, I appreciate your gratitude. Okay, so I have a bunch of things I need to share with you. First of all, we will be back tomorrow at 9 a.m. and I'll be covering day 2 of the trial of this evidentiary hearing. It's not a trial technically, it's an evidentiary hearing. So but there's a bunch of things I need to explain to y'all, questions that you guys have asked that I want to answer for you with respect to what we saw so far today and in preparation for walking into tomorrow. So I'm going to start with this. What do these questions have to do with the Trump case? So in case any of you who are unaware, just to explain to you, this is a motion to have Fani Willis and Nathan Wade and their respective offices, meaning including the district attorney's entire office, removed based on there being a claim that this entire prosecution against these defendants, and it was Michael Roman's counsel, Ashley Merchant, the blonde woman, who brought this motion first. Trump's attorneys signed on to it on behalf of Donald Trump. And there were a whole bunch of bases that they laid out as to why it is that they must be removed. And they're basically saying that they're interested parties and that this is against the interest of justice. Now, we need to just sort of break that down a little bit here. The law in general is very concerned about the appearance of impropriety, which you would think would lead to a fairly low threshold that, hey, look, if we have bases to assume that there's impropriety here, or even the appearance of impropriety, that's a basis to say, get them out of here, right? I mean, that's essentially what we'd be saying. There were a number of bases. The bases that were incorporated in the moving papers included that she's using this to gain her own fame by citing 38 different interviews she did, and for her book, and all these different arguments. And the only one out of all the arguments that were put forward by the movements that seemed to move the judge at all was the fact that this personal relationship that she has with Special Prosecutor Nathan Wade was the motivation for this entire prosecution in the first place. The only reason we're here is because she was trying to get her boyfriend a job. So that's why we end up having this evidentiary hearing to basically determine, because in response to that, Nathan Wade said, yeah, we had a relationship, but that didn't start till after I was retained. Meaning I first became special prosecutor, and then I formed an intimate relation, a romantic relationship with Fani Willis. So the judge was very fixated in hearing only testimony that related specifically to that relationship. And when did it start? And what was the nature of the relationship? When did it change from being a person into being a romantic relationship? It's just a friend. That's different than if it's someone who's a boyfriend. So that's why we heard a great deal of testimony and questioning of both Nathan Wade and, well, it's all three witnesses, frankly. Well, I mean, technically there were four, but the first witness was Terrence Bradley, who's a former partner of Nathan Wade. And there were so many objections because of conflicts of interest and because of attorney privilege that we didn't really hear much from him. We'll probably hear more from him tomorrow. And he should be an interesting witness to hear from. But really, it started with Yeardy, who's a lifelong friend, or 30-year has a friendship with Fani that she disputes the level of their friendship, but goes back at least 30 years. And Yeardy claims that Fani Willis told her in 2019, or late 2019 or early 2020, that she was in a romantic relationship with Nathan Wade. According to the papers that were filed by Nathan Wade, they weren't in that romantic relationship when he was first retained to become special prosecutor, which was on November 1st, 2021, nearly 2 years after they met. So Yeardy said they got romantically involved a couple months after they met, and then you have this contract that's signed in late 2021, 2 years later, and Wade and Willis were both claiming No. Our relationship didn't start until April of 2022, months after he was already special prosecutor. Now, so that's how all this relates to Trump's case. That's how their whole romantic relationship relates to Trump's case and this whole RICO action, which doesn't seem like it would, but based on what the motion is, you can understand why we're hearing testimony about that element of things. Now, so that's the context for y'all, so you can better understand that. Once we better understand this context, so there was a line of questioning that I think might have happened even before I'm sure it happened before the break. It was a while back that I never really weighed in on, where you had, and we saw differences of questioning style and ability. Where Ashley Merchant, I'll tell you this much, and that's Michael Roman's counsel. She seemed very effective against Yeardy, relatively effective against Nathan Wade. She really seemed to crumble more against Fani Willis, who's a very tough person to examine because of a couple of things. First, because she has tremendous attitude, and the court gives her crazy latitude with her attitude, in that they basically, it's almost as if the judge was cucked by her, if not by her personally, then the status of her position as district attorney. But he seemed very hesitant to basically tell her to shut the hell up, which is what a judge would have done in most circumstances with any other witness who was acting like that. I mean, maybe they wouldn't if it was Trump on the stand. I don't know. But certainly there was a great deal of latitude that he was giving to Fani Willis. I'll allow you all to speculate as to why he was granting the latitude. I'm sure many of you will speculate it was because he's in the tank for the Democrats. That may or may not be true. I have no idea. I'm not going to speculate on that. It could be that he was awed by the office, but I don't think I'm going on much of a limb here to say that he gave her far greater latitude than I've almost ever seen a judge allow a witness to get away with, where she's questioning the papers. You never see a witness get away with that, saying all these lies you said about me. No judge would allow her to just start rambling on and screaming about that. You never see that ever. So that's the evidence that I think we all saw, which indicates that he was somewhat intimidated by Fani Willis, if not by her personally, then by her office, right? That he's allowing her to get away with all that crap, which no witness should ever be allowed to get away with. But I do think it's an interesting question when we're analyzing with respect to the second re-upping contract. This is a brand new contract. Now, the judge seems very, very fixated on, were you in a romantic relationship before you signed a contract? Well, even by their own admission, by the admission of Willis and Wade, their romantic relationship, look, if you ask Ms. Yeardy, Yeardy would say that it started all the way back in 2019, 2020. If you ask Wade and Willis, they say it started in the spring of 2022 when love was in the air. But he signs a new contract in 2023, and their relationship was still ongoing at least until June of 2023, or if not the end of the summer, depending on whether you ask a man or ask a woman, because apparently that's a big difference according to Fani Willis. But so when they're signing that second contract, they are under their a personal relationship, and you can ask, okay. One could make an argument saying that at that point, there's no indictment going on at that point. The indictment doesn't come until when the second contract is signed in around April of 2023. There's no indictment. There's no special grand jury. Nothing's happening at that point. Now, some would say he already started the case. They didn't want to pick up and keep the ball rolling with him. Okay, fine. But when she's signing disclosures, which she had to sign to the state, she basically said that she was asked, she has to give disclosures. She has to give disclosures as to whether or not she got gifts from anyone who's working under her. And she recognized and admitted, Fani Wilson recognized and admitted that he is working under her and that gifts from him she would have to disclose. And she's like, well, none of those dinners were like, maybe a dinner is $100, whatever. But it's cumulative. It's cumulative. So in that sense, there's more than one dinner over the course of the year that he's working underneath her, and she doesn't disclose the fact that he's buying her dinner over and over and over again, which I'm sure was well over $1,000. So there's that element to it. There's also the element of the fact that she admitted that before he was hired, he would come to her house multiple times. She seemed to be guessing around 10 times, pick her up her house and take her out for dinner before he signs that contract in November 2021. That is, and when asked and by Sado, who was Trump's attorney, did any other employees, any other your co-workers come to your house and pick you up for dinner? No, none of them. So we have this whole murky type of qualification as to what is a romantic relationship, what is the nature and status of relationship here. And I'm confident that Sado and probably some of the other attorneys, when they're giving their arguments to the court, they're going to make the point. Then, because this was a powerful point that Sado made, and I think that his direct examination of Fani Willis was far more effective than Ashley Merchant's, because he was pinning her down, and drawing distinctions between the way Fani Willis was looking at, treating, dealing with, interacting with Nathan Wade prior to contracting with him compared to anyone else who worked in her office. So you want to sit here and pretend that you didn't have a romantic relationship. I got to tell you something. Someone's come to your house 10 times and taking you out for dinner. You're in a relationship. You're in a relationship. I mean, that's pretty clear. That seems pretty evident. So she wants to say we didn't hold hands, whatever. You can believe Yurdi or disbelieve Yurdi, who said that she saw them hugging and kissing in 2020, 2021, all that stuff. You can believe her, you can disbelieve her. I mean, that Fani Willis would say that she is biased, they're in a fight. Okay, look, let's try and give some latitude here to the other side of the aisle, which is going to be claiming, hey, okay, look, there's, this is, she is biased. It's possible that Yurdi is biased. It's possible that Yurdi's lying because she hates Fani Willis today. And that's definitely possible. They seem to have a very not friendly relationship anymore after being friends for many years. They seem to have a significant falling out. So it's possible that she's making stuff up to make Fani look bad. But the point is that the admissions that Fani Willis made make it fairly evident that there was a relationship. However, I think what we should worry as far as where the judge seems to be showing this great deference to Fani Willis, that he's sort of caught in the crosshairs here of conflicting desires, because he does seem, as much as he gave a lot of latitude to her while she's there on the stand, there was a number of times that he could have leaned in and helped Fani Willis in the state in objections that they raised. He didn't have to have this evidentiary hearing. He could have given in on their motions and then risk being overruled. Which, what are the chances he's going to get overruled? He didn't. So all of you who are assuming he's in the tank for the Democrats, I'm not going to kid you. That was not my personal take. My personal take was not that he was in the tank, but that I think he seemed intimidated by Fani Willis when she was on the stand, or at least reluctant to embarrass her by striking her testimony or things of that nature, until it got so out of hand, so crazy, that he's like, look, please stop so I don't have to strike your testimony. He seemed to be scared to strike her testimony. I don't know what the hell is the huge embarrassment of striking her testimony, but he seemed to be very, very worried about offending her. That's not necessarily him kissing up to them because of Democrats. It could be kissing up because of power. It could be whatever it is. And I can understand how you're going to draw negative inferences about him. And I'm not one to tell you where you should draw your inferences. That's for you to ultimately decide. But I'm simply saying, I'm trying to give you both sides of the argument as far as assessing the work that Judge McAfee is doing here, as far as assessing the work of these different attorneys. I think Ashley Merchant seemed not. I mean, it's a tough position, and I'm not pissing on her as an attorney or her abilities. I think that she's done really, really very strong work. I just felt like her direct examination of Fani Willis was sort of not nailing her down enough. And you saw the difference when Sado was up there, that he was just like, how many times did this happen? How many times? Very short, boom, this limited fact, as opposed to allowing Fani or giving openings to Fani for her to just start blabbering. You all a liar, blah blah. It's just like ever since it was just much more contracted and concise. Where he was able to show the stark contrast between the way Fani Willis dealt with Nathan Wade compared to any of her other peers. Now, So that's what I really wanted to get out there for you. I just wanted to cover a few other things here. In his billing, he put in here 24 hours. I put this aside here, because I wanted to just give you a little horn blast here, and second, because this is Tankrat here is an attorney, and he said, and one of the things we saw in Nathan Wade's bills was that he billed 24 hours in one day, which is lunacy. It's crazy. And he's like, I've never billed 24 hours. Please read this line, billed hours 24. It's crazy. It is crazy. Nathan Wade's bills were kind of a joke. Even when he's describing the work he performed, it was such a poor description that he literally could have copied and pasted the same description, like review documents, talk to team. And it's like 9 hours. Talk to team, 9 hours. You have to put in there what you talked about, what the topics you were covering, the issues that you were addressing, the legal research. You cover what legal research you're doing, not just legal research, 7 hours. Drafting, 6 hours. It's like, it's a joke. It's a joke. I'm telling you right now, I would never be able to get a client to pay for that with that kind of crappy, shoddy billing. No attorney could, because your client would look at you and say, are you out of your freaking minds? You just wrote talk to your team 7 hours, and I have no one knows what you were talking about, and you could have just made up 9 hours. You could have made up 3 hours. You just chose at random 7. We don't even know what you're talking about. So that's what I'm saying is his bills seem comically bad. So when they're sitting there whining about how he worked hours for free the entire time, I was just thinking,
poor you.
it's like, please do it like a professional. Do it like a professional. Act like professional. You can't bill 24 hours in 1 day. No. Just no. I don't even care if you were working 24 hours. You still can't bill it. If you were working 24 hours straight, you cannot bill 24 hours. He claimed that it was a process of over a few days. It's just like your bills are so stupid and so empty. I'm sorry. He's claiming he's worth $600 an hour. Poppycock. I don't buy it. I don't buy anyone would paying $600 an hour if that's how he's issuing bills. I just don't buy it. It doesn't make any sense to me. 0 cents. 0 cents at all. You want to say that you think he's giving her latitude, so when he throws the book at her, it looks like he tries best to let her off. Maybe. We don't know. We don't know how he's going to rule. Could be. Thank you, but thank you for the $20 super chat. I appreciate that. Barracuda, I thought it really interesting that he specifically made a point of her not dating him as long as he was dating her. Yeah, she's got issues. That woman is narcissist. She's got crazy issues. I'm going to tell you something on this point. What's really interesting to me is I see a lot of call me crazy. I'm going to say something that I'll bet you're not going to hear anywhere else. What I'm about to say right now, laying into this, I kind of felt like personality-wise, it's going to sound ironic, Fani Willis is the female version of Donald Trump, personality-wise. It's like the female manifestation of just sort of somewhat self-involved, painting things, looking at things from your side of the angle. It's like all the foibles that I see in Trump that make me cringe, it was the exact same thing that I was seeing with Fani, where it's like, yeah, she has more of a feminist element to her. Obviously, he's not going to have that. But I'm just saying, as far as painting it, like, how are you looking at me? How are you, as far as, the persecution complex, there was just a lot of similarity that I felt like, And those of you who are sitting on one side of the aisle, whatever side of the aisle you're on, whether you're sitting on the left or the right, just ask yourself, like, really, just do a self-assessment. I know that you probably really like one and really hate the other, but I really see them as being mirror images of each other. Just one is man and one is a woman, so it's going to manifest differently based on their gender. But I think the personality issues that we've all seen, even if you're a Trump fan, and Lord knows I loved his work as president. I mean, he loved his work as president. But just as far as the personality issues, the feeling that, the sense of entitlement, every critique you would have of Fani Willis's personality, I can promise you those are critiques that the left would throw at Donald Trump. You can at least recognize that. Whether you agree that he deserves those critiques, at least recognize that any criticism other than like, even the whole racism thing where she's like, I would never put a black man down that way. A black man, yeah, a white man. The left would call him, and I think wrongly, they would call him a racist. How many times they call Trump a racist? It's really, to me, and it's really kind of amusing that I think all the critiques that we have of her personality, some of which I see are female manifestations of Trump's personality issues, and some, it's just, to me, it's funny, the mirror imagery that I noted while I was watching her on the stand. So I wanted to share that thought with y'all, and that, and you just gotta be honest with yourself as far as like, even if you don't agree that it's the same thing, at least recognize the other side would, whatever words you're saying about her or whatever words you're saying about him, that's what the other side would say about your champion, so to speak, and the battle champions of Fani versus Donald, if you're going to consider Fani a champion, which the left certainly does. Have you ever heard the whistleblower recording of the grant money? Do you think that's going to come in towards a credibility corruption? I did hear about that. I heard you. It's a good question you're asking, Anna. This does not. So this is another thing that the judge ruled out and said, I'm not interested in that. Anything having to do to show that he's unfit or she's unfit or other sort of recklessness with respect to how they run their office. He has this judge has said, I don't want to hear any evidentiary testimony about that element of the motion. So any corruption issues and stuff like that, this judge has said, I don't want any testimony on it. Does that mean he's saying I'm not going to rule in the movement's favor on it? Technically, it does not mean that, although it seems to imply that. Seems to strongly imply that he thinks that's an illegitimate basis to have Fani Willis removed, because he would say, look, even if she's corrupt, that doesn't mean that defendants get to shove her out of their case. By that logic, any defendant would have a basis to shove her out of that case. So if she's terribly corrupt. So yes, do I think she's corrupt and a liar? 100%. I'm very confident she's a corrupt liar who basically tries to portray herself as a victim all the time, and probably has deep racial issues with white people. Deep racial issues with white people. I think she's out of her mind, and definitely has a sense of entitlement, which is just aggravating. But so yeah, and the corruption, yeah, I think I would trust that whistleblower over her 11 times out of 10. But that this judge doesn't want to hear about it, so it's unlikely to come in here. Grifty says, give her a long leash so he doesn't look biased when he rules against her. Also, pin your links when I post tomorrow for the all new viewers. Grift more, grift harder. And it says, don't be too hard on him. It's his first time prosecuting a case. He normally used to chasing ambulances. She was a hot mess. She was crazy. She was crazy. How you doing, my brother Nate? I hope you had as much enjoyment covering this. I know Nate was covering this earlier today. So I hope you had as much enjoyment as I did. This was a lot of fun to watch. This was if you came in late, seriously, it's worth just sitting back and watching. Testimony of Nathan Wade, even testimony of Yurdi, which was everything today was just, this was a really enjoyable day of testimony. And I knew it would be. Tomorrow should be pretty good too. Fani Willis equals Blamber Heard. Oh, Blamber Heard, like blabbing on and on. I like it. And it says, if I were questioning her, I'd use experience as a DA against her. In your experience, what's the payment method choice for criminals, drug dealers, etc.? Why? Let her explain it herself. I like it. I like it a lot. Even if although it's more necessary in front of a jury, because you sort of want to plant that seed in the minds of the jury, it's less likely to be impressive to when the judge is sitting as the trier of fact. But still, I like your thinking. I like it. And it could annoy a judge when he's sitting as the trier of fact. As a sidebar, do you think if Elon purchases Disney, we might get a Disney movie that they don't kill a parent at the start? I don't know. We might get a movie where white people aren't idiots. So a couple other things I wanted to cover here. If you missed it, please go back and watch Fani Willis's entrance. It was around 5 hours, somewhere between 5 hours and 15 minutes and 5 hours and 5:15 and 5:45 in my video. You definitely want to watch her coming in there. There's a whole fight that's going on about whether or not the court should grant the state's motion to quash the subpoena of Fani Willis. And the state is sitting there saying, you know, there's not enough reason to have her here. There's plenty, you know, they got everything they needed out of Nathan Wade. And I thought they were going to lose on it. And Fani Willis comes charging on in there saying, give me the stand. She really looked like it was like a WWE thing. She comes out there in her flaming pink outfit. Put me on the stand. And she came out huffing and oh, how dare you, bunch of liars. You sitting here lying about a black woman, lying about a black man. You're sitting here, you racist, coming out here making up all your lying charges. You sound crazy. It was insane. It was really, we needed Vince McMahon. So Matt Murphy asked this question: aren't Fani's conversations contemporaneous or new with those RICO defendants? How does she plan to prosecute a case based on statements? I don't have an answer for this. I don't know. I don't know how you get their statements in. How do you get their statements in also? It's not going to be easy for her to do in a criminal prosecution, but this was a great catch by Cash that I wanted to point out, where he said, she starts talking about how they went out to dinner in 2020. He said, we didn't go out to eat in 2020. So because of his health, it was an interesting conflict where they did not seem to be on the same page. And trust me, look, this is my personal opinion. I'm not laying an accusation here. So I want to be clear. I'm not making a statement of fact. I'm making a statement of opinion that I think Fani Willis watched Nathan Wade's testimony. That's my own personal opinion. She claimed that she didn't. She's not legally allowed to watch it because as witnesses, she's not supposed to be watching the testimony or knowing what he's saying. But it seemed fairly clear to me. And the reason I came to that conclusion is she just seemed to realize that when she said something that was at all different, she's like, I'm sure he would say stuff. When she was being asked, first question out of the gate that she was asked was a question as to like, how did you know that we were going to call you now if you weren't watching the trial? And she's like, well, it just seemed common sense. Please. There could have been 1,000 ways. They could have gone to Bradley after Nathan Wade came out. She had no way of knowing that. She had no business walking into the courtroom. The only way she would know that is if she saw that they were arguing over it. Because Bradley, honestly, was the one they should have been called. That a lot of people thought that she'd be calling. What's she rushing into the courtroom for? So these claims that she wasn't watching to me, ring as being completely empty. Because Terrence Bradley, what Fani Willis said when she was arguing about Terrence Bradley, what she said was, you know, that she was there was a whole thing as to whether Terrence Bradley was going to help give an anchor as to why these other witnesses should be brought in there, because and to fight against the motions to quash, saying they're not introducing anything that's can help the case along, and all these issues about whether or not there's privilege that attaches to it, and how the privilege attaches, and where there's a privilege, and what the nature of the conversations that are privileged, or the observations that are or are not privileged. Which I went through that during the lunch break. I started talking a lot about the whole privilege. I don't want to repeat myself on that. You can go to basically, I would say about the 3-hour mark is when I was talking about of this video is when I was talking about privilege. So if you're interested in hearing that, which I did go through a very detailed analysis about privilege and attorney-client privilege as it relates to this particular case. But I will say that Fani Willis saying that she knew she was next, that's ridiculous. That's a joke. That's a joke. The only reason she knew to come in there and she was busted on it, in my opinion, is because she was watching the trial. She was, and she's not supposed to be. Janelle asked, is there any evidence to back up the questions the attorney is asking her? Can she be impeached? And why is she being allowed to talk like this? I'm so appalled no one else could get away with this. So, I mean, the evidence that has been submitted. I mean, I think she crafted that answer as far as where she has cash around. And my daddy always told me keep cash around, which sounds like a joke, whatever. But her ability to talk that way is because the judge basically allowed her to do it. And Ashley Merchant didn't stomp on her enough. Sado kept her more, and her questions were too open and providing openings for Fani Willis to sort of start going off on her soapbox. So, yeah, there's that. Tank Rat, I wanted to just give you the war horn. And thank you for this. And you're right. In most government and company ethic rules, relationship between supervisors and supervised is unethical. 100% agree with you. I wanted to thank you this. I thought this was a really nice thought. And I also wanted to thank those of you who actually who were able to come in and just give the gratitude. This was an interesting question. And this is the question which really made me analogize to Donald Trump. This is really, your question here, Debbie, is what made me see the parallels with Donald Trump, because as soon as you said this, as soon as you sent me this super chat, where it's like you're sitting there and you're saying like, shut the, like as her attorney, a lot of times we're watching witness and you're literally like, shut up, shut up, shut up. And you are, and with some witnesses you can do that. Her personality is not the type that I think you can rein her in. She thinks she knows best. She thinks she knows best. So you might be signaling her that, but you also know she ain't going to listen to you. And that's what made me see the parallel to Donald Trump, because when Donald Trump is on the stand, you can sit there signaling him and going, and he's just going to keep going. You keep going. And that's why when you ask this question, the first thought I had was like, yeah, you might be, unless you know she's going to ignore it. And look at her. Look at her. You think she's going to listen to you? She ain't going to listen. They didn't want her going in the stand, and she's like, I'm taking the stand. You think she's going to listen if they're giving her a signal to shut up? She thinks she knows best. She's Fani Willis. I'm Fani Willis. And you know what? The judge said, oh, you're Fani Willis. I mean, it's ridiculous. But we're living in a world like this, and I'm just going to say this. We're living in a world like this where people act like jackasses, entitled, empowered jackasses, because other people around them respond to it by saying, oh, yes, you're right. Oh, yes. The judge is sitting there practically saying to her, oh, yes, massa. Oh, yes, massa. That's what I felt like the judge was saying to Fani Willis. She's the boss, and he's going to be like, please don't say that, massa. Please don't do that, massa. Please let her. That's what I felt like. Like he was just like, sorry. It felt like she was able to treat that courtroom like it was her courtroom during the direct examination of Ashley Merchant. And the tide quickly changed when there was another attorney in there who was a little more seasoned than Ashley Merchant, who was basically, and that was Steve Sado. I think it's Steve is his first name, I'm not sure, but Sado was in there, and when he was asking questions, he just kept her focused. And he's like, no. This is my question. Answer my question. No, answer my question. Answer my question. And just keeping her focused, where anytime she tried getting up on, she's like, reach up to the soapbox and start trying to climb up. He was like, no climbing. No climbing on that soapbox. So you gotta appreciate good lawyering. And that's what that was. I also made a note to myself to explain Chinese wall. So when she was talking about the whole taint examination, and I thought this was a good line of questioning. It's like, okay, so you're hiring Nathan Wade as special prosecutor. You're hiring the other people who are in his firm to serve as examining taint issues going on in the district attorney's office. It's like, are there no other attorneys out there in the world that can be hired other than your boyfriend's or his firm? Like, there's no one else out there? No one else? Really? Like, there's no one else? And I jokingly said, well, she was only going to hire black people. And I really think that's true. I don't think she would hire anyone who's not black. And maybe her options were very limited. I'd be curious to see the names of the other people she considered who rejected the special prosecutor, or purportedly rejected the special prosecutor job that she was offering, and whether any of them were white. Because my gut says probably not. Probably not. So I wanted to explain Chinese wall. Chinese wall is a term that we use to when there's an investigation into something and it relates to someone in the office. So a Chinese wall is a reference to the Great Wall of China, that sometimes you'll have people in an office that seem to be working in a conflict with others in the office. They put up what's called a Chinese wall, which is basically designed to take steps to safeguard, to make sure that sensitive information that might affect someone in your office is kept from that person while it's still being examined and looked at by people who are working in the same room as you, or not the same room, but the same overall offices as you. So they put up what's called a Chinese wall. So that's why we heard reference to that. I also wanted to explain gifts for $100, which I think I covered that, which was basically, I didn't explain it in full. So she was required to report gifts of $100. And this relates a little bit to Cash's question here. He said, as a public official, she should be required to ask for an RFP, which is a request for proposal. So then, and sort of go through that vetting process. Had they asked if she did that or she just picked Wade, she would not. They would not be allowed to ask that question, because this is one of the areas that the judge says, I don't want to hear evidence. I don't want to hear any testimony about that. That's not part of this whole evidentiary hearing. So I thought you were asking a good question. I'm telling you, if they tried asking this, they would have been slammed down, because the judge specifically said, I only want to hear about whether the relationship tainted this whole hiring process, not about whether or not there was proper vetting or corruption or whatever. I don't want to hear about that. I only want to hear about whether or not their personal relationship had an impact on this prosecution getting started, but not about whether she ignored standard procedure here, whether she got approval from the Atlanta Commission Board. For whatever reason, that's where the judge decides to limit it. I think that on some of that, they have appealable grounds to say, look, if she's ignoring that process, isn't that sign of the fact that she's looking to give him a job? And they seem to sort of really cut the legs off on that. So, but the reason I thought the gifts for $100 was an important element, which was that was coming up here, was because the gifts for $100 comes in with respect to the fact that look, if you're looking at him as being a boyfriend, well then maybe he doesn't have to give, you don't have to report publicly that, hey, this guy who works with me gave me money. If you're not looking at being a boyfriend, then it's an employee relationship, or a principal agent relationship, some sort of relationship. And if that's the case, then you either have to report it because, it's just something that work people are hanging out together, or if it's a personal relationship, you don't have to report it. So the fact that you didn't report it seems to be an implication that you were regarding it as because you're in a romantic relationship with the person. That's where I thought that they were trying to go. The judge seemed to want to hear nothing about that, which surprised me a little bit. But I just wanted to share with you that interesting little thing that I think it was the attorney McDougal tried asking. The judge didn't seem to want to hear anything about that. So, finally, we have here, Allegan News says, should first question, it's not finally because I need to get to Rumble. Should first question with the sequestered witness if you were informed about any prior witness testimony anyway. They're just going to say no, though. You can ask that question. They're going to say no. I wanted to just give a little horn out here to Janice, who said, had to search my web browser to just do this, but thanks for covering this, and screw Rumble's UI. I agree with you on that. Bulldozer said he's a middle-aged white man. He doesn't want to get in trouble for telling a strong black woman to be professional directly. Pathetic excuse for a judge. And that's a valid critique. The judge really failed. He failed, in my opinion. When she was on the witness box, he failed. Whatever excuses you want to give, whether it's the office, whether it's because it's Fani Willis, something about her personality, whatever it is, he failed to control his own courtroom. And he let her take over the courtroom, which was a joke. It was embarrassing. It's embarrassment to him. And Faux Peasy says she mastered the dark arts of playing dumb, which I think that's a fair point. Okay. I think I covered. Oh, no, wait. Patrick Kennedy says, can you imagine being a judge and kowtowing to anyone? What a law cuck. Yeah. Joe is going to ignore the diggers, and that's why I keep coming back. Locals is awesome. Thank you. I'm not ignoring the diggers. I showed you the love. But I really appreciate your generous. In fact, I'm going to give you one of these because you gave me a $10 tip over in locals. That's my way of saying thank you, my brother. Thank you, Patrick. I appreciate my brother. All right, tonight I do plan on live streaming. That'll be at 10 p.m. I'm supposed to be going into spaces right now. You need to follow me on locals so that way you'll find wherever I pop in. Last night I didn't live stream on my own channel. I was over on a different channel. If you follow me on locals, which is goodlogic.locals.com, goodlogic.locals.com, then you know where you can find me and my commentary so that you can either express your praise or your animus for whatever it is that I'm expressing. That's goodlogic.locals.com. So I'm probably going to head over to Spaces in a little bit, assuming that Spaces is up and going. I haven't looked at X all day. So, in fact, I'm going to let you know whether or not it's going. Let me do a quick check on that. They said we're starting at 4 p.m. instead of 6 p.m. Hopefully it's okay with you. See you on stage. Yeah, I don't know if I'm going to be in Spaces or not. I don't know if I'm going to be in Spaces or not. So, yeah, I had So anyway, tomorrow I will be doing a live stream tonight, God willing, at 10 p.m. I might be talking about this. I'll probably be covering some other topics as well. Almost certainly. That's at 10 p.m. Tomorrow morning, 9 a.m. We start 9 a.m. tomorrow. I will be live streaming this tomorrow. Don't want to miss it. We're going to see the cross-examination of Fani, the redirect. And Bradley testimony should be fire as well. You're definitely not going to want to miss it. So that's going to be tomorrow. We start at 9 a.m. But before that, I guess I'll see you tonight at 10 p.m. And that's over. But for all my appearances, goodlogic.locals.com. I thank you all for joining me. I am going to be landing my plane over here. So until we meet again, thanks so much. Stay happy. Eat some bugs. And as always, Godspeed.